All right, ladies and gentlemen, good morning. This is a code enforcement hearing for the city of North Miami. Today is July 3rd, Wednesday, 2024. I am Jose Smith, Special Magistrate for the city of North Miami. The Special Magistrate is empowered under the Florida statutes and the North Miami Code to hold code violation hearings. The purpose of this hearing is to determine if a code violation exists on your property as seen and cited by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, so all persons speaking should do so one at a time to ensure that the testimony is clearly audible on the recording device. If English is not your primary language, then please inform me when I call your case. We have interpreters who will assist you during the proceedings. When your case is called, the property owner, agent for the property owner, and any witnesses that you may have should announce your presence. When asked, please speak directly into the microphone and say aloud your name, your business or mailing address, and your relationship to the property. If you are not the property owner or an attorney representing the property owner, then you must present a power of attorney or a notarized statement in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked if you are aware and understand the violation that is being heard today, and if you understand what is required to resolve the violation. The city will present its case first, and then the property owner will be given an opportunity to testify on their own behalf, bring forth any witnesses to testify, present evidence, photographs, other documents. You also have the right to cross-examine the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending upon the case type, I will set an abatement date or a compliance date for the violation to be resolved, or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement at this time, I will table or continue the case until a further date in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal the administrative order on the case to the circuit court. An appeal must be filed within 30 days of the date of the execution of my order. In accordance with Florida law, if a person decides to appeal any decision made by a special magistrate with respect to any matter considered at these proceedings, then the person will need to have a verbatim transcript or the record of these proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim transcript shall be the responsibility of the appellant, and it is recommended that persons who plan to appeal should provide their own court reporter at this proceeding. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment is $100 per case. Once the city records an order that imposes a fine and authorizes the levy of the filing of a lien against the property, then the city will charge additional administrative fees to record and release the liens. At this time, I believe the clerk will either swear in the witnesses or we will have a pledge of allegiance. I forget which goes first.
Which order? Yes, Magistrate. Thank you, everyone, again. I will be having the police officer to administer the oath to the officers and the inspectors. So if you all can enable your audio and video, please. Inspector Colson, Murillo.
For team building and everything, and we didn't have a chance to get to it because we were so busy. So I sent a notification that the meeting was being postponed, but I've already.
I have an audio coming in.
You know, in another.
I'm not sure where that's coming from.
But it's canceled. It's postponed, not canceled. Postponed. Okay.
There was another meeting I think sent to me.
Okay, I think they muted at this time. All right, thank you. Officer Carter.
Okay, please raise your right hand. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
All right, now we'll have the officer administer the oath to the translators, if we have our translators available. All right, we don't have our translators here with us. Let me go ahead.
We'll go ahead and swear them in later if necessary.
Okay. Okay, we have one. All right, if you don't mind enabling your audio and video.
Audio enable. Video able as well. You guys able to see me?
No, we hear you, but don't see you.
Is that the Spanish interpreter?
Yes, I believe so.
We got to be able to see you, otherwise
Yeah, I know.
We have a problem.
No.
No.
I'm moving my camera. I know what's going on.
All right, maybe you'll have to sign in again. In the meantime, we can go ahead.
We're done talking, so we'll lower your hand.
Okay.
All right, so
Can anyone hear us?
we can hear you. Can you please mute your mic until we give you a call?
Thank you.
Okay.
All right, so translator, go ahead and try to restart that. And in the meantime, I'll go ahead and read the instructions.
Okay.
All right, good morning, everyone. Thank you for participating in today's special magistrate hearing. I will review the process by which today's hearing will be conducted. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. I'm sorry, I'm getting some feedback. One moment. Sorry about that. When your case is called, if you are signed into Zoom, you will receive a notification giving you access to the audio and video so that you may give your testimony. If you are physically at the City Hall and wish to give your testimony, you must sign in at the code clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided with access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click on the raise hand button to be acknowledged. Before giving your testimony on your case, please state your name, property address, relationship to the property. If you wish to have an interpreter assist during your case, please indicate this when your case is called. Magistrate, that concludes the instructions.
All right. Any additions, deletions, changes?
Yes, we do have 3 amendments to the case. Item number 24 on the agenda is closed.
Okay, go slowly so I can make notes.
Sure.
And you don't have to redo this later. So 24, item 24, can you read the case number for the record?
Sure. Item number 24 is Jean Max Forville and W. Jocelyn, case number CEBPR 2023-00806.
Is that closed because of compliance?
Compliance.
Okay, very good. Next one.
Item number 25, Jean R.
No, GE.
I'm sorry?
CE.
No, I'm reading the item number. Number 25, Jean R. Cordado with W. Case number is CE GMP 2022-00118. This is also closed due to compliance.
Okay. And the third one?
The third one is item number 35, Nomi Condominium Association, Inc. Case number is CEBPR 2023-00781.
And that's closed because
due to compliance. And then allow me to give you your abatement dates. Let me know when you're ready.
Okay, go right ahead.
All right, your 30-day abatement is August 19. 60-day abatement, September 16. 90-day abatement is October 20.
Got it.
All right, so at this time, if everyone can enable their video, we're going to do the Pledge of Allegiance. Officer Carter.
Please place your right hand over your heart.
You can see us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, are we ready to call the first case?
Thank you, Officer Carter, for that. All right, so we're going to start the hearing with item number 15 on the case. And that is Daniel Mikhailov. Case number is CEMIS 2024-00193. Daniel, if you can accept the invitation that I just sent you. Daniel, are you?
Can you hear me?
We hear you, but we need to see you, Daniel.
Yeah, I don't know how to get this video going.
There should be a little
I see.
on the bottom, it should be on the bottom left-hand corner next to your microphone. It's an image of a recording camera.
So I see a mute button, I see a hand, a chat, captions, and more. I don't see an actual camera.
Check in your more to see if there's a video option.
More?
There may be There may be three little dots on top on the right-hand side of the image.
Yeah. I press
top.
that, and the only option it gives me is disconnect audio.
So you're gonna have to scroll your hand to the left, and then on the left-hand side, you'll see a mute and a start video.
To my left?
Yes, on that bottom left, you're gonna have to do that there.
Yeah, it's not, there's nothing there. It doesn't scroll left or right. It just stands still. And there's only
Are you on a phone or a desktop?
I'm on the phone. I can get on the desktop.
If you can, please, so we can.
1 second.
Okay, let's proceed to the next item and give Daniel a chance to reconnect.
Sure. The next item we're going to call on the case is item number 11 and 12. One moment, please. is Aruba Investments 155 LLC. Case number is CEFOB 2022-00143. This was previously found guilty by Magistrate Smith with an abatement date of November 16, 2024. The fine was set at $250 plus the $100 cost assessment. And item number 12, Aruba Investment 155 LLC, CEZCU 2022-00290, previously found guilty by Magistrate Smith with an abatement date of November 16. Fine set at $250 per day plus the $100 cost assessment. And Gennaro Murillo is the officer on this case.
All right, let's hear number 11 first. Gennaro.
Yes, Your Honor. Inspector Murillo, Neighborhood Services Department here in Miami.
A little louder, please.
Can you hear me?
Yes.
Yes, Your Honor. This case was opened on March 9th of 2022 to a property address 15500 Biscayne Boulevard. This was a reference for not having a business tax receipt for Cascade Restaurant at 15504. This case, from my final inspection, there's still no compliance as of June 18 of 2024. The notice to appear was posted at June 3rd of 2024, and on June 5th, this notice to appear was on mail.
Okay, when was your last inspection?
On June 18th.
Okay, I'm familiar with the case since I adjudicated it. So the abatement date was November 23rd.
November 16, 2023.
November 16th of 2023, and there's no compliance as of June, correct?
Correct.
Yes, Your Honor.
For a business tax receipt, is business still operating?
Yes, Your Honor.
Okay, based on the testimony of the city's code enforcement officer and the evidence presented showing that the property has been out of compliance since the abatement date of November 16th, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $250 plus $100 cost assessment. The fines shall continue to run on a daily basis until there is compliance. Next
question for you, Magistrate. Juan Sorrell is here to represent the case, and he wants to ask some questions.
Is anybody else going to be able to be heard, or just the city?
No, you can be heard, Juan.
Mr. Magistrate?
Go ahead, sir.
But that's my question. Are you just going to listen? Hear the city?
Well, we did not know that you were on the queue, so
I have an appearance.
Yes, you just logged in, so that's why I clicked on it.
Yeah, the hearings are set for 9:30, sir. They're not set for 9:50. So if you
I've been online since 9:30.
Okay, we didn't know that. Go ahead, and I'll be happy to listen to you. And if you make a case and convince me that I should reverse myself, I'm happy to do it. But explain to me, sir, why you have not complied with my order of November 16th requiring that you obtain a business tax receipt.
Well, first let me
go ahead.
Let me put on the record, my name is Juan Sorrell. I'm a partner at the law firm of Jones Walker LLP on behalf of Aruba Investments 155, who is the property owner.
Sir,
okay, Juan, we're getting some feedback from you. But Juan, if you can enable your audio and your video so we can see you as well, Juan.
I'm also the owner of the restaurant here, and for some reason I was not invited to testify, but I'm here.
We can't see who's speaking. We need to be able to see you and be able to speak to you.
I don't have this option of the camera, unfortunately.
I can't enable my camera either.
Well, I can't hear both of you at the same time. So
you have Mr. Magistrate, you have two parties here before you today. My name is Juan Sorales on behalf of Aruba Investments.
Juan
Sorales.
From the Give me a moment. Juan, I'm trying to give you an instruction. If you can please hold on a second. I'm trying to see if I can send you the invitation again to enable your video and your audio.
Same thing for me, Alexander Rubinsky.
Madam Clerk, can we also confirm whether or not the restaurant owner was already sworn in with the previous crowd?
Right. So once I get them their audios, I want to go ahead and try to do that for them.
I can join as a panelist?
Yes. You need to join as a panelist.
Can you hear me?
We can hear you guys. We just need you to enable your videos. We hear everyone. We just need your videos enabled.
I'm sorry. I'm trying to.
I'm here.
I'm sending the invitation for you guys to accept so you can get your audios. All right. So if all of you can please raise your right hand so I can swear you in. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right.
All right.
Again, for the record.
Sir, please be quiet. Let me speak first, and then I'll give you an opportunity to respond, okay? I had just entered an order, which I am happy to reconsider after I hear all the evidence from whatever parties are involved, okay? We're going to handle this like we're in court, okay, Mr. Sorales? You spoke first, so I'd like you to identify yourself again, tell me what firm you're with, and the party that you represent.
Yes, sir. My name is Juan Sorales. Jones Walker, on behalf of Aruba Investments 155 LLC, who is the property owner of the shopping center located at 15500 Biscayne Boulevard, North Miami. My client is the party that is cited with these violations because it is the property owner where the subject premises are located. The violations, however, are that of our tenants, Rusky LLC, doing business as Kaz Restaurant. And they are the party who has undertaken corrective actions to comply with these violations. They have a representative here hearing before, or here present today at the hearing as well, who can give more details. But it's my understanding that they have worked diligently and in good faith to comply, and that they have good news to report today, that they have obtained approval of all their permits in their plans. The permits were approved as recently as yesterday by the city of North Miami. And with that, I'll turn the floor over to our tenants representative who can give more details.
All right. What is the name of the tenant representative?
Alexander Rubinsky.
Okay. Do I see you? There you are. Okay. You are the tenant for the restaurant?
That is correct, sir.
Okay. You were cited November 16, 2023 for not having a BTR, right?
Yes.
And I heard council say something about a building permit.
That is correct.
What is the relationship between the building permit and the failure to secure a business tax receipt? What's the relevance of a building permit?
Okay, so the reason why we cannot, first of all, I would like to say that business tax receipt and the CU, both of them are paid in full every single year. So we don't have any outstanding balance. The reason that we don't have it in compliance is because we did some additional construction in the restaurant, which was not permitted and that's why our certificate of use and business tax were pulled out, and that's why we went into violations. So we have submitted the plans to legalize this construction, and the comments we have received back from the county first that we need to increase our capacity in terms of grease trap and to add an additional evacuation exit. So all those things were added to the plans. The review was completed by the county, if I'm not mistaken, around February or March, and was submitted to the city for their review. The plans were finally approved, and we have the GC, and we have the permit in hand, which was picked up yesterday. Up until now, we just paid in fees almost $30,000. $13,000 was for the fees of the county for water and sewer. $13,000 was to the city for water and sewer, and as well as yesterday I paid $2,300 for the permit of construction. I actually even invited our GC to be on this meeting. I don't see them currently because maybe they couldn't join as well. There she is, Paula Correa. She is the GC who we hired to help us, not to help us, to do the construction for us at the restaurant, which we're starting on July 15th. There is a lot of work that needs to be done. We have many trades are already aligned because we need to cut the floors, we need to remove concrete, to install grease trap, to do another opening in the concrete block wall for the evacuation exit. We have electrical work scheduled. So I try to upload all the evidence with the contract with the GC, the permit, and the schedule of construction. But unfortunately, the evidence couldn't catch because it was after June 17th. And I'll be honest, it's my fault. I didn't see that the evidence needs to be uploaded before that. So we do have a contract. We're starting construction on July 15th. It's already confirmed with all the parties, and the permit is on hand. So it's from this point, hopefully everything will go smooth if we're not going to face with any obstacles during the construction process. Hopefully not, because for us as a business, it's really important to be open as soon as possible, because we have 10 employees to whom we pay salaries, plus we have the rent. So for us, it's extremely important to finish with those violations as soon as possible. And currently, I have a schedule. If I can, I can share it with you on the screen here for construction.
No, I don't need to see the schedule on the screen. I need you to make a commitment as to how much time do you need to complete the work and to get both the CU and the business tax receipt.
Currently, as per schedule, if we're not going to face with any delays in inspections or any unforeseen events on construction site, currently the schedule shows that we will be 100% complied by August 30th.
Okay. The illegal construction that led to the problem was an increase in the size of the restaurant. Is that what I heard?
Yes.
And because of that, there was an issue with a grease trap. Who brought that up?
So we submitted to the city first, and then it went to the county. That we were trying to legalize this construction. We put it half wall, we put it a stage. It wasn't like a full structural, it just was a partial construction. But when we submitted the documents for approval, we got a pushback because they said for a restaurant, you need to comply in terms of grease trap. This is the new regulations. In terms of the capacity, you need to add an additional evacuation exit. So that's basically what happened. Because originally when we opened the business, we opened the business as a grocery store and a small deli. And then we switched the business to a restaurant. And when we did that, we did this additional construction, but it wasn't legalized. So when we submitted the documents for approval, we got a pushback that we need to add all those things, and that's what caused this process.
So the original certificates of use and the original business tax receipts were for a different business than a restaurant.
It was a grocery store, and we changed then the certificate of use to a restaurant, which was done. Everything was done as per regulations. The only thing is that this construction that we added, we didn't know that it needs to be legalized at that point, and that's why when the inspector came to do the revisited this the restaurant, they pulled it back and said that we are not in compliance, and that's why we're facing with what we face right now.
Okay, so you were dealing, or are you still dealing with Durham at the county, or
no? It's completed, fully approved. It's just in terms of construction right now, so that's why the permit.
So what are you going to do? What are you going to do between now and the end of August when you say you're going to be completed?
So on the 15th, we started in construction. On the 15th, we started in construction. The first couple of days are allocated for the demo and removing the concrete slab for the installation of the new grease trap. From that point, we will also opening the doors, doing the rough inspection for the plumbing and for the framing, and then we're gonna install the grease trap. Do the rough inspection of the footings to be able to pour back the concrete, going through final inspections of electrical, plumbing, and building, and requesting to revisit our premises for compliance to get our certificate of use and pay for the business tax.
All right, let me, at this point, let me hear from Inspector Murillo and ask him what the city's position or recommendation is regarding this violation.
Your Honor, I'm just going to add that, that they have been operating a licensee.
I can't hear you. We lost you.
We still can't hear you, Gennaro. We can't hear you.
Hear me now?
Yes, you're in and out. So.
You hear me?
Yes.
Yeah, so Your Honor, I just wanted to add that they have been, operating with a licensee since they were originally cited in this condition. And this case has been open for over 2 years already. We have gave them several extension, so I just wanted to add that. So whatever is you decide, Your Honor, I'm fine with that.
Okay. As far as the permitting and the plans that they've submitted and the work that they are saying that they are in the process of undertaking, do you have any reason to believe that that information that they provided is incorrect?
I was not aware of that until the other day. I think it was I don't know who was it. Was either Alexander or Juan Kami, and they told me about all this permit that they were working on. But so far, I mean, I didn't know nothing in detail until just now.
Okay. Mr. Sorales, first of all, let me just say that that I understand that you're the owner of the property. You're representing the owner of the property. The law is clear that the ultimate party that is responsible for any and all violations is the owner of the property.
I understand, sir.
And in some municipalities, the tenant may also share the liability, but you as an owner, and you are the one basically that's being cited. And I understand the concerns that many landlords have with respect to tenants who do work without necessarily letting the landlord know. And since you are the owner and you probably have a lease with your tenant, it would behoove you to be on top of your tenant to make sure that once these violations have been identified, that everything that is supposed to be done is done.
I can assure you, Your Honor, we do so almost every day.
Okay, and many times the owners exercise their right to terminate a lease when the tenant is in violation. And so I would definitely use that as leverage. I don't know how many tenants there are, but because of the work that is being done and the fact that it's your tenant, it's not you. What I'm going to do is I am going to table this case. I am not going to wait until the end of August. I am going to give you until the abatement date of August 19th. I'm going to table it. I'm going to rescind, suspend the order that I dictated a little while ago before I knew that you were on the call. And so what I'll do is and you need to really stay on top of your tenant, because again, you are ultimately responsible. I know that, for the most part, it's the tenant's responsibility, but you also share some of the responsibility here. So please work with your tenant, do whatever needs to be done as quickly as possible, and I'm going to table the matter until August 19th, at which point, if there's no certificate of use, if there's no business tax receipt, or if there's no if there are any building violations, I will definitely ratify the fines, and the fines will stick. So if your tenant cannot comply by then what you may consider is an eviction proceeding for the violations, and that'll protect you from any further responsibilities. But right now, I'm going to be lenient and give you a little bit more time to get these premises in compliance. It's a certificate of use and a business tax receipt on both cases. I'm going to table them until August 19th.
Is there a hearing on August 19th, Your Honor, or do I just follow up with the city?
I missed the first part of your question. Can you repeat?
We're abating till August 19th. Is there a hearing on that date, or do I follow up with the city?
No, there will be a hearing on August 19th.
No, Magistrate. No. August 19th is his abatement date. However, the hearing after that abatement date is the September 4th.
Okay, so here's how it works. I'm giving you until August 19th, but on September 4th, I will rehear the case. If there has been compliance by August 19th, then I don't need to hear the case. If there's no compliance by August 19th, then there will be a hearing on September 4th.
And just one more question. The fines that have been accruing since when is it, the
November 16th, 23.
What is happening with those fines?
Well, have they been abated? Those violations and those fines have not yet been ratified. That's the first thing that I did when we started this meeting.
That was my understanding.
I ratified those fines. Those fines right now are in abeyance, pending compliance. So if there's compliance by August 19th, then there will be no fines. If there's no compliance, then I will exercise my discretion on September 4th and make a determination as to whether those fines are ratified and modified or mitigated in some fashion. So we'll talk about that. If there is no compliance, hopefully there will be a compliance on August 19th.
Understood. Thank you.
Your Honor, before you make your final ruling, permission to speak?
I'm sorry?
Permission to speak from the city's side before you make your final ruling?
Absolutely. Madam City Attorney, go right ahead.
Just point of clarification. The abatement date has already been set in this case. The abatement date was November 16, 2023. The city has no objection to tabling this case to allow further compliance before the fines are ratified. However, the city does object to the changing of the abatement date. As you are aware, the city has the ability to go retroactive on the fines to the original abatement date. So the city wants to clarify that August 19th is not the abatement date. It would be the original abatement date of November 16th, 2023.
I agree with the city attorney completely. It was never my intent to change the abatement date. It is merely my decision is to table it until my next hearing of September 4th.
Thank you for
there is no change. There is no change in the abatement date. If there is no compliance by September 4th, when I rehear the case, then all the fines that have been running from day one will be ratified.
Thank you, Your Honor. Thank you for the clarification.
Yes, you're welcome.
Your Honor, may I just add something, if I may?
Yeah, quickly, because we need to move on.
Yes, very quickly. It's construction-wise, we're gonna be completed. I just want to say that I need a cooperation with the city in terms of inspections and getting this finalized, because construction-wise, I'm 100% committed to comply before the 19th.
Mr. Rubinsky, I heard from Inspector Murillo that he had not heard from you at all. So communication works, sir, let me finish. Communication works both ways. You want the city to go out there and do inspections? You got to call for inspections. Your contractor has to call for the inspections. It's very easy to blame the city when the contractor drops the ball. Okay.
No, I'd agree with you 100%.
And most of the time, it's not the city's fault; it's the contractor's fault. So make sure you're on top of the contractor to get whatever inspections are necessary. And if it hopefully it won't, but if it comes back before me, and by some strange coincidence, it turns out that the inspector dropped the ball, I will take that into consideration. But typically, it's the contractor that hasn't done the work that always it points the finger at the city for any delays. So you better be on top of the contractor.
Absolutely, and that's what will be done. The only thing I would like to say that Inspector Murillo was aware of the construction and the permitting process. Even in the evidence documents from the previous hearing, you can see that our permitting process was attached to that. So there was a communication.
You know, don't drag. How does that saying go? Don't drag the feet from victory. Okay, you won. Stop talking. Okay, so let's move on to the next case.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Magistrate. We're going to try again with Daniel Mikhailov. Daniel, I sent you the invitation to become a panelist. If you can please enable your audio and video.
Finish interpreter is ready, and I think you guys will be able to see me now.
Yes, we can see you.
Just to let you guys know. Okay.
So Daniel, if you can please enable your audio and video.
Can you see me?
We cannot see you, Daniel, but we can hear you. Are you on a desktop?
Can you see
All
now?
right. All right. Perfect. Thank you. All right. Just please hold for a second. Let me call this case into record. All right, Magistrate, this is item number 15. Daniel Mikhailov, case number CEMIS 2024-00193. The officer on this case is Officer Murillo, and we do also have one of our police officers who is on this case, Officer Gene Sosa.
Yeah, I saw the officer earlier, and I was going to ask on what matter.
He's here. He's on.
Yeah, on what matter he was on, because I don't like to have police officers hanging around when they should be protecting the public. So typically, I called on officer on matters involving law enforcement. officers first. So let's hear first.
Let me swear Mr. Daniel in.
Okay.
Mr. Daniel, if you can please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right, Officer Gennaro and Sosa.
Okay, Mr. McKay, first of all, are you the owner of the property?
Yes.
1855 Hibiscus Drive.
Yes.
I didn't hear it. Yes?
Yes.
Do you own a boat?
Yes.
Do you understand the nature of the charge, the violation that has been filed against you by the city of North Miami? Do you understand what you're being charged with?
Yes.
Okay. Do you agree with the violation, or do you contest the violation?
They haven't given me any information. It just says that I'm chartering illegally, and that's all I know. There was no real information. There was no, nobody ever reached out to me about anything. The only letter I got was this letter right here and this letter right here. My neighbor told me.
You, sir, you live in a residential area, right?
I do, yeah.
Okay. I've seen the file, and there's the boat. Do you not understand that you're not allowed to engage in boat charters from a residential area? Is that something you didn't know before? Or?
Well, first of all, I didn't engage in boat charters out of my house. I do have receipts from Duffy's that I paid $250 for pickups. I do have a partner, and we do have friends and family. We let them use our boat pretty often, which I didn't know that was illegal. All of those cars in the driveway, I can tell you every single person whose car that is by name. There was nothing illegal done. Nobody has ever approached any of my guests to ask them if it was a charter or not. You know, so I maybe charter my boat twice a month, if that. I don't use it as a money maker. It's my private yacht. You know, and like I said, they can go to Duffy's. They can get the receipts from every time I pulled up to Duffy's. The charter companies, who I use, maybe one or two charter companies, know exactly the address where to do pickups and drop-offs, which is, again, Duffy's. You know, I feel that this was just an attempt to try to see if I'm chartering or not, because I personally has never chartered in my house. And I don't want random people showing up to my house to charter my yacht. You know, I do have a BTR from City of Miami. I was in Miami Beach Marina for about 2 or 3 years. I never had a violation, no issues, no nothing. You know, for me, this was a surprise. And I've obviously asked my guests if anybody's ever approached them or asked them. They said, no, nobody's ever said anything. I've asked my captain, which I use only one captain. He says nobody's ever approached them or asked them anything. So to me, this was like a little weird that I even got this letter saying that I'm chartering out of my property with no evidence.
Who are those people on the boat?
Those are my friends. I invite people on my boat all the time. I'm going to invite people on my boat on 4th of July. I'm inviting people on my boat this Saturday coming up. You know, I let my partner use the boat.
Do they contribute towards the purchase of fuel?
No, they don't contribute nothing, and I don't need them to contribute.
You pay for all the fuel yourself?
Yeah, I pay for all the fuel myself all the time.
Where do you get the fuel?
I got the fuel from a truck that delivered it right before I went to a Bimini trip, maybe a month ago or so. I used to get my fuel at Miami Beach Marina when I was there for a few years, but ever since I don't dock there anymore, I dock in the back of my house now. I had the fuel delivered by a truck.
Yeah, sir, I'm very familiar with the Miami Beach Marina. The Miami Beach Marina is not in a residential zone. In order to operate there, you do need a business tax receipt, and it is not the same situation. It is not the same situation as doing business from your home. So I'm not going to. First, I'm going to let the city present, and then we'll make a decision. I know the officer is here, the inspector is here. Inspector, why don't you present your case? The defendant, the alleged violator, the property owner, says these are all his friends. You know, what information do you have that these are not friends or friends and family, as they say?
Your Honor, all this evidence I received has been from Gene Sosa, Officer Gene Sosa. He's the Marine Patrol officer. So in this case, I will let Officer Sosa give his testimony.
But before that, did you not put on the screen some advertising that you discovered online, or did I misread that?
Yes, that was also an advertisement from the boat.
It is advertised charter. Absolutely, yes.
Sir, it's not your turn to speak right now. Please let me hear from the officer. So officer, what is that you're putting on the screen?
So yes, this is an advertisement from the boat that's been traveling from the Keystone. This is also pictures that were taken from a neighbor in Keystone that he's been complaining about all this charting that's been happening from 1855 Hibiscus Drive.
Okay, what you have on the screen right now came out of what website?
Boat at Sea.
Okay.
That's the website where they have the advertisement for this boat.
Okay, and that's the boat in question?
Yes, Your Honor.
Okay, and show me the other photographs that you identified earlier of the boat behind the house.
Magori. One second, Your Honor.
Can you repeat that, please?
The picture of the boat on.
Yeah, the picture of the boat behind the yard, behind the back of the house. Okay.
Not that one. The other picture.
Okay, yes. and the home in question is to the right of where the boat is?
No, this is the canal on the Keystone area. Okay,
I'm going to ask the officer, but I'm interested in whether or not the people on that boat got on at the home or were picked up elsewhere. Do you know, sir, Mr. Murillo?
Say that again, Your Honor. I'm sorry.
Yeah, go back to the picture of the boat.
Yes.
All right. I see several people in the back deck of the boat.
Yeah. Mm-hmm.
I also see someone on top. Several people there. Were those people picked up at the?
So from what I was told, they were picked up from the property.
I'm sorry, you say that again?
From 1855 Hibiscus Drive. They were picked up from that property.
Okay. All right. At approximately what time of the day do you think? Do you know whether they were picked up?
No, Your Honor.
Okay. All right. So let's get additional information from Officer Sosa, who's a member of the Marine Patrol. Officer Sosa, please identify yourself again and your position with the City of North Miami.
Good morning, Your Honor. Mr. Sosa, and I'm on the Marine Patrol. I'm currently on the Marine Patrol. What's going on is this. I have a resident who's very concerned about charters out of our city. And from February 24th to Saturday, June 1st, he sent me 8 pictures. And the 8 pictures shows different people on the boat, right? And the picture that you were showing earlier, just the boat's coming back and the boat's going out. The one at nighttime, the boat's coming back, which he would have picked up from home because he's dropping them back home. On the picture that's daytime on that you have there, that you showed on the screen, the boat's going out, so that means going out of his house. So what's going on is this. In all these pictures, there's a bunch of different people on board. So what happens is, when you advertise for charters and you have people going in and out on the boat or going from your house out on the boat, automatically the residents complain or think that there's a charter going on. So that's what basically, I have not made contact with the boat personally, but I keep receiving pictures from a concerned citizen that every time the boat goes by, there's different people on board, and he's providing me pictures. So back in February, I don't think this was made. He might have just moved in. I'm not sure when he moved into the city, but I started receiving pictures from February 24th. And the last picture that I received for that particular boat was in June 1st. And there's 8 pictures that I received with different dates. So that's the biggest concern with the city, that he's picking up from his house and, going out on charters, which a charter's not illegal, but you just can't run from the city. And I heard him say he uses one captain. Normally, if you run a charter, the people running the charter should have a list to pick up from actual captains, not just one captain every time.
All right. Are there different requirements for captains of charters whether they do it for the owner of the boat or whether they're engaging in a charter type activity? Are there different licenses for that?
No, basically on his contract, what he needs to do is he needs to provide the charterers a list of captains, and they will pick from there, not just one captain. So I don't know how long he's been just running captain, but normally that's the way it works. That's the way it operates. The person that's running the charter has to pick the captain. The person doing the charters just doesn't provide the captain.
Okay. Have you been able to identify whether or not the owner of the boat or the yacht was one of the occupants of the yacht when they were engaging in what you're calling a charter?
I would have to zoom into the picture. I have not personally stopped the boat, but I'm going off what pictures that have been sent. If the owner's on board, he could easily be inside if that's the case, or he can be outside. But I would have to look through the pictures again and see if I didn't even know what the owner looked like. This is the first time I see him, so I would have to look to see if he's one of the occupants on the boat, or it's close enough to see.
Okay. Mr. McKay, have you been a passenger on your boat while these family and friends of yours were out boating?
So I have my phone in my hand right now. That picture that you showed me with all those cars in my driveway, I was personally on that boat that day, and I can show you videos and pictures that I was on that boat that day myself. Because you see, what they're doing here is there's obviously a neighbor that is obviously, jealous or whatever the situation is. They're sending pictures from February, which is exactly when I moved in till now. I never denied that I charter my yacht. That is true. But I do pick up and drop off in Duffy's for charters. And every single charter company who I work with knows that very specifically. It was never a secret. I never denied chartering my boat. That's a fact. It is advertised to charter, yes. I do have contracts that show that I charter my boat with these companies, okay? And there is a pickup and drop-off location, and it's Duffy's. It's always been Duffy's, and always will be Duffy's, okay? I do use my boat. I am on my boat very frequently. This weekend alone, I will be on it twice, okay? And I didn't know that it was illegal to let my friends use my boat, okay? If a neighbor wants to complain about me using my boat, there is nothing illegal done. Nobody has ever complained except this one neighbor, and they're only complaining because they think I'm chartering. We're not bothering anybody. We're not making a mess. We're not screaming and yelling. No one's doing anything out of the ordinary for this neighbor to say anything. And if the neighbor started immediately after I moved in, which was like February, 1st or 12th or whatever it was when I moved in, you know, clearly this neighbor doesn't like the fact that I have people coming to my house and enjoying my yacht, which I paid for and I own, you know. I just don't like what's going on. You know, nobody knows what's going on. The officer doesn't know what's going on. The inspector doesn't know what's going on. You know, nobody knows what's going on. All they know is that there is a charter online, which the picture that you showed me, by the way, I don't even work with that company. I don't know who that company is. They just put up a picture of my boat there. They have no contract with me or anything. I've never worked with them a day in my life. Okay? So they're showing me a picture of a company that I don't work with. Okay? And I've never agreed to charter my boat for a week for $36,000. That doesn't exist. So that company is obviously just making stuff up.
Okay.
You know,
Magistrate, Mr. Daniel, allow us one moment. Magistrate, I do have Karen De Leon who's testified against this case prior. And then I also have the deputy city attorney and another code officer who has also dealt on this case who would like to speak.
Okay. Let me first hear from the city attorney, who's had her hand raised for a little while, and let me hear any legal arguments or positions that the city has with respect to the charges in this case.
Thank you, Your Honor. The defendant has testified that his contracts for charters have a specific location outside of the city of North Miami at Duffy's restaurant, I believe is his testimony. The city asked whether any evidence was presented to back up the testimony. Is there any physical contracts that the property owner is able to provide to prove this statement that these charters are operating outside of the city?
Mr. McKay, any response to the question that the city attorney has asked? Any contracts or any understandings or agreements or documents that in any way would sustain your allegation that the charter originates at Duffy's in North Miami Beach?
So here is my last pick up and drop off the problem is I'm on my phone and
I can't see your phone.
So it's kind of hard for me. But this is my contract.
Just read to me what are you showing me?
Okay, I'm reading to you. It's an invoice for Mia Lifestyle. It's a pickup drop off, $250 at 6/21/2024. That's what I paid to do a pickup and drop off at Duffy's, and I have a receipt right here in my hand because you know, I just started documenting stuff ever since I got this letter, just for proof.
Permission to respond, Your Honor. The defendant's testimony is very clear that he has a contract with the charter company that advertised this boat for charter, that the location must be not inside the city, that it must be at Duffy's, which is a commercial establishment outside of the city. What the city is asking for is proof of that statement. That you
I have a contract that I can forward to you.
Too late, sir. You should have done it before, not in the middle of a case.
Well, they never said anything to me on this letter of what they wanted or anything like that. I just came on here.
Just on the second document. If you look at the second document,
says that you've been engaging in illegal charters a single-family residential neighborhood where it's not allowed. It also shows a number of cars parked in your driveway, and I've heard testimony from the police officer to the effect that there has been coming and going from your single-family residential neighborhood. I've also seen an advertisement, you know, whether you own it or disown it, or whether you place it or somebody else places it. The inference is that it relates to your activities at your home. So I think the evidence to me indicates that you have been engaging in charters, and I find your comments that these are all family and friends. I find that testimony to be incredible. I don't accept that testimony. That is a usual comment made by people that are being charged with illegal charters. These are all my friends.
Nobody has boarded my boat. Nobody has ever boarded my boat to find out if it's a charter or not. And the officer clearly said that.
Yeah, well, that's true, but I've seen pictures of automobiles parked in your driveway.
Because there's automobiles in my house, that is
if you keep interrupting you, I'm going to silence you. I am talking, and I am telling you what I've heard so far. You had an opportunity to bring in people, the very same people that went on your boat, to testify that they're all friends and family. They've never paid anything. They never boarded from your home, that they always were picked up at Duffy's. You had an opportunity to bring witnesses to back up your story, and I haven't heard anybody on your behalf testify that it wasn't a charter, that it was friends and family. So now, sir, I'm going to give you one last opportunity to convince me, based on the evidence, that everything that was being done here was being done out of Duffy's and not out of your home.
How would you like me to prove that?
Do you have a witness?
I have plenty of witnesses.
They're not here.
I would like to maybe find a different day where I could be more prepared with witnesses and receipts and everything else that's
Sir, you were told this would be a hearing on the violation. If you had witnesses to back you up, you should have brought them. So, Madam City Attorney, Mr. Inspector, what is the recommendation the city is making? Is this a one-time fine based on the code, or is this? Do you want me to set an abatement date? What is the relief that the city is seeking?
I'll defer to Inspector Murillo.
Inspector Murillo, is this a one-time fine situation? What is the fine set forth in the city code?
Oh, you hear me, Your Honor?
Yes, we hear.
Yes.
Yes, Your Honor. One-time fine, Your Honor.
What is the amount that is said? And not that I'm bound by it, but what is the amount that the city code provides? Is it 500?
No, if I'm not mistaken, you have ruled in the past $5,000.
I don't recall ever. I don't recall a $5,000 violation.
Your Honor, if I may.
There was one violator who will appear later in this case, where it's been done multiple times over many months.
Right, I believe, Your Honor, if I'm not mistaken, Jose was trying to make a comment, but I believe it's within the 1,100 or 1,500 it was. But Jose, if you can correct me if I'm wrong, please.
Yeah. Okay, I know that the Prashnik case, which we're going to hear later, I think that I issued a violation there. If you look at the file, it's in today's agenda. What was the violation that I issued on that one?
Which case, Your Honor? What's the
number 23? I set a fine of $1,000.
Okay. Yeah, I see it.
Okay, look at item 23.
Right.
Okay.
I see your fine of $1,000. Yes.
All right, that's the same fine that I'm going to levy in this case.
Okay.
Can I ask you for the date of the picture?
All right, this case is over.
I'd like a date so I can provide evidence for that specific date on an
All right,
appeal.
this case is over, sir. I've imposed a fine of $1,000.
I'm going to be
I could have gone higher because I find your testimony incredible, and you have no witnesses, and I accept the testimony of the city's witnesses. So we're done.
Yeah, I know we're done. You guys just bamboozled me. Thank you.
That's whatever you file your appeal, sir. Get a lawyer and file an appeal.
gonna do that. Thank you very much for
Magistrate, really
use their
quick.
yachts.
We did have Karen. You don't need Karen to speak anymore, correct?
As long as she's on, I've already issued a fine, but I would like her to testify just for the record. In the event that the property owner does file an appeal, I'd like the witness to come forward and give her opinion, her testimony, what she's seen, what she's heard, not what somebody told her, but basically her own observations of what she has seen at this property.
All right, Karen, if you can please raise your right hand at this time. Do you solemnly swear and affirm the testimony you're about to give in today's proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do. We can't hear you, Karen. There we go.
No,
say I do.
Can you hear me now?
We hear you.
Okay. Thank you. Honestly, I have seen some action at this house. I live close by, and I wish he had stayed on to understand that, you know, he moved into this neighborhood recently. So he didn't realize that he moved into an area that has a boat charter issue. And I wish I had gotten to tell him that it's not that he's being bamboozled. He just walked into a situation in which he didn't know that he wasn't allowed to do it. So I will keep my eye out since I live close by, and hopefully this will be one and done.
Thank you, Karen.
All right.
Next case.
I've already imposed a fine based on the testimony that I had heard from the code officers, and I've given the resident an opportunity to say further and make further comments, but my testimony my opinion had already been made up based on what I heard before. So what I would encourage the resident is to report it to Marine Patrol if it happens again, and I would like if it's possible for Officer Sosa to stop the vessel, take names, addresses, phone numbers, and next time I'm going to be a lot more severe in my punishment. And if it continues, and if this person becomes a habitual offender, a repeat violator, the fines can go up to $15,000 per event. And I don't think that he's going to be able to run his charter and face $15,000 fines at the same time. So anyway, that's my ruling.
Okay. Your Honor, we're going to move along to item number 23. Jacob Parshnik Trust.
Yeah, Jacob Parshnik. This is a matter I remember it well. It's been before us at least 3 times.
Right.
And I'm familiar generally with the facts, and I'm surprised that the case is coming back to us. But let me ask if somebody from the Jacob Parshnik Trust is present.
We do have someone present.
Okay.
All right, so let me finish reading it into records. Jacob Parshnik Trust, Parshnik Irrevocable Trust, case number CEZPU 2023-00194. This was previously found guilty by Magistrate Smith with a compliance date of 24 hours, which was March 7 of 2024. The fine was set at $1,000 plus the $100 cost assessment. And Magistrate Smith also set a one-time fine for the property owner and tenant each. And if no compliance was met by both shall be charged $1,000 per day until compliance is met. We have Monique Benson. We also had a Robin Glass. Robin, I don't see Robin here. So Monique, and would you both please raise your right hand? Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you. The officer on this
All
case
right.
is Gennaro Murillo.
All right. I think this case has come before me at least 3 times. In none of the cases did Jacob Parshnik Trust appear. First of all, who is the trustee of the Jacob Prashnik Trust?
I am, Your Honor, Monique Benson.
Monique Benson. Is there a person by the name of Jacob Prashnik?
Your Honor, that was my ex-husband who died last year. He's my ex-husband.
Okay, so you are now the trustee under that trust, and you were the last time this case came before us, correct?
Yes, Your Honor.
Okay, is there a residence located at 1998 Northeast 135th Street?
There are 3 small cottages there which are all rented out.
Okay, they were rented out to tenants?
Yes, Your Honor, yes.
Yearly rentals, monthly, what?
Yes, yearly. Would you like me to make some points or just answer?
No, I just need you to answer.
Sure.
I'm not going to let you make a speech.
Okay.
Yearly rentals for each of the 3 properties?
It was the entire property was rented to a gentleman called Roman Travato, the entire property, and then he sublet all of those properties.
Okay.
Until April.
Okay. Have you been living in the area over the last couple of years?
No, Your Honor. I actually lived in Gainesville, and upon the death of my ex-husband, January the 9th, his body, we found his body in one of those houses. He was living there. I was in Gainesville, and I came back, and I inherited this property. And at the time, Roman Travato was there, the boat renter. And I had to basically clear up a whole estate, business, property that Jacob Prashnik owned. He's the father of my daughter, so she was the inheritor of all of this, but she's a juvenile. So I Roman Travato was renting the dock from me, and then he asked if he could rent everything, the entire property. And for me at that point, because I was dealing with all of this, I said, yes, you can rent the dock, the houses, everything, and you sublet it. So that was the lease agreement that I had in place with him almost immediately after my ex-husband died.
Okay. Do you understand that you are not allowed to operate any water sports, charters, paddle board activities from a single-family residential property?
In defense to that, Your Honor, when we bought this property, when I was married to my husband over 20-something years ago, from day one, we understood that property to be zoned commercial and residential. It's a very unusual folio. So that's how we had always known it to be. We had always rented the houses and the docks out to boats. And when all of this came to my attention, and even now it's listed on the property appraiser's online platform, it's listed there as commercial and residential. And even on the MLS, the Miami Association of Realtors, it's listed as commercial and residential. I mean, all of this is new to me. When this came to my attention, and your counsel will attest to that, the day after I got my first notice, I never got notice 1, notice 2. Roman Travato never gave me any of these notices. He never told me that we had been served. He never told me that he had gone to court. He never told me that you yourself had imposed a citation on the property, that nothing further could happen there. The only time I found out about that was when I came to the city on another event. And the minute they informed me of that same day, I reached out to Roman Travato and I reached out to the other boat tenant, and I told them they had to vacate my property, and they were gone in 2 days. The minute I found out, and they can attest to that. I came in there and I spoke with them both. I had a conversation. I mean, this whole thing is very upsetting to me because I had no idea what this gentleman was doing on my behalf, representing myself in your court. I mean, when I looked at the video, it showed that he told you that I was traveling. That's why he was there. That's a lie. I was in Miami sorting out Jacob Prashnik's estate. The only time I got the notification was when he had a lease in place for a year. When that lease expired, I rented the property myself individually to the houses. And it was at that point the tenant then called me and said, hey, there's a notice on your door. And at that moment, I came to the city immediately. And it was only then that I was told, and I saw the video, I was told of the citations, I was told about the fine that was in place. And I told them I would pay straight away. And they said, wait until you see the judge and you can tell the judge all of this. The whole process, I only found out about all of this, Your Honor, on June the 3rd. That was the first time I heard about anything that happened on this property. It's all troubling.
All right.
I mean, just so you know, they've gone.
Ma'am, I don't question anything that you told me. You said you were living in Gainesville.
Yes, Your Honor.
A city that I'm very familiar with because I spent many years at the University of Florida. Right. I know it's changed quite a bit. The gentleman that appeared before me, as I recall, had a business across the street, and for him to be able to rent out his paddle boards and wave runners and whatever else he was doing, he testified that he entered into a lease with you. I don't recall whether or not he made any comments about you being out of town or not. I always wondered in all that, because this case has come up several times. I think the first couple of times there was some issue as to whether you got proper notice or not. And one time, I believe the city removed it from the calendar. I'm not sure why, but I have seen the activities there. I was wondering where in the world it was the owner living that despite repeated requests from the city, and I know that the next door neighbor is a condo association, and the condo manager or president kept writing letters after letters after letters, not just to you, but the code people, even elected officials got letters. Wow. So at this point, I'm going to ask the inspector to bring me up to speed, because after the fine was issued back in March, I thought that the matter was resolved, but apparently it kept on going. And unfortunately, Ms. Benson, not unfortunately, but it's well understood in all municipalities that the owner, even when the owner has no knowledge of what the tenant is doing, the owner is ultimately responsible, because the owner has a responsibility to make sure that the tenant is in compliance. You just can't turn over your property to a tenant and close your eyes and think that the tenant is going to do everything correctly. So I would ask the inspector to bring me up to speed on what has happened since March 7th of 2024 that the city believes should require an additional penalty.
Your Honor, before Mr. Ramon wants to say something.
Okay. Mr. Director.
Laz, unmute your mic.
Thank you very much for the opportunity, Mr. Magistrate. In this case, unbeknownst to us, it was on another case, just as she stated. She came in. We didn't know. We had other discussions for permitting and stuff of that nature. Usually, as a courtesy, if you come into the department, we'll sometimes go and say, hey, look, go look at your property. I didn't put two and two together, but what I can attest to is the urgency that occurred right after the situation. So there was really just reaction from the owner at that point. And the pictures speak for themselves. The activities that were going there speak for themselves. And, you know, they were definitely going on. But I do know that once the John Travato was out of the picture and I've gotten in contact with the property owner, she did take the steps that were needed to be taken in order to address the problem of the commercial activity at the property. So that's our Lazaro Ramon, Neighborhood Services Director.
Has the $1,000 fine that I levied back in March, has that been paid?
I don't have that, but I'll let the Mrs. Benson if they.
Yes.
Good morning. When I came in, I did say when I had found out about the fine, I did ask Director Ramon if I should pay it, and he said just wait for your court case and you can pay it then once I've spoken to you, and I will pay that because I understand a fine being in place, but if I'm may I ask, Your Honor, I get very nervous and I'm emotional about this because
I understand, ma'am.
Sorry.
I've believed every word that you have stated, and I know that you are a good person. That you went through a very difficult situation with your husband, and now that I'm hearing you, I understand that the tenant and the other operator are the bad guys here, not you. So I'd like to hear from the gentleman to your right, and we may be able to resolve it favorably to you.
My name is Robin Glass. I am Monique's husband, and I can attest to everything that she said. Your Honor, we only found out about this whole process last month in June. That is because every time a notice was posted, the tenant would hide it from us because he didn't want to be evicted. He didn't want to get out. That's my belief. The first time it was in September and he didn't stop the activities, didn't notify us. Then he was notified of a hearing in March. He didn't tell us either before or after the hearing, after he had been cited and had to pay a fine. He didn't tell us anything about this. He still kept on trying to turn the whole property into commercial, but we didn't even know that the property wasn't classed as both. So we were in the dark all this time. It was a shock for us when we heard in June that all this had been going on, and we watched the video of the court hearing 3 or 4 times. I have everything down by the minute, and I can tell you exactly when he said that we were traveling. That's why we weren't there. It was 42 minutes into the hearing. So I do understand that we should have been aware of what was going on, but every time we went there, everything was fine.
Except the time when he had that kayak, and I saw
when we went there in November, and he had asked us, "Oh, can I put a couple of kayaks on his boat?" And we said, "Well, maybe, etc." When we went there next time in November, he had a rack of kayaks there. Monique immediately told him to get rid of them.
I have the email showing that as well.
We didn't even have time, Your Honor. I did a very detailed chronogram of everything that happened. But because when we found out, not so long ago, and the deadline to apply documents and witnesses was on the 17th, we just didn't have time. We didn't have the able time to present all our case. So this is where we stand, and we ask for your clemency.
May I ask one thing more? May I add something?
Yes, ma'am.
The other thing, just so you should be aware, and I'm looking at my notes here, the other thing was in your trial, somebody there spoke of that the first time it came to your attention that he had the kayaks there, he spoke to the inspector and said that he would go to the city and he was going to change the zoning there. He thought it was commercial residential, which is what I believe. Right. That he said that he was going to go to the city and change the whole property to commercial. And at that time, a few days later, I received a phone call from a gentleman called Frank Wolin, who I'd never met, never heard of, calling me and saying that if I would be interested in converting my whole property to an entire commercial zone. He said that way his client that he was representing, a company called South Florida Adventures, could continue to run their business from my property. I'm like, who is South Florida Adventures? I'd never heard of them. And then when I put two and two together, I realized that they must be the people who had all those kayaks on my dock. So Roman was subletting another business from my dock, getting me into all this trouble, which I had no idea about. I just didn't even know that there was another person involved in that time. And that's when I said to him before that conversation, get your kayaks off my dock immediately. And this gentleman said to me that he could help me with the city, because he was an ex-mayor. He could help me rezone. I said, I've got no interest in rezoning my property. So, I mean, this man Roman Travato was just doing all these things illegally behind my back and put me in this position. I mean, even when his lease was up after that year termination, and this is when he had been cited, you had told him when I saw the video, no commercial business could be run from that property. He then signed a new lease with me for a month. He never told me, hey, Miss Benson, the city has told me that you can't run any commercial property, any business from it. Otherwise, you're going to be fined a daily fine. He never told me that. I would never have renewed a new lease with him. I mean, he just lied.
Yeah. If there is any evidence of perjury, perhaps the city wants to follow that up with the state attorney's office. It's difficult to prove, but that's one option. Another option, ma'am, is, of course, you have every right to file a lawsuit in county court for any damages, including fines, that you may have been subjected to because of the misuse, illegal use of your property. It's painful to me to have to again reaffirm the fine that was previously entered against you, based on the information that was available to me at that time, and based on the fact that you were the owner, based on the fact that notwithstanding what the MLS says or the folio says or what the county says, the fact of the matter is that this is a residential area where these types of activities are not allowed. In fact, the citation that is here before me today, number 23, right, deals with, well, I thought that it had something to do with the fact that there was no business tax receipt or certificate of use, but nonetheless, this property cannot be used for that purpose. So for today's hearing, I am not going to levy a fine based on the testimony that you have given me, and I'm not going to impose any other sanctions, even though I left that issue open if it continued. Now that that you're aware of the problem and the fact that you cannot use this property for these types of activities, and that you will not engage in any further rentals with anyone for these activities, I am not going to impose any fines today. But the fine that was imposed for the prior activity that was back in March 7th, that fine will stand, because I wish I could say to you, you know, I'm going to take it away because it's unfair. It is unfair, and the remedy that you have, which is really not a real remedy, because you're not going to go out and hire a lawyer and sue the tenant, but you could, to the extent that you're being cited $1,000 for the illegal actions of your tenant, you could have an attorney write a letter to the tenant seeking reimbursement for the fine that you will be paying for that last activity. I also take consideration, very serious consideration, at what the director testified to, that you have always acted in good faith and that you are basically an innocent bystander on a matter that you thought that it was okay because of what you had been told. And
right.
So all in all, I'm going to find today's case. I'm going to dismiss. The pre-existing fine stands, and as I mentioned in my ruling last time, the $1,000 fine is also one that the tenant is responsible for. The tenant owned property across the street. As I recall, they had a business across the street. And to the extent that a lien needs to be placed on his property, or if it can be placed on his property, I'm not sure that the code allows that. But I would like the city to go after the real offender, which is the prior tenant. So with that said, Madam City Attorney, any comments?
None.
Okay. In that case, ma'am, I appreciate your coming in. Your husband was very helpful. Everybody in the city is sympathetic to your situation, and I wish you well. And I'm sorry about the death of your husband. I have heard that name before, because I know someone with that name who's a jeweler in Bay Harbor.
That's our family. That's his family. That's his cousin, the Prashnik.
Yeah, I know that there is a jeweler in Kane Concourse by the name of Prashnik.
Yeah, so Prashnik. Well, thank you. I want, if I can just say thank you to you. I mean, it had me so worried and scared and troubled and all of those things. And I also want to take the opportunity, as you mentioned, just to thank your city, all of them. Behind the scenes, they were, when I did go into a tailspin of panic and worry, and all of them, from the director to the representatives to the inspector, everybody was so kind and so empathetic and assured me that everything, the city is there to keep in place rules and bylaws so everybody is safe and the city runs seamlessly. So I respect that. And I just wanted to kind of pay homage to them because they treated me so kindly, and professionally. And
we have a very professional staff. The code people are the best that I've ever worked with, and I've worked with many cities, and they're unbelievable, and
they really
sympathetic. And are you going back to Gainesville?
No. This whole move brought. As much as I know how much you like Gainesville, we went there for fear of water rising and climate change, but it's not a city for us. It's too quiet. We came back only because of what happened to Jacob, my ex-husband, and I haven't seen my home since this happened. I packed a suitcase. I had to come down and arrange this. I haven't been back there for a year and a half. We're just renting the house out, and we're putting our roots back here in Miami. It's more of a vibrant city, more our pace.
Well, happy to have you back.
Thank you,
thank you, ma'am. All the best to you. Thank you.
Thank you, Your Honor. Thank you so much.
We appreciate it.
Okay.
Thank you, Magistrate.
Do we go?
Yes, ma'am.
Yes, ma'am.
How do I pay the fine, though? How do I pay that fine?
We'll go into the city and talk to them there.
Yes.
Go to code director. Where do they go and pay the
Magistrate, they'll just come into the city to pay that fine, but they can reach out to their officer as well, Gennaro, and he can give them further guidance for that.
Thank you.
All right. Feel free to call the inspector or the director, and they'll tell you. There is no urgency. I'll give you 30 days to pay it. So.
I'll pay it tomorrow. I'll come in. I'll pay it tomorrow.
All right. Thank you.
Close the book. Thank you, sir.
Thank you.
Thank you, everybody.
Director, just one comment on that. Yes, ma'am. We're done with your case.
Okay.
I know someone recently got a traffic ticket as a result of an accident. So they attended a Zoom meeting just like this one, and the traffic magistrate issued like $150 fine or something like that. No pros, nothing, no points, no nothing, and gave the driver a year to pay $150, which I thought was a little ridiculous, but that's what they're doing in traffic court.
Wow.
A year to pay. Okay. That's the county for you. Okay. Anyway,
Thank you for the feedback, sir.
Any further comment, or we're ready to move on to the next case?
I think we're ready to move on to the next case.
Let's do it.
All right, perfect. All right, so the next case we're going to call is item number 26 on the agenda. That's Jean Ravost, Odette Ravost. Case number is CEB PR 2022-00643. This was previously found guilty by Magistrate Kazoo with an abatement date of July 20 of 2023. Fine set at $450 plus the $100 cost assessment. Let me invite Mr. Ravost in. Mr. Ravost, could you please accept the invitation and enable audio and video? Jean Ravost. Please enable your video so we can see you. Mr. Ravost, can you hear us? You're on mute. If you can unmute yourself as well. All right, I'm gonna move forward until Mr. Ravost can gain access. So I'm gonna call item number 14 at this time. One moment. Item number 14 is Cliffs on the Highway, Inc. Case number is CEGEF 2023-00046. The attendee on this case is Yvette Blanco. Yvette, I will allow you in, Yvette. If you can please enable your audio and video. You just received the invitation, Ms. Yvette. Please enable audio and video. All right, Ms. Yvette, we see your desk. We need to see you.
Hold on. Yeah, I forgot I was remoting into the office.
Folks, you need
Hello,
to be
Miss
prepared.
Yvette. If you're not prepared, we'll have to move along.
Yeah, I just want to tell everyone that's
I thought I was. I thought that I was, but I think you can see me now.
Okay, now we see two videos.
Two Yvettes, one on the desk.
Okay.
You need to get rid of that one. And those who are waiting in line, please be ready when your case is called, so that we don't have to waste time
Miss
getting ready.
Yvette,
So,
if you can please raise your right hand for me. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
All right, we have Officer Murillo on this case.
Yeah, ma'am, if you could remove the other video from...
I did, Magistrate.
Okay. All right. Ma'am, your name, address, and relationship to the property.
My name is Yvette Blanco. My address is 12900 Southwest 80th Street, Miami, Florida, 33183. I am the permit runner for the leasee of this property for the renters. And I apologize because when I read the notice, I didn't realize I normally handle this for the renters, like when they have items like this. And they made the owners aware that I would be present, and I didn't realize that you would need an affidavit from the owners. I don't know if you can still hear it based on what I can update you on the violation.
First of all, being a permit runner is typically not sufficient to give you standing to represent either the tenant or the owner. I am lenient when it comes to property managers because I put them under oath and I ask them if they have the authority of the property owner or the tenant to speak. I'm reluctant to admit you as a representative of either, unless you have an affidavit from one or the other authorizing you to act on their behalf. Do you have an affidavit?
I do not, because since I've done this for the renters in different code issues throughout this different cities and counties, we've never needed that, and I apologize. I should have read the information closer, and I guess so should they. They should have as well. I apologize for that. The only update that I can give you is a permit has been applied for. We should have the plans from the architect next week based on what we submitted, the building department asked for corrections to be made, and they wanted an architectural plan. So we did hire an architect, and we've been assured that we'll have the plans next week. I don't know if you want to continue this so that I could get an affidavit, or they should be cured, I would imagine, with no with no issues coming. I would imagine 60 days.
First of all, I've appeared before the city of Miami. I've done this in several other cities. My preliminary instructions, and every magistrate that I know whose preliminary instructions are read into the record, they all say very clearly that if you are not the property owner or an attorney for the property owner, that you have to have an affidavit giving you authority. So I don't know which magistrate it treats you a little differently. I do know a plans runner in Miami Beach that does a lot of the work that you're doing, but she always has authority from the property owner. Nonetheless, I understand that you understand the nature of the violation. I would I would rule the same whether the owner was here or not here, whether the tenant's here or not here. I've reviewed the file. I'm going to let the inspector state for the record what the violation is, and then I'm going to make a ruling.
Okay.
Yes, Your Honor. On January 4th of 2023, I opened a case to the property address 12990 West Dixie Highway. They were cited for not having a dumpster enclosure. They were advised to install a dumpster enclosure and require and obtain permits from the building department. I had an inspection on January 17 of 2023 where there was no compliance. A notice to appear was posted on June 3rd of 2024. It was also made on June 5th, and as of my final inspection of June 18 of 2024, there has been no compliance.
Okay, can you show me the picture of the dumpster again?
Sure, Magistrate.
Okay, so the code requires that that dumpster be enclosed by some kind of structure. Does that have to be a concrete structure? It could be any structure.
No, it could be a metal, wooden enclosure.
How much time do you think they'll need to do that?
If you're asking me, Your Honor, I mean, I don't know how far they are with the permit. I know that they applied for a permit, but I've seen those that they have been denied by building, and then some sort of notes that they put. This notes were added on April 26th, and so far there has been no updates from the building department.
We do have Miss Pressy on the Inspector Pressy.
Go ahead, Inspector.
Shawnee Pressy, if you can enable your video. All right.
Can you give me the process number, please?
It's going to be BFE 00 2024 00073.
You say 73?
Yes.
Okay, so they just submitted this application. Well, they submitted the application in April, and as of today,
nothing's been submitted.
Yeah, it was denied, and they haven't submitted any updates. So it's back on the owners, the property owners, to make the corrections and resubmit. It was denied by zoning and building.
Correct. They requested for architectural plans. We hired the architect on the 20th, paid him on June 10th, and he's told us that we should have the plans next week, which we'll upload. I presume, should everything be included in those plans, the permit should be issued. Thereafter, just manufacture the fence, the enclosure around the dumpster. I would think, given inspections and everything, I don't think this should go beyond 60 days.
All right, here's what I'm going to do. I am going to enter an adjudication and set a compliance date of September 16th.
Okay.
So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance or abatement date of September 16th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. I was a little lenient on the abatement date. I was going to say August 19th, but considering that it's summer, many people go away during August, and this may require some inspections and plan reviews and what have you. I will, as I said, I would extend the abatement date until September 16th.
Thank you, sir.
Okay. Folks, if you're not on a case, please mute yourself.
All right, Magistrate, we'll go back to item number 26 on the agenda.
Thank you. Have a good day.
Thank you, ma'am. Item number 26 is Jenny Revost. She was on and then.
Okay.
Your Honor,
I'm sorry.
Your Honor, Ms. Revost needs a Creole interpreter. She was unable to understand the commands to turn on audio and video. That's why she was unable to join earlier. So I'm not sure if we have an interpreter available.
Let me see.
I thought I saw one earlier.
We had our Spanish interpreter. Do you? I don't have I didn't see the Creole interpreter log in for today.
So how do you want to handle it, Madam City Attorney?
I do not. I'll have Ms. Rivos. We're not even able to have her confirm whether or not she needs an interpreter, but I do not feel comfortable going forward with the case without an interpreter present. So if we're unable to confirm availability for an interpreter today, we will be forced to continue the item and table it.
I concur.
Okay.
I agree with the recommendation for legal as well, Special Magistrate.
All right.
I
yeah.
can ask her if you want me to.
No.
Fine.
If she's telling us she needs an interpreter, we cannot move on because she needs to understand what I'm saying, what everybody's saying. So, can we get an interpreter between now and the end of the hearing? Maybe she can hang on for another hour or so.
I can definitely try, so I can let her know that in Creole so she doesn't, log off completely.
Okay, because it'd be a shame to have to redo this and keep the violation alive. It is not a life safety issue, but it's a significant issue. I'd like to get it resolved. So let's put it off. Let's put it off for maybe an hour until we're done. I'd like to get this done by 1 o'clock if possible.
Okay. All right, I'll let her know. Madame Rivas?
Oui.
S'il vous plaît, sou ka tan nou un ti moment parce que nous pa gen un moun pou explique information en créole pour so n'a pas essayé joindre moun nan pour yo ka translate pour, OK?
Oui, merci.
OK, pas gen problème. So ma retire sur screen now. L'aimerait encore wa retourner, OK?
Oui.
Poko sorti net, OK? Just tan nou relo encore la fin wa venir encore.
Oui.
OK, merci.
Merci.
Okay. Next case.
All right, next case is item number 27, June 18 Properties, LLC, CEBPR 2023-00857. This was previously found guilty by Magistrate Kazoo with an abatement date of June 20 of 2024. The fine was set at $350 plus the $100 cost assessment. We also have item number 28 and 29 for the same property. Item number 28, June 18 Properties LLC, CEMIS 2023-00171. And item number 29, June 18 Properties LLC, CEPPK 2023-00034, previously found guilty by Magistrate Kazoo with an abatement date of June 20 of 2024. Fine is set at $250 plus the $100 cost assessment. The officer on this case is Gennaro Murillo.
All right, let anybody present on behalf of the owner on numbers 27, 28, and 29.
No, the owners are not present for these cases.
Okay. Officer Murillo, I reviewed the file. There's a restaurant. Apparently, they put up a very nice
exterior.
Wait a second. I'm getting a message that I've lost you guys. Can you hear me?
Yes.
All right. Let me go back because I've disengaged the meeting. I'm going to have to leave and come right back. Okay. Am I back on?
We hear you, but we don't see you.
Okay, then I need to start the video.
Yes.
There we go. Okay, as I was saying, it's a restaurant. They put up a sign. They don't have a permit for the sign. Is that it?
Yes, Your Honor.
Can you show me some pictures?
Absolutely. One moment.
There are multiple businesses on this property, correct?
Yes, Your Honor.
And at the moment, we're dealing with Los Pirales Miami Restaurant, right?
Yes, Your Honor.
Restaurant and bar, 13488 Biscayne Boulevard.
Yes.
Okay, so that's not the sign. Show me the sign. Is that the sign we're talking about?
Yes, Your Honor, yes.
The green one?
Yes, that's the one.
And you need a permit to put up that sign?
Yes, Your Honor.
And to the best of your knowledge, they do not have the permit?
They don't have a permit.
Okay. So therefore, based on the unrebutted testimony of the city's code enforcement officer and the photograph and evidence presented showing that the property has been out of compliance since the abatement date of June 20th, 2024, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $350 plus a cost assessment. These fines shall continue to run on a daily basis until there is compliance. Next case is 28. It's the same restaurant. I believe that
Magistrate Smith, 27, you've already set the fine, so you want to ratify it, you're saying?
Yeah, I ratified the fines accrued to date, and I also said that the fines will continue to run on a daily basis until there's compliance.
Perfect, thank you. All right, item number 28.
Same property. From what I read here, they have some outdoor dining.
Yeah, same property, same business.
And they have outdoor dining right there. Is that what you're talking about?
Yes, Your Honor.
And you need a license to have outdoor dining?
They need a permit from zoning.
Okay, and that's according to Code Section 29-5-109. They don't have it. Have they applied for it or not?
No, Your Honor.
Okay. So, and is this the owner that is being charged, or is it a tenant?
The property owner.
Property owner. Based on the unrebutted testimony of the city's code enforcement officer, the photographs and evidence presented showing that the property has been out of compliance. Oh, wait a minute. There is no adjudication on this one. Why is that?
No, there isn't. Because we had tabled this case before.
Oh, I see. I thought that it was part of the same order from Magistrate Kazoo. Okay.
The next one is.
So this one I'll adjudicate. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of August 19th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 29.
By the way, let me go back to the last case. The outdoor dining that we're talking about, is that on city property or is that on their property?
That's on their property.
That's on their property. Okay. And okay. And the code requires that outdoor dining have a separate license.
Yes, from zoning.
Okay. All right. So from zoning. Okay. So my ruling stands.
All right. Item number 29.
Proceed.
Number 29, Janelle.
Item 29, Your Honor. They were required to obtain permit for the building department to resurface and restripe the entire parking lot. an order to comply was posted on April 11 of 2024, and I had a final inspection on June 18, and there has been no compliance.
Okay, can you show me a picture of the surface lot reflecting the violation? Okay, and what you're requiring is that they restripe so that the cars know where they're supposed to be parking.
Yes, Your Honor.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of August 19th.
No, Magistrate, this one you've already ruled on before.
Oh, no, I didn't, but
Kazoo, yes.
Kazoo did. Okay, all right, yeah. This is a ratification. Okay.
Yes.
Based on the unrebutted testimony of the city's code enforcement officer, the photographs and the evidence presented showing that the property has been out of compliance since June 20th, 2024. I find in favor of the city, ratify the fines accrued to date in the amount of $250 plus a $100 cost assessment. And the fines shall continue to run on a daily basis until there is compliance.
Okay. All right, the next case we're going to call is item number 45, which is Talia Yvette Estevez. Case number is CEODS 2023-00274. The officer on this case is Gennaro Murillo.
Yes, Your Honor. So on November 11 of 2023, this case was open. This was after complaints that I received on the property address 550 Northeast 140th Street. They had outdoor items, including doors and like windows.
Yeah, show me the pictures. It looks like a junkyard. Have you made contact with the property owner?
No, Your Honor.
Is there somebody actually living there?
Yes, there's somebody living at the property.
Okay, that's totally unacceptable. That's not what this city should be all about. You opened this violation back in November of last year?
Yes, Your Honor.
Okay. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city and set an enter an adjudication and set a compliance date of August 19th, 2024. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
All right, we're gonna go into item number 2. It's 12940 Aurelia LP. Case number is CEDIC 2024-00002. The officer on the case is Gennaro Murillo.
And there's no appearance on the...
No appearance on this case.
Folks, I've said it enough times to basically bore you to death, but when you don't appear at a noticed hearing, my fines will be higher and it'll cost you more. So it's in your best interest to attend these hearings. They mean something, especially if there's an order that has been entered and not complied with. So by the way, on this one, I know that there's nobody present, but I did not see any this is a serious case, but I did not see any photos.
We do have a video available.
Yeah, this is dumping a pool into a canal. It's one of the more serious violations that I see, and I'm very strict about that. But I saw no photos in the file except a window. So you need to prove to me that there was illegal dumping.
Gennaro, do you have the video available? That if I share my screen with you?
Give me 1 second.
I'm here. Go ahead. Show me the video.
Give me 1 second, Your Honor.
Oh. 1 second.
One second, Your Honor.
Well, while he's doing that, Madam City Attorney, it's the violation is 12-8. Can you just read for the record, if you can, real quick, what 12-8 says about dumping into a canal?
Yes, Your Honor.
Yeah.
So Section 12-8 is under the nuisances section of the City Code. It states that it shall be unlawful for the owner or occupant of any lot or any other person to dump, dispose, or otherwise place into the canal, bay, or other waterway in the city any trash, debris, garbage, or any other type of waste material.
Okay.
Well,
yeah, I just wanted to be clear, because I guess a lot of people don't get it, and in some cities it is a criminal offense. A police officer can actually go into your home and arrest you. And I verify that with police officers in at least 2 cities. So this is serious stuff. So please show me the video.
All right. Give me 1 second. Magistrate. One moment. What's this? Gennaro, you sent me the email once before. Can you resend it?
You want me to send you the video?
Yes, please.
1 second.
Who took the video?
This came from a neighbor.
We heard a very similar case last month or 2 months ago. Is this the same property or a different property?
No, this is a different property.
While we await the video, Madam Clerk, is there any possibility that we could call cases 33 and 34 next? These are attorneys that are representing the clients that are have a conflict. They may not be able to stay much longer.
You said item number?
33 and 34.
Yeah, let's do that. While we're looking for the video, because that's on that case we can hear later. 33 is one where
NM Real Estate Holding.
Yeah.
I believe the attorney representing this is Attorney Mickey Marrero.
Okay. Yeah.
All right. I'll go ahead and read that item into the record. Item number 33 and item number 34 is NM Real Estate Holding LLC, case number CEEXC 2022-00029, previously found guilty by Magistrate Smith with an abatement date of May 22, 2024. Fine set at $300 plus the $100 cost assessment. Item number 24, NM Real Estate Holding LLC, CEFAW 2022-00084, previously found guilty by Magistrate Kazoo with an abatement date of November 16, 2023. Fine set at $500 plus the $100 cost assessment. The officer on this case is Shanna Sanders.
Is Mr. Marrero in the queue. Don't see his name.
Marrero, let me see.
The attorney present.
I'm checking for him because he wasn't on my registry.
All right, because I thought that was the reason we were going to
No,
move
I
on
didn't
from
see
the
him
last one.
register today, so.
Do you see a Ben Fernandez? Because that is his law partner.
What is the name? I'm sorry?
Ben Fernandez.
It's the firm of Burkow.
Correct.
Yeah, okay.
Fernandez.
I mean, I think they're on because I'm getting email.
Let's see. I don't see Fernandez. And what is the other name?
So Mickey Marrero has sent me an email. He says he has his hand
Okay,
raised.
Michael Marrero. Okay, I do see Michael, so we'll go ahead and allow him in here.
And Ben Fernandez also has his hand raised.
Okay, they have two Michael Marreros. They'll just need to change the name. And then you said there was a Fernandez.
Good morning, still.
All right.
How are you?
I see Mickey Marrero in his best suit and tie. I don't know who you represent. Is that NM Real Estate Holdings?
Yes, we represent the property owner on this case and the operator of the business. And I think my phone was on before, but I removed that. I see my name twice. I'm not sure why, but I was in two different devices. Actually, Your Honor, I'm in Miami Beach. I was at a special magistrate hearing this morning, and I've been here because I don't want to get in the car and miss my items. So,
how did they treat you there?
They treated me fine. It was a pretty simple case. It's a fence permit. This is actually the much more complicated fence permit. But
who was it? Annette?
It was Annette. Yeah, Annette Camp.
Okay. All right. If you see her again, give her my regards.
Will do. She may be back in a little while.
Okay. So I've already adjudicated this case. It has to do with some exterior rear wall that has severe cracks. I have seen the pictures. I don't know what you're going to ask me to do. It's clearly a violation. What is your client's position?
So, Your Honor, yeah, you are correct. There's already been adjudicated. We've been working tirelessly. I mean, well, my client, his expediter, and have been working tirelessly to get this permit issued. As you can see, both violations require the issuance of permits to do the repairs. And we submitted, well into last year and have received comments multiple times. I was going to tell you that we submitted in June, I think it was June 18th, and we're waiting for comments. We just got an email during this hearing, Ben and I, that the city responded with some zoning comments this morning. And we've reviewed those while this hearing is ongoing. And we believe I was hoping to tell you that because there was a pre-submittal meeting a few weeks ago, the expectation from building was that the permit was imminently going to be issued. So we're anxiously trying to get this permit so we can proceed and complete the work. The comments from zoning that came this morning are a little surprising. We believe we now need to meet with them because the comments exceed the scope of the violation. We really feel we can get this sooner, but we continue to get comments back and forth. We're anxious. I mean, my client, we've been in touch with them a couple times this week. They're really anxious to proceed, but we just keep getting additional comments every time for this permit. I don't know, Ben, if you have anything else you want to add.
Who am I hearing from?
My partner, Ben Fernandez, has been working with me on this as well. He's got a close relationship with the owners.
Well, Mickey, the problem that I have is that it's been since August of 22. My last ruling on it was back in February 7th, and it is a significant significant defect or violation in the concrete. I don't know to what extent is it life safety. When did you actually apply for the building permit?
So they submitted remember, and just to remind you, Your Honor, there was other issues with this property. There was a whole loading issue that was resolved. And then there was this maintenance of the surface parking lot itself. Those things have been addressed, thankfully. So all we're left is with this issue, with permitting on the walls. They submitted November of 2023, have had meetings with the city. I'm looking at a timeline here on June 16th, another meeting in May. There were multiple submittals in between that. February 26th, March 19th, April 16th, discussions with the city. We submitted, based on the May meeting, they submitted revisions that they hoped would be approved on June 18th. And we just got comments this morning that we now need new comments that were not prior comments. So now,
right. And you're not happy with those comments. So you have to obviously work around them or resolve them. What are the comments?
They're zoning comments. So we hadn't gotten those before. We were dealing mostly with the building department, and I think we've gotten past those issues. I think, again, I was reading them, Your Honor, while I'm in this Zoom hearing, so I skimmed through them. I have to take a little more time to digest. There's like 5 or 6 zoning comments that we haven't seen. So I was hoping to tell you the permit would be imminent, and once the permit's issued, we think we need 60 days max to complete the work. But we still don't have a permit, and we're trying. Ben, anything you want to add? I know you've been speaking to the owners.
Sure. I don't know if you can hear me, Your Honor, Mickey?
Yes, I can hear you.
Oh, thank you. Thank you, Your Honor. Ben Fernandez, Mickey's partner. And as Mickey indicated, we just received these comments and have not had a chance to speak with your zoning administrator about them, with Mr. Cook. We'd like to. The nature of them is really they're sort of increasing the scope of the required improvements to request fences, improvements to walls that were not anticipated. And I think that perhaps the confusion or the disconnect is that these are non-conforming structures since the building is so old, and there are new code requirements that are applicable to new construction. And so I think that
building or zoning.
I think that they're zoning mostly, the ones that I saw. There may be building as well, but there's definitely zoning comments about increasing a wall height, about adding a fence, I don't think we have a problem with beautification requirements, because I think our client is willing to improve certainly the look as much as possible. That's the ultimate goal of the business. And as Mickey said, we've already addressed some of the problems that started, which involved the use of the business. Those have been resolved. Now we're just trying to get this place looking as good as possible.
What kind of a business is it?
It is a
thrift store.
Thrift, yeah.
Incredibly popular thrift store that everyone, we've been there. It's very busy.
I'm sorry, what is it again?
Red, White, and Blue Thrift Store is the name of the business.
Okay. Is it one business or multiple businesses?
It's one business.
Okay. I have not heard from the city, from staff. Inspector Sanders, is that your case?
Yes, it is, Magistrate. That is my case. Pretty much everything that they're stating is correct. They submitted applications. It was denied. They did submit something on the 18th of June. As stated, it was denied again on the 20. I'm looking here specifically. It was denied on the 25th of June. Specifically, you were asking, what were the comments? They're stating that they need to submit the layout for the new concrete wall, as they're stating that because it's abutting a residential property, that the 6 feet that they were asking for is not allowed. They're asking them to go 8 feet. They're stating that they need to provide certain screening for outdoor storage that's going to be there. They're specifically saying they need to depict the type of materials, wood and chain link fences, and commercial districts are not allowed. But it's, again, as they say, there's 6 different comments. It's been, as you have already stated, a long time since we've been working with them to rectify the situation and to obtain the permits. As of today, as they're stating, and I, agree, the permits have not been obtained and movement needs to be made. I mean, I've been speaking with Michael, here and there regarding this matter, but at the end of the day, it is a very, very, very busy business right on the corner of 125th and 6th Avenue. Very, very busy, I must stress. So, we need to go ahead and obtain those permits, almost immediately.
We really want to. Believe me, there's a lot of frustration on our side. I'm committed to, and again, I don't know, Ms. Sanders, that you say the 25th. We literally got them at around 11 a.m. today. Maybe the expediter was delayed in sending them to us, but we got them just now. But we were happy, Ben and I, to sit with Derek Cook to go through these. We think they're fixable, and we can, we're anxiously want to get these permits. You can see from the record, there have been a lot of meetings with the city. There have been resubmittals. It's not lack of effort on our team's part.
Mickey, Mr. Marrero and Mr. Fernandez, my inclination is to give you a little bit more time, but I am very disappointed that despite my order, here we are 2 months later, and we still don't have a permit. And yes, I know the law changes, and I don't know what architect or contractor you're using, but somebody that knows the code should know better that it should have been 8 feet instead of 6 feet. And the applications are being denied over and over again. I don't care who you're using, but I can't really ignore that it's been since 2022 when this violation was issued, and I've seen the pictures. They look horrible. What business would want to operate with cracking walls like that? It's just not good business practice. So, I mean, I trust that you are competent enough to let the owner know that I'm getting tired of hearing this case. I really need them to do the work and do it quickly. So if I were to give you that little extra, leeway, and if I were to grant a slight extension, what can you tell me in terms of when are we going to get this fixed?
So I've been told that once they get the permit, which we were hoping to have, I mean, frankly, when I was here with you last time, Your Honor, I fully expected to have this permit by now. But that once they get the permit, 30 to 60 days, the work will be done, closed, inspected, everything. We just don't have the permit. So Ben and I are committed next week, because obviously tomorrow's a holiday and the city's closed on Friday. I will make myself available to the zoning senior staff. Ben and I will commit to you that we will get more involved. I mean, again, this is an architect permit. We're not directly involved. I will get myself involved if necessary.
I trust you. I believe you're being honest and sincere, and now that you're involved. And I'm not sure that you were involved the last time, were you?
I typically don't get involved with permit expedite. I get involved with this type of stuff with zoning hearings. This is a fence permit, but clearly there's some disconnect, so we're going to get involved because these comments came as a surprise.
So what I will do is I will table this until September 4th. And trust me, and I think you've known me enough years to know that I mean what I say and I say what I mean. If it's not substantially completed, if that wall is not substantially completed by my next hearing, September 4th, not only will I ratify the fines, I will increase going forward what the fines are. So I think I'm being pretty generous. I'm not going to make you. I'm not going to order the ratification and then make you go through mitigation. You're familiar with how that works. The mitigation in this city is different than it is where you practice. There, it's easy. You go in front of the special magistrate, and the magistrate mitigates based on certain criteria. Here, it's a little bit more complicated, so I'm not going to make you go through that, but I urge you to please get this done by September 4th. Otherwise, I'm not going to be nice, okay? And it's not about you. It's not about you. It's about the owner, okay? So let's table this until September 4th.
Thank you, Your Honor. Appreciate it. Have a happy 4th of July. We'll
Thank you.
Get progress by then. Thank you.
Okay. All right. We'll do the same with the following case number 34. All right. That'll also be put off table until September 4th.
Perfect. September 4th.
Right.
Table. All right, so the next case, Magistrate, I'm going to call is item number 17. It's Fabiola Tamarique Trust, case number FYBRR 2022000020. I have Mr. Reginald Lawyer in person. One moment, please. Laz, if you can have Mr.
Great. Just for the record, Magistrate, we had some computer issues and we have some residents that came here in person. So they're actually in my office and they're using my desk. I know that on the screen it'll say Director Ramon, but for the record, I want to make sure to say this was the resident, sir.
Excellent. I understand. So, Reginald, what is the last name?
Lawyer. Mr. Reginald, if you can please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
The officer on this case is Shani Pressy.
Okay, now this case is called Fabiola Slamarki. Is that the name of the owner?
That's my partner.
That's your partner?
Yes.
The property is at 1270 Northeast 128th Street?
Yes.
Okay, you're being charged with not having submitted the 40 or 10-year building recertification report, which is due. Have you made any efforts to submit the report?
Yes. Now, the warning went up to the wrong address. I didn't know about it until they give me the code. They posted in the apartment.
What address did it go to?
In New York, somewhere in New York, 30. I don't know. I got it right now somewhere.
Okay, you say the notice went to New York?
Yes.
Okay, not to the property address. Is that correct?
No. The court one they posted in the apartment. That's when I get it. That's when I get it.
Okay.
So
because I've never had a case where they do not do the right posting.
Now when I came down here, I talked to the case manager, and they sent me downtown to change it to the county. I did change everything, and I had a company was doing the inspection, and I'm at the right part, but the problem is the time.
The only question I asked you was, have you submitted the 40 or 10-year recertification, which is due now? Have you submitted it? No. Okay. That's the only answer I want to hear. That's the only answer I want to hear. You know you're supposed to do that, right?
I know because I did it before, but I didn't, I didn't get the warning. That's why I didn't know when the time was due.
Okay. How old is the building?
I think that in the 50s.
Okay. All right. Let me hear from the inspector. Inspector Pressy.
Yes.
Can't hear you. You're muted.
This is Inspector Pressy taking over this case for Vanessa Willards, the FYBRR 2022 0020. This recertification notice was previously sent out back in 2022 in August, if I'm not mistaken. And as of today, has not been compliance. The address on file, some bids and property appraiser was the correct address that the mailing that went to. So, and then I had him to go down to property appraiser to update his address information.
Okay, so service was proper because it went to the right address, correct?
Correct.
All right, and you went one step further and you posted the notice to appear on his property? Correct. Okay, and so how late is the certification?
I think this one is 2 years. This was due in 2022. We in 2024, so it's almost 2 years now.
Okay. Is it the 40-year or the 10-year?
The 10.
Okay. All right. Well, in view of the fact that it hasn't been properly timely filed, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that there's a violation of County Code Section 8-11F and City Code Section 5-37. The violations exist, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of, I'm going to give him a little extra time because he may need to hire an engineer or an architect. So I'm going to give him an abatement date of September 16th. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Madam Pressy, are there have you inspected the property?
I went by there. I haven't went directly all through the property, but it looked like it's safe so far. That I don't really see any like cracks in the walls like that from the outside from what I've seen. I haven't had no complaints about the property yet. But yeah, that's about it.
All right. All I would ask is that if it turns out that you see any building violations, that you cite them as quickly as possible while we're waiting on him to comply with the 40-year recertification.
Will do.
Okay. Thank you.
You're welcome.
Reginald, I think we're done. You have until September 16th to get an engineer or an architect to file a 40-year.
I got somebody working on it.
All right, tell him that he's got to do it quickly and file it before September 16, or there's going to be a problem.
Okay, no problem.
All right.
That sounds fair enough.
Okay.
Thank you.
You're welcome.
That sounds fair.
Work with running. Good, man.
That's excellent.
Thank
Take
you.
care. Nice to meet you. Nice to meet you. Okay, Mom?
Thank you.
All right. By the way, do we have a new building official now?
We do not. We've had one since June, so it's been a couple of months. His name is Mr. Richard Ruby.
Okay. All right. It'd be nice once he's on board, if he was available to. Not that I need him right now, but there are situations where I may ask him to address life safety issues, and that would be helpful in my rulings.
Great, noted. We will address this with DSD and have him show. Thank you.
Okay.
All right, the next item I'm going to call is item number 125 Street Plaza Inc. FYBRR 2017-00014. The officer on this case is Shawnee Pressey, and I have the individual here, Frank Wooland.
Okay.
Again, magistrate, he'll be using Director Laz's computer to testify.
Okay. All right, Mr. Wolin, you're not Director Rahman, but I do recognize your face. You're here on behalf of the property owner, 125 Street Plaza Inc. Is that correct?
It is, and good morning, Your Honor. Nice to see you.
Good
Mr.
to see you.
Llewellyn, are you an attorney?
I am.
Okay.
Yes.
Your Honor, I would ask that you pass this matter until September 4th. I know it's been going on a long time. I've recently gotten involved with it, and the property passed the structural portion, and apparently there were some electrical problems. We had some issues with the tenant, and I'm going to be dealing with the tenant personally and replace whoever's supposed to be correcting the problems with someone else if they can't get it done very, very rapidly, Judge. I do have a letter from Policar Engineering Solutions, who is the engineers that we have hired to do the 40-year, and they've indicated to me that the property is safe, and I would just ask for this matter to be passed. I understand that building department has no objection, and I have also spoken with Director Raymond, and he has no objection, and I haven't spoken with Ms. Warren yet, but I don't know that she would have an objection.
All right, I'm going to hear from all three of them, but let me first see if I understand the facts. And Inspector Pressey, please correct me if I'm wrong. Having reviewed the file, my understanding, my recollection, and it's been about a week, was that there was a report that was submitted in 2017. However, the report found that while there was compliance with the vast majority of the trades, the requirements, that there was an electrical issue, and that it failed. The report failed because of an electrical issue. So, am I correct, or do you read it differently?
No, I want to make sure we talk about the same property. We talk about 12865 West 60 Highway?
No, we're talking about 125 Street Plaza Inc.
It's called Lickin now. It used to be the old Royal Castle.
The one on 7th Avenue. Yes,
Right.
that's correct.
12490 Northwest 7th Avenue.
Correct. That's correct. But this has been going on since 2017. As of today, they have not made the necessary corrections or stopped by the building department at any time since I took over as a building officer. So I'm bringing it for you, and I want to put it on record that, hey, they just showed up today. He came to me today to ask me to postpone, and I told him I couldn't.
Okay. Director Rahman, what is your recommendation, sir?
Being that I'm in contact with Mr. Wolin, I don't have any objections as in the other. I think that Mr. Wolin is pretty diligent, and I feel that 30 days would be to revisit this at your discretion, sir. But that's
all right. Let's, as we've done a couple of times before, let's. And I know that Mr. Wolin will do everything within his power to represent his client. And from the address that I have as the owner's address, I can tell you for a fact that the owner is not someone who is indigent. I see 464 Ocean Boulevard, Golden Beach, Florida. That is a very high-end area. So I don't think it's a question of money. It's a question of actually going out there and doing the work and doing the inspection and passing. So I will move the case to my September 4th. I will table it until September 4th, and if not, at that point, I will enter an adjudication and set daily fines. So, Mr. Wolin, please, let's get moving.
Your Honor, I do appreciate that very much. Also, I need to point out the property for the last 10 years has been in the possession of a tenant. The tenant has issues with his rent and other issues. We are working through that. And again, if the tenant can't do it, we'll just take over and do it ourselves by force if necessary.
Yeah, I need to remind you that as a landlord, you have every right to go into court and move for eviction for failing to comply with his obligations.
Very good, Your Honor. Thank you.
Okay, you're welcome. Do we have a case with you also later on, or is that?
Yes, you do. That's my personal case.
Okay.
My wife and I own the office building that I occupy, a 2-story building on West.
Yeah, you don't have to tell me. I've already reviewed the file. It's kind of a similar issue, I believe.
What item are we talking about, Magistrate?
So as long as we have you on camera right now, let's take your case now as well.
Which item are you referring to, Magistrate?
The one that...
item number 18.
Okay, Frank Willis. Okay.
Yeah, it's the same gentleman that you're seeing on camera, yes. And it's also a 40 or 10-year recertification report.
Your Honor, I have hired Policar Engineering Solutions.
One moment, Mr. Willock. Let me read this case into the records. Item number 18, Frank Wooland and W. Marsha. Case number FYBRR 2022-00024. The officer on this case is Vanessa Willis, but Shani Pressy would be representing this case.
Your Honor, I've hired an engineering firm. They've already done the structural, and it's paid for, and I'm waiting for the electrician to do the tomography study, and it's been paid for, so I should have this all wrapped up in the next 2 or 3 weeks.
Are there any violations on the property?
None to my knowledge, Judge.
Other than the fact that there's you haven't filed the recertification report.
There were no violations.
Let me hear from Officer Pressy, right?
Yes. This property also, this is a case from 2022. As of today, no report has been submitted. Moving forward, I mean, even though once they submit the report, it have to get reviewed, and any correction that needs to be made, it takes sometimes they don't make the corrections, or it takes them a while to make the corrections, as his last case from 2017. They don't come back and they don't follow through. But like I stated just now, as of today, nothing has been done to this property.
Okay, Mr. Wolin, you have your engineer. You've paid for the engineer. You've paid what else?
For the electrical tomography report, where they take infrared pictures of the electrical panels to make sure there are no hot spots.
Okay, when can you promise me that the report will be filed?
Within the next 2 or 3 weeks, Your Honor.
Okay, and what kind of a property is this? Is this a commercial property?
Yes, Judge. It's a 2-story small office building. It's concrete CBS, and it's a 4,000 square feet total. It's 25 feet wide by 100 feet long. It's a small office building on Dixie Highway, right across from the Goodyear.
And how old is the building?
Probably 50 or 60 years old.
How many tenants?
3.
Okay. All right. I'll table it until September 4th. Please comply. Don't
Will
make
do,
me,
Judge. Thank you.
Don't make me punish you. Okay. It's all about compliance.
You
okay?
won't have to.
September 4th. Okay. Next one.
Thank you again. I'll do it. It's still your.
My apologies. I was on mute.
We have
All right,
a
I'm
Creole,
going to.
I think we have a Creole interpreter.
Yes, we do have the Creole interpreter here. So I do have an attorney who's also registered on here. So I'll go move with him, along with him, then I'll have Miss Ravost after. So item number 19, Javork Tatarian, case number CENUS 2024-00080. The officer on this case is Shanna Sanders. The attendee is Carlos Dominguez. Let me allow Mr. Dominguez in. Mr. Dominguez, if you can please accept the invitation.
Hi, good morning, Your Honor. Can you hear me? Can you see me?
We can see you, Mr. Dominguez. Is there any other person here for this case? If you can please raise your hand.
No, ma'am.
Nope. All right, no problem.
At least not nobody that I brought.
Okay.
My apologies. Which case are we on?
19. Javork. It's Javork. Shanna on 1935 Keystone Boulevard.
Okay.
So it's a noise ordinance case, I believe.
Yeah, let's, Mr. Dominguez, are you an attorney?
Yes, sir.
What firm are you with?
My own law firm. It's 305 Injury.
All right. What's the address?
The address I have is 1935 Keystone.
No. What's your address?
Oh, I apologize. My firm's address is 1221 Brickell Ave. I can spell that for you. Suite 900, Miami, Florida 33131.
And the name of the firm again?
305 Injury.
No, the name of the firm.
That's my law firm, 305 Injury. It's the area code for Miami.
Okay, gotcha. All right, and you represent the property owner, Javork Tatarian?
That is correct, Your Honor.
Okay. 1935 Keystone Boulevard. Are there any witnesses that you intend to call?
Not at the present moment, Your Honor.
Okay. You understand the nature of the violation?
From the notice that was received by my client, it is a noise ordinance violation. The notice did not contain the code, the municipality code, so I wasn't able to. I looked it up, but I wasn't able to verify the exact code that the violation is based on.
Okay. According to my review of the file, the city has cited you with violating section 12-2. Nuisances prohibited. Have you had a chance to look at that ordinance?
Yes, sir. That's chapter 12.
Yes.
Yes, I have reviewed that specific ordinance.
Okay, and what is your take on that ordinance?
My take on that ordinance is that let me pull it up just so I'm on the same page. I just had it up. I apologize.
No person owning, leasing, renting, or occupying land in the city shall permit or maintain any nuisance as defined in this chapter. And you got to read the rest of the chapter.
Right.
which tends to annoy the community or injure the health of the citizens.
And Magistrate, I apologize while he's reading that over. I do have, and I want to make sure we chime in. We have the HOA president, Karen DeLeon, that would like to give testimony on this case.
All right, she'll have to present the testimony as part and parcel of the city's position,
yes, definitely.
the city's case. Okay, and what is the name of that individual that you just mentioned?
Karen DeLeon.
Okay.
And Karen, please raise your right hand. I know you swore in for the other case, but do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do. You're muted.
Okay.
I do.
Thank you.
All right. First, let me hear from the code officer. And I understand that there may be a police officer. Is there a police officer involved?
There is, and I requested his presence at today's hearing. I or the clerk have not heard back from him, but again, we did request his presence in body cam footage so that it could be presented.
Okay, well that's critical evidence. So if the officer is not present, or if I can't see that evidence, we're going to have some issues here to address with the city attorney. So go ahead and present, officer.
Shanna Sanders, City of North Miami, Neighborhood Service Inspector for property address 1935 Keystone Boulevard. This case was given to me through a police incident report. It was initially given to me through emails when I got into work Monday morning around, let me look here, I want to be exact, on March 12th. I received an email from many residents, including the Keystone residents, regarding a party or incident that happened over the weekend. At that time, we requested the incident report from the police department. From the police report, is stating that they went out actually on March 9th, 2024, approximately the 2100 hour of the evening. The officer responded to 1935 Keystone Boulevard, as he spoke with the property owner regarding a gathering that was happening at the property. And specifically says, upon arrival, I made contact with the homeowner, Mr. Jorvork. I apologize, Taranian. He stated he was having a small gathering with friends at his residence. The property owner was advised to turn the music off, and he complied without incident. Again, I requested that the officer be here so that he can give testimony. Per the emails that I've received on that Monday morning, it seems as though, and that's why I wanted to make sure that the HOA president gave testimony. The emails are stating that it was not a small gathering at all, and it was a huge party that was taking place. But again, other than the police incident report and the emails, that is my testimony as to what transpired on the evening of March 9th, 2024.
Let's see. That was one incident, and it went from 7 p.m. to 8 a.m. Is that the city's position?
That's from the emails that was stated to me. Yes, I am showing, per the police report, it stated that the music was turned off. However, through the emails, it was stating that well into at least to 7:34 was the last time they heard music. It went well into the early morning hours of the morning.
Can you put on the screen the report from PD? Leave it on for just a second. Okay. So this is not a short-term rental or what I would call a party house situation. Is that right, Inspector?
Well, I wouldn't necessarily say that because looking at the history of the property in the past, it does show that they have been cited for a short-term rental in the past. However, the case was closed, stating that ad was presented to the city. However, when we looked online, the ad had been removed, so we closed the violation and just been keeping an eye on it.
I'm not asking about what may have happened, earlier. I'm asking about what happened on March 9th. On March 9th, which is when the violation was issued, the city was not citing him for a short-term rental violation or a party house issue where you charge admission, it becomes a business enterprise, and it's illegal under the code because you're not allowed to do a business activity in a residential area. We're not talking about any of those things, right?
The only other time that I have seen, I do see that there was another violation that was open a year ago on March 23rd regarding the same matter. It was opened by Officer Gennaro Murillo. I didn't take a look at it. I do say that it was pretty much the same thing, that a large party had taken place. But again, that case was never brought to the magistrate or presented.
You haven't answered my question. Yeah, on March 9th, we don't have an Airbnb or a short-term rental issue, right?
Not that I'm aware of. Only other than the two violations that were opened.
On March 9th, not the other ones, but on March 9th, the violation is a loud party, too much noise, a nuisance. That's what this is all about, right?
That's correct.
Okay. So the city has to convince me that a nuisance was being created or maintained on March 9th. So what is the evidence that what under the definition of nuisance, and I've read the definition and what constitutes a nuisance, and perhaps the city attorney can weigh in. Where is the nuisance?
Then again, I'll be honest, I have to say, other than the police report that I received and the numerous emails that I received from the residents of Keystone, I would consider to be a nuisance.
Okay. Does the city of North Miami have a noise ordinance?
Yes, it does.
And what ordinance number is that?
Let me take a look really quick and see.
We'd be looking, Officer Sanders, 1214, 1215 in that area of the code.
Well, that's 12-2 is nuisance.
Do you want the exact reading of the code?
No. I want to know if the city. My question is, if the city has a noise ordinance, why was the property owner cited for a nuisance rather than a noise violation? That's what I want to get to.
Honestly, I went by there being two previous violations already opened for a party that took place at the property, as well as the complaint about short-term rentals taking place. So I was addressing it as a nuisance at that time.
But not a noise violation.
I didn't open a noise violation because per the police report, it stated that the noise was turned down immediately from the 2100 hour. That wouldn't necessarily fall into the noise complaint, because that would be, if I'm thinking correctly, around 9 o'clock. The noise nuisance doesn't really fall into order until, I believe, and I would have to look in detail. I think it's either 10 or 11 o'clock at night. I also went by the emails that were sent to me. The email stated that it took place in the early morning hours, but again, per the police report, in which we tend to go by, it stated that it was turned down at 9:40 p.m. So I wasn't necessarily comfortable with stating that it was a noise violation because, again, the music was turned down immediately, and the officer didn't state, anything other than that.
Okay, I'm going to address some of my questions now to the city attorney. You're aware the county has a noise ordinance. It's 21-28, right?
Correct, Your Honor. I believe the testimony of the officer is that the reason she pursued this not as a noise violation, but more as a nuisance, is because of the impact of the disturbance, the fact that this particular property had engaged in previous incidents of a similar nature, also due to the large amount of complaints received by the office. So in her opinion, it rose to the level of a nuisance. And that's why she opened this as a nuisance violation, not simply a noise disturbance. A noise disturbance, we would be here only discussing the level of noise and the time period in which it occurred. But because this is a nuisance, what the city wanted to present to you this morning, Your Honor, was the testimony of the officer that responded to this party, so you could hear the magnitude of the party that was in progress when he responded, as well as the actual footage, the body-worn camera footage of what he saw when he responded to this party. Unfortunately, Your Honor, the only thing we will have to provide for you this morning will be the testimony of a resident neighbor who likely witnessed the party in full effect on March 9th.
Okay, I'll be happy to hear from the neighbor. I'm just asking questions regarding some of the legal issues, which I cautioned you at the beginning I'd be concerned with, because as I read your nuisance ordinance and what nuisance means, and I'm looking at number one, nuisance means any one or a combination of the following. One, any nuisance known at common law or in equity jurisprudence, or as provided by statute, administrative rule, or ordinance. That doesn't help me. Number two, an attractive nuisance which may prove detrimental to health and safety. Maybe, okay. Number three, physical conditions dangerous to human life or property or detrimental to the health or property values, or which tend to degrade the appearance of a neighborhood. Maybe. Conditions related. Number four doesn't apply. Number five, fire hazards. So I guess technically you could make a nuisance case.
The city feels comfortable that it could have made a nuisance case based off of 3, 4, and 5. If you look, it could have constituted a fire hazard due to the amount of people at the party. We just don't know that because we don't have the officer here. Number 4 could have been satisfied if the sidewalks have been blocked due to numerous cars being parked there. We just don't know that without looking at the body-worn camera and hearing the testimony of the officer.
Okay, so you understand, legally the problem that I'm facing.
Understood.
Understood.
And the city understands the fact that we are coming in with not the evidence that we wanted to present today. Most of the evidence that we would have presented today would have came from the officer who was on scene and witnessed the party and was witnessing the conditions at the neighborhood. And with the officer not appearing today, we are coming in at a disadvantage.
Okay. Just as a suggestion going forward, as the director and I know very well, we both come from a city where noise violations are issued like, hundreds every day. And I'm familiar, the city has its own noise violation, but typically it mirrors the county's noise violation. And it addresses a lot of the issues that the nuisance section does not apply. Okay, for example, I'll read to you from the county's noise violation, which mirrors almost every city's noise violation. The purpose of this section is, and it's 21-28, noises unnecessary and excessive prohibited. Purpose of this section is to protect the health and quality of life, Miami-Dade County residents, visitors, through the regulation of unreasonably loud, excessive, unnecessary, unusual noise. This section shall apply to incorporated and unincorporated areas. It shall be unlawful for any person to make, continue, or cause to be made or continue any unnecessary, unreasonable, loud, excessive, or unusual noise. And by the way, that applies 24/7. What changes is that if you're making, if it's music, for example, there's a presumption that if it happens after 11 o'clock and you can hear it 100 feet away, then it's presumed to be a violation of the code. What I'm saying is that going forward, it may be easier to make a case using a noise violation. If you don't like the one that you have, you can use the county, because the county applies universally to every municipality. So let me hear now from the neighbor, and I'd like the neighbor to address the issue of nuisance. Why was this party on this evening? What did you hear? How late did you hear it? What kind of condition did you observe? What did you do about it? Any information that you can provide that would help the city meet its burden of proving that there was a nuisance going on the night in question.
Shauna, am I the neighbor or there's somebody else?
It's you.
It's me. Okay, no problem.
I believe you're the neighbor.
Oh, I am the neighbor too. Actually, I have the honor of being both. And I realized we could have filled this up with a bunch of people, but okay. Yes, this house on this evening had a party that was beyond thought. My evening was spent with my neighbors texting and calling me saying, what the heck is going on? It was so loud. 1935 Keystone Boulevard, then there's a canal, then there's Hibiscus, then I'm on the other side of Hibiscus. So it was quite the distance, that with doors closed, windows closed, hurricane glass, it didn't matter. People were freaking out at how loud this party was. Now, the party started early, credit. My husband and I took a walk over there. Our concern had been that this has been a party house in the past. I understand we're not talking about that, Magistrate, but this has been a party house that, to the point where people have been like, I can't live on the street anymore. And we've worked with code. Could be there's a new owner. We'll get to that. So I walked over. I did speak to a couple that was walking into the property. I asked, is it a friend of yours who is having the party? Does he live here? And they said yes. I said, would you please do the kindness of telling him it's really loud and neighbors are complaining and they will be calling the police. And while the police were there at the 9 o'clock hour and did their stuff at the 9 o'clock hour, thank you. If police records were pulled, you would see that this party continued. They might have toned it down a little bit, but it continued. So the discomfort that it caused to everybody within the vicinity, that they could not enjoy their own homes, being inside their own homes with the doors closed, that's the issue. And we're not looking for anything horrible to happen to these people. We just need it to stop. And to their credit, there has not been another complaint from any other neighbor since this party occurred.
Okay. All right. And you live how far from the property?
Okay, so they're 1935 Keystone Boulevard, and I'm 1935 Hibiscus. Estimate's like 800 feet.
Is there a canal?
Yeah, so they're on the canal. They're on the south side of the canal. And then I'm on the north side of Hibiscus. You giving me more information on that?
Okay.
A couple, yeah. Yeah. So Canal, another house, a street, and then me.
Okay. And you said after the officer noted in his report that the party had ended or the music had been turned down by 9 o'clock. You're saying that the music continued. Did it continue past 11 o'clock?
Definitely continued into the wee hours of the morning. They did turn it down when the officer left. They turned it back up. And later into the evening, they turned it down enough that I personally was able to finally go to sleep, but there was still a party going.
Is your residence more than 100 feet away from
Oh, yeah,
this house?
yeah. Because you go the canal, so what's that, 75 feet or so? Then another house, then the street, then me. So it's several hundred feet. I'm not going to be able to guesstimate it. But yeah, same house, a canal and a street in between us. Same address.
Okay. And approximately how many people do you estimate were at the premises?
I didn't see the party itself. I just saw the cars, and it was a couple houses worth of cars. They were politely at least diagonal on the swale, but probably 15, 20 cars were there.
Okay. Was this a particularly, was it a holiday weekend or is any particular day that they were celebrating?
Not that I'm aware of.
Okay. March, would have been March 9th. Is that a holiday or a weekend or what?
Birthday.
Spring, maybe a birthday, spring.
It could have been a birthday. It could have been a birthday.
Okay.
Yeah.
Okay.
Yeah.
All
And
right.
as I'm saying, Magistrate, nothing since, which we appreciate, but the audacity to have such a ridiculously loud party, we would certainly love for the message to be given, not okay. And if it is being used again as Airbnb, obviously we don't want that to happen. We don't have any indication that that's continued.
Well, there is no proof that it happened on March 9th.
Yeah.
All right. I have asked all the questions that I felt were necessary for me to be able to make an informed decision, but I have not heard from the property owner, whose attorney is Carlos Dominguez. Sir, I'm going to give you an opportunity to argue both facts, law, and anything else you want, and then I will decide what action I will take.
Thank you, Magistrate. And a brief question. Am I able to cross any of the witnesses if I deem it necessary?
Yes.
Understood. I'm going to start off with an argument, and then I may cross one or two of the witnesses. So
okay. Yeah, but let's not make it adversary. This is not a court, and it's, the formal rules of evidence don't apply. So if in the process of cross-examination you want to prove a point, just make your point, okay?
Absolutely, Your Honor, and I respect this body, and I understand that I will use the utmost decorum in my argument and questioning.
Okay.
So, Your Honor, looking at this case, and it's interesting. At the onset of the case, I thought that this was a noise ordinance violation just by looking at the plain reading of the notice. And now it's turned into a nuisance, which, as Your Honor was given the law on it, this case doesn't qualify as a nuisance. There was no testimony rendered that would demonstrate that there was a fire hazard or safety or harm against other residents. We don't have any testimony as to the exact amount or number of alleged guests at the residence. The only testimony we received was from the inspector, which I didn't hear any testimony from her that she actually was at the scene or the site on the day of the alleged incident. And I know that there are emails, texts, police reports, body-worn camera. None of that has been presented today. So I think that is pertinent with respect to review of this case. And also with Miss, and I apologize if I butcher your name, ma'am, Miss De Leon. She explained that that there was a party beyond thought. and I'm not sure exactly what that means. You know, I'm going to ask her a few questions about the party. I think it's important for all of us to understand her observations. But I think what she said contradicted the police report that, or at least what Inspector Sanders said, which the noise had stopped once the police arrived. According to Ms. De Leon's testimony, the noise continued. So there is a contradiction of testimony there. And Your Honor, you know, looking at all the facts and also considering that the alleged property never received any complaints after that police visit, I think that is also a pertinent element to all this. You know, wrapping this all up, Your Honor, you know, I attended the last hearing, which was reset unilaterally. I wasn't given notice of that, so I actually sat through that whole hearing expecting the case to be called. And, you know, my client is, you know, he's understanding of the situation. But again, I don't believe, legally speaking, that this is a nuisance. This would not qualify as a nuisance. I don't think that there was sufficient evidence presented. And so, Your Honor, I defer to you. I don't think I'm going to move forward with the questioning. I appreciate the time and opportunity for you to hear me out. And yeah, thank you.
You know, this is, I heard the city attorney say that it does qualify as a nuisance, but as I read the definition of a nuisance, typically my understanding of the law, and believe me, I know nuisances. I've been a city attorney. I've been a resident for a long time. A nuisance typically is not a one-time event that happens between a certain hour and another hour. And the definition that the code cites, it talks about physical conditions dangerous to human life or property, and conditions relating to private or public property which impede the traffic of folks and whatever. Where I do see a possible nuisance violation, and in my mind, a nuisance is something that takes place over time. A one-time event, in my mind, as I understand the law, a one-time event does not diminish the value of property, does not create a nuisance as we understand nuisance in the legal sense. But there is a provision in the city's nuisance ordinance which talks about detrimental to health or property values, or which tend to degrade the appearance of a neighborhood. And that's why I'm struggling a little bit, because that definition, or detrimental to health or property values, or which tend to degrade the appearance of a neighborhood, may qualify. But Mr. Dominguez, what do you think of that?
Again, Your Honor, respectfully, we didn't hear any audio of the party. We only heard testimony from De Leon. We don't know how loud the music was. There was no measurement device presented or no decibel amount for the music. I understand that according to Inspector Sanders, there may have been previous violations. I haven't seen those. And I stand by what my initial argument was, Your Honor, that this is not qualified as a nuisance.
Yeah. All right. So this is not a criminal case. This is a civil matter.
Correct.
Is there any reason why your client is not here? Is not here to deny the allegations?
Absolutely, Your Honor, and I understand that this is not a criminal matter. So his attendance may have influenced this case, absolutely. But Your Honor, he is a surgeon, and he had various patients today. He also had various patients in the last hearing. He deals with various different types of surgeries each day. And so that's why he needed to hire my services in order to represent him in his absence.
Mm-hmm. Well,
yeah.
Anybody? Does
It was
anybody
fined
else?
already.
Yeah. Does anybody else involved in this case wish to make any further comment?
Yes, man.
Yes.
So just from the homeowner association point of view, we're not looking to penalize the gentleman. He's our neighbor. We just really would appreciate if it didn't happen again. And when I say a party beyond party, it's that type of thing where you bring in the type of amps that you would have at a large stadium type thing, and you put them next to water. So an awareness from our neighbor that it's just not kind. That, like a warning to not do it again. Obviously, since this happened, the fact that there haven't been more parties is a thorough relief for us, having been through party after party, weekend after weekend for so long. Once again, could have been previous owner. I don't know when it changed hands, etc. That's all that we're really hoping for from a neighborhood association. We're not looking to penalize anybody.
All right, I appreciate that. Mr. Dominguez, in an effort to resolve this without getting into legalese, you understand the importance of being a good neighbor, and these parties do not contribute to neighborly peace. Okay.
Absolutely.
And certainly people are entitled to celebrate their birthdays. They're entitled to celebrate the 4th of July tomorrow. Sometimes, Memorial Weekend and spring break brings, a lot of people into town and they want to celebrate. But sometimes the place to celebrate is not in a single family residential neighborhood. And I see some legal issues with the case, which I as a magistrate, I have to explain that there's really not enough, and the standard is higher. The burden of proof in a case of this nature is higher than it would normally be in a civil case. For example, in a civil case, it's greater weight of the evidence. In a case of this nature, in code violations, is higher. Anyway, I don't. This case is not necessarily being resolved because the city failed or didn't fail to prove its case. It's being resolved because the association wants to live in peace, and Mr. Dominguez's client wants to live in peace with the association. And so I'm not going to fine the owner based on the evidence that I've heard today. And based on my interpretation of the law. And I will tell you, though, that if it does happen again, I will not be as lenient. So please, I know your client evidently is a successful professional, probably has a lot of friends, but when it comes to, if you're going to do a party, it's great if the party is between 7 and 11, and then after 11 the music is turned down so that it doesn't bother the neighbors that are more than 100 feet away. Now, if it would have been the next door neighbor complaining that he or she could hear trumpet or something, it's a more difficult case. But if you can hear it up more than 100 feet away, to me, it's unreasonable, unnecessary, and it would violate every noise ordinance in the book. So that's it. I'm basically saying to you, sir, be careful, be a good neighbor, and continue to work with the association. So I will dismiss the violation with the warning and the caution that if it comes back to me, again, and hopefully it'll include the noise ordinance, because that's my ticket to fine you. And again, if you read the noise ordinance carefully, you can cite somebody for a noise violation if it happens at 8 o'clock in the morning or at 10 o'clock at night or anywhere in between. Noise is noise. And if it's unreasonably loud and if you can hear it more than 100 feet away, it's deemed to be unreasonably loud. You can bring it as a nuisance case. You can bring it as a noise violation. Give them, both. But it's easier for me to find somebody guilty with citing a noise violation instead of a nuisance violation. A nuisance is typically something a little different. So based on that, I'm done. I hope this doesn't come back to me. So anyway, have a good day.
May I address something, Your Honor? I
yes.
will make it very brief. Thank you so much. I appreciate this honorable body. I know that you have a bunch of cases coming up, but I just wanted to, send you my appreciation. My client sends you the same. I will advise my client of everything that was discussed today. Thank you so much, Ms. Sanders, Ms. De Leon. To the deputy city attorney, thank you. I hope everybody here has a great day.
Thank you.
Thank you.
All right. Goodbye.
Bye-bye.
All right, Magistrate. We do have Ms. Rivas as well as the interpreter who's been patiently waiting. So let me call that into record. That is item number 26, Janae Rivas, Odette Rivas, case number CEBPR 2022-00643, previously found guilty by Magistrate Kazoo, with an abatement date of July 20 of 2023, fine set at $450 plus the $100 cost assessment. Ms. Rivas, if you can please enable your audio and video for me, as you did earlier.
Good morning. I haven't been sworn yet. This is the interpreter.
All right, interpreter, let me this word. To be an officer of the court. For our Creole interpreter, do you solemnly swear or affirm that the translation in which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Please say I do.
I do.
Miss Rivas, if you can please raise your right hand.
Madame Rivas, vous pouvez lever mes doigts pour en l'air, s'il vous plaît?
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
Est-ce que vous jurez solennellement que tout témoignage ou bail pendant la procédure ça, c'est la vérité, seulement la vérité et rien d'autre que la vérité, que bon Dieu vienne en aide? Dis oui, s'il vous plaît.
Oui.
I do.
Sir, can you please state your full name, your address, and relationship to the property?
Madame, est-ce que vous êtes capable de dire nom complet et adresse là avec relation avec propriétaire, s'il vous plaît?
I said, sir, I meant man. I saw the Haitian Creole interpreter and I thought that he was the party, but I see that the owner is Jean Revost.
Yes.
Yes.
All right. Name, address, and relationship to the property.
Oui, dis-moi nom, adresse ou et qui relation avec propriétaire.
Moi, relais Jeanne Revo, moi c'est maître propriétaire. Adresse là c'est 1040 Northeast 145 Street, North Miami, Florida 33 161.
My name is Jean Revo. I am the property owner. The address is 1040 Northeast 145th Street, North Miami, Florida 33161.
And you're the owner, correct?
What's the propriétaire là, Robin? Yes.
Oui.
Wait. Yes. Okay. Do you understand the nature of the violations that are being charged by the city?
Est-ce qu'on comprend la nature violation que city a chargé là?
Oui, me comprends.
Yes, I understand.
Have you done anything to correct those violations?
Et est-ce qu'on t'a fait un bagay pour corriger violation ça yo?
Nous fait tout bagay city a mandé. Nous bay toute application, nous payer toute fee, nous employé un contracteur a toujours fait tout ça, il a demandé, contracteur allé dans City en tout temps, ça fait 2 ou 3 semaines, là, dans City en 2 fois, li chita avec examineur, moi, j'ai tonton qui habite l'autre bois, li allé dans City en tout temps, kounye à ce City en attend parce que nous fait tout ça, il a demandé nous faire.
Yes, we did everything that the city requested. We sent all the applications. We paid all the fees. We employed a contractor who did everything that has been asked by the city. They went to the city. They go to the city all the time. For the past 2-3 weeks, they went there and sat with the examiner. And I have my uncle there as well that live over there that went to the city and spoke with them. So we did everything that was requested from us, and we're just waiting on the city now.
Does she have a permit to legalize the carport?
Est-ce qu'on gagne un permis pour légaliser parti garage là, pardon?
Oui, nous avons permis ça, nous avons demandé permis, là, nous avons fermé le garage là, c'est un contracteur, nous avons employé, c'est lui qui a demandé permis, il a une licence, et il a inspecté après, il passé tout le test.
Yes, we have a permit. We had a permit for the carport. The contractor that we employed requested that. They have their permit and they have everything that they needed, and they had it supervised. Everything was done.
All right, let me hear from the officer in question. Officer Morillo.
Yes, so I see here that structural denied this on April 12th. Flood denied it on April 19th. I just see that on yesterday zoning approved, but they still need to do come to the city building, yes, and do revisions to the permit.
So they've done quite a bit of work. They've actually gone through building and zoning, and they do have zoning, right? And the structural was denied because
zoning just approved yesterday, but they still been denied by flood and structural. And
what's the problem structurally?
Let's see. Let me read the comments.
May I interpret that in the meantime?
Yes, please. Let the interpreter interpret.
Alors, officier a commencé pour faire connaître que alors partie structure là, il a été refusé de maintenant le 12 avril. Il y a un autre département encore qui était en refus le 19 avril. Mais hier, département zoning là lui-même était approuvé. Mais qu'on y a là toujours, il y a une attente pour partie construction avec pour être capable de faire révision pour permis. Donc magistrat lui-même a affirmé si toutefois nous avons fait un bon parti dans le travail qui supposé fait et que nous gagnons permis pour zoning là et que l'officier a répondu oui que nous gagnons parti par zoning là qui était approuvé depuis hier qu'on y a ces parties structurelles là et qui problème et que les pral vérifier pour capable de répondre question magistrat qui c'est qui problème qui gagne dans partie structurelle.
Okay.
Okay, I'm listening.
All right, go ahead, Mr. Inspector.
Okay, Your Honor. So it says on the comment that they put on April 12th, previously issued comments still not addressed. So this comment on what this one was, they noted this on February 15, which says update FBC code and standards on plan, provide wind calculations, provide special inspector form. So none of this has been provided.
Mr. Interpreter, can you interpret that and ask her what is it going to take to get the permit approved?
Bien. Et donc, dans ça que officier a appelé, et rapport que li gagne, et il dit que gagne un commentaire qui était fait, alors qui était sorti pour 12 avril, et côté que t'es bail en note que t'es adressé, alors pour adresse là, côté que noté, alors ça t'est noté le 15 février, et de mise à jour, que t'es bail de BC1, pour demande et calcul qui fait pour attente qui gagne à possible bouchage ou bien barrage. Donc question qu'on y a c'est que magistrat a posé pour vous, c'est combien de temps vous pensez ça prend pour capable gagner et permis ça que attend là?
Moi, je ne peux pas dire combien de temps parce que là, nous finissons par tout ça, si on demande qu'on y a nous obligé de retourner si nous pas qu'à faire pour compte nous. Ensuite, je ne peux pas comprendre qui j'en fait gagner un bagage qui noté depuis 12 avril et que nous pouvons faire rien sur lui. Or, contracté à sortant et en city, il fait 2 voyages pendant fin mois juin, arrivé dans mois juillet, il chita avec examineur pour mettre tout bagage à jour.
Well, I can't say how long it's gonna take because after we do, we provide everything that the city requested. We just have to wait on for the city to reply and provide the permit. Now, one thing I don't understand is if something was noted since April 12th, why nothing has been done yet. And the contractor has been going to the city. They went to the city twice between June and July. They sat with the examiner. And so why is that not happening yet?
Well, explain to the property owner that the plans that were submitted to the city were rejected as improper, because it did not deal legally with the structural portion of the plants.
Bon, ça qui passe, c'est que plan que nous te soumettre by city, yo te rejeté li parce que li pas adéquat et parce que li pas répondre de manière légale à structure plateforme là qui était dans plan.
Kounye, ça me comprendre, c'est chaque jour nous retourner nous battre derrière dans caisse ça parce que ça a gagné pour 6 mois moi-même avant dans hearing because chaque 2-3 mois dans hearing m'tere le city yo dit c'est celle zoning qui peut approuver tout bagay approuver. Or kounya et tout plan rejeté, m'pa comprendre.
Well, now I feel like the case is being pushed back every time because 6 months ago I was in a hearing because we always have a hearing every 2, 3 or 3 months. And the last time I called the city, they told me that everything was approved from zoning and all other departments. Everything was, I'm sorry, they said everything else was approved. It was only the zoning approval that was missing. And now I don't understand when you say that they were rejected.
I'm going to let the officer address that specifically, but before the officer says that, addresses it, tell her, number one, zoning issues have already been addressed, number one. Number two, building issues are not yet resolved. And whoever she spoke with, she spoke to the wrong person. Maybe the contractor gave her misleading information, but the city says that there are still structural problems with the plans.
Bon, mbal kite inspecteur a parlé sur ça, mais avant ça, moi, m'a informé, m'a expliqué que partie zoning là, problème qui gagne pour partie zoning là, li gen temps résoudre. Deuxièmement, problème qui gagne pour partie construction, partie building là lui-même, ça pour qu'on résoudre. Et donc, quel que soit le monde qui a été parlé avec client, peut-être a été parlé avec mauvais monde, qui a été mauvaise information, ou bien peut-être que c'est contracteur qui lui-même recevoir mauvaise information et qui ba ou information qui pas correcte. Mais bureau et City en lui-même jusqu'à présent dit que gagne un problème qui c'est un problème structurel.
All right, I don't need a response from her. I'm going to ask the officer to perhaps put on the screen the comments from building showing that what the problem is so that the property owner can see for herself rather than relying on the contractor or somebody else saying it, what the actual comments from the building department say.
Donc, on a mbral quitter officier lui-même pour t'y parler sur ça, et j'aime désolant pour capable expliquer qui ça exactement gagne comme information dans notre yo, contrairement à ça que yo dit ou bien que peut-être contracteur a dit pour capable connaître exactement qui note que yo gagne qui ça gagne pour faire.
Okay.
Okay.
All right. Officer Murillo?
Sorry, Your Honor.
Can you put on the screen the comments by building?
Gennaro, I can allow you to be the host in order to share that, because their building comments wouldn't be in this case, because that's something they need. That's through the building department. But if you pull it up, Gennaro, I can give you access. Okay. One moment. One second. Let me see if I can pull it up. Huh? You ready?
Go ahead. If it's gonna take much more time, we'll move on.
Yeah, well, I will have to log into the building's comments in order to do so. Because building comments would not be in the actual code violation case, so it would be.
I understand. How long will it take for you to do that?
If you just give me a few seconds, I can log in there.
All right, seconds are good.
Let me share this screen.
I just want the property owner to get the
These are the
facts.
comments here.
Okay.
Which one? So that's one of them. Here is
Can you make
another.
it? Can you make it a little larger?
I don't think so. And that makes it even smaller. I'm not able to make that larger, Magistrate.
Okay. What I'd like you to do is I'd like you to send that over to the property owner so she understands why the plans have not yet been approved. She may be under the misunderstanding that it's the city's fault when in fact it's the contractor's fault. So I would like the interpreter to explain that we're going to send her a copy of all the reasons why the structural plans are defective. And until and unless those issues are addressed, she's not going to be able to get a building permit. And it's not the city's fault, it's the contractor's fault. And the contractor is the one that is telling her that he's done everything and he doesn't understand why the city hasn't issued a permit. No. These are the reasons the city hasn't issued a permit. Okay, Mr. Interpreter.
Nous allons voyer toute information sur plan et structure là et qui pas bon pour capable connaître qui ça exactement qui fait que pour ka jeune permis parce que peut-être au cas et gagner alors faut que tout ça est fait pour ka connaître tout ça qui supposé fait pour avant même pour capable recevoir permis construction parce que c'est pas faute et bureau city en que lié mais c'est plutôt faute contracteur qui a peut-être à bas au fond information qui pas fait ça le supposé faire et puis ou même on pensait que c'est city qui pas fait ça que le supposé faire donc n'a voyé tout et notre pour capable connaître exactement qui ça bien pour faire.
OK, merci.
Okay, so this is what I'm going to do. To be consistent with all my prior rulings and understanding that the property owner has done a good job trying to get the permit issued, and in fact has received permission from the zoning department to go ahead with the permit. There's still some issues that need to be resolved in good faith. So I am going to table this until September 4th, as I've done in prior cases, to be consistent, and explain to her to please show the what the city is going to send her, show that to the contractor with instructions to correct them no later than September 4th. If the corrections are not made by September 4th, I will ratify the fines, and then the contractor is going to be the one that's going to be responsible for all of these fines and violations, and may have a licensing issue with the state for failing to protect his or her client in these proceedings. So just explain to her that she has until September 4th. I'm going to table the case. She's going to receive these papers from the city showing where the contractor made a mistake, and I want the contractor and I want her to tell the contractor to correct the mistakes.
Et donc ça m'a fait pour me capable de continuer de manière consistante avec décision que moi prends puisque me comprendre que vous même en tant que propriétaire là vous fait très bien et dans façon que vous essayez pour joindre permis et juste dans point que vous arrivez joindre et approbation zoning pour capable avancer et à question permis mais par contre toujours gagner quelques petits bagages qui pour résoudre qui pour qu'on fait. Donc m'a avancé dossier m'a m'a renvoyer pour mettre jusqu'à 4 septembre. Donc s'il vous plaît, ou même m'a besoin pour montrer et contracteur tout papier que City a bral voyer ba ou qui gagnait instruction sur correction qui pour fait et ou a dit contracteur à ça que li supposé faire et 4 septembre plus tard ça a supposé fin fait. Sinon a gagné moyen à redémarrer toute amende et qui était supposé à marcher et c'est contracteur lui-même qui est responsable pour ni amende ni violation qui fait et il capable même gagner problème à licence et à travers de bureau l'État et par rapport au fait que lui-même li pas fait travail li j'en supposé faire pour le protéger ou même en tant que client avec travail que va les faire. Donc on va recevoir papier et ou même faire contracteur à connaître ça que le gain jusqu'à 4 septembre au plus tard pour travail pour ça et correction au fait et puis pour capable jeune permis.
OK, merci.
Okay, thank you so much.
All right, Inspector Murillo, please be sure to send the comments to the property owner so she can confront the contractor with what the facts really are.
Yes, Your Honor.
Okay, thank you. Next case.
Excusez-moi, est-ce que li ka voyel directement à adresse côté m'habite?
Excuse me, can you send that directly to my to the address where I reside?
I already asked the inspector to do so, and he will.
Moi, j'ai demandé au officier pour le faire ça, il a fait ça.
Mais m'parete nan kay la, c'est m'parete même dans set la même. Pas vle li voyel la kay côté North Miami.
But I don't live at that address that's in the case. I don't even live in the state. So I don't want it to be sent to the address in North Miami.
Well, then she's going to have to come over.
Yes.
She's going to have to come over. Are you willing to send what address do we have for her? Inspector Murillo, what address do we have for her?
I'm sorry, Your Honor, can you repeat?
She said that she doesn't live at that house, that she has a different address, and she wants you to send it to the other address.
So she wants me to send her all the notes from the building department?
Yes.
To her address?
Yes, but she has a different address.
The address we do have on property appraisal is 1040, but she will need to provide that information to us, magistrate, or she can come and pick it up personally.
Okay, that's what I'm going to suggest.
Okay,
Mr. Interpreter, ask her to drop by the code office to pick up the information.
Bon, c'est pas. Sorry. So
that we don't have a mail issue.
Actually, magistrate, the building department, they were able to provide all that information to her.
Okay, so then have a copy in an envelope at the building department for her with her name outside the envelope for her to pick up.
Et y a préparé papier pour quitter le bureau et avec y a tout mettre dans enveloppe avec non soli et puis pour capable passer dans bureau pour prendre.
Parete Florida, nous met voyel dans discount là.
Well, I don't live in Florida. You can send it to the 1040 address.
Okay, send it to the 1040 address. The fact that she doesn't live in Florida doesn't matter. She has to have access to these documents. Somebody has to send it to her, or she's going to have to come down.
Mais ok, il pour une adresse 1040 là, et parce que le fait que vous pas vivre dans Florida, ça n'est pas vraiment compté là important. Donc il faut que tu aies un monde qui pour prendre pour capable voir ba ou.
Ok, merci.
Okay. All right, let's go. Let's move on.
All right, magistrate, the next case we're going to call is item number 30, La Puerta Life Center, Inc., FYBRR 2015-00064. This case was previously found guilty by Magistrate Kazoo with an abatement date of March 4th, 2022. Fine was set at $500 plus the $100 cost assessment. The officer on this case is Shawnee Pressey.
Anybody present on behalf of the owner?
Yes, I'll have a Rachel Streitlife, I believe is the pronunciation. Please correct me if I'm wrong. And also accept the invitation to speak, please.
Hi. Good afternoon,
Hello.
Magistrate. It's Rachel Streitfeld.
No problem.
On behalf
Streitfeld, are you an attorney?
I am an attorney. I'm here on behalf of La Puerta Life Center. My address is 7293 Northwest 2nd Avenue in Miami.
Ms. Pressey is the officer. Shawnee, if you can please enable your audio and video as well.
Judge.
Who Who's talking?
That's Miss. I think that's Miss Percy's background. No.
Yeah, I try to keep my thing mute because of the background behind me.
All right. Can
in
you
the
enable your
office.
video at least? Oh, okay. Never mind.
I did.
I'll
I'm
mute you. All right. Go ahead.
Okay, so Magistrate Kazoo found the property owner guilty on back in December of 21. That's a long time ago. Imposed a fine at $500, and this is a 40-year recertification issue, a violation of 5-35. Ms. Streitfeld, please tell me why there has not been compliance in accordance with the magistrate's order.
Thank you for the opportunity, Your Honor. My understanding is I was under the impression that this case was closed. The property, La Puerta Life Center, is a church that has been under construction for quite some time. My clients purchased this property before the pandemic when their membership at the church was thriving. And they took out a construction loan to do an interior renovation. They began work on the building. And then during the pandemic, they lost many of their members, and they've been continuing to identify or to attempt to identify basically the money to continue with the construction project. So the building is vacant. It has not been in use. There's no one there. And the status of the building is that it's been vacant and under construction for several years. They did have an engineer provide a report to the city of North Miami. That report was submitted and filed. It's February 20th, 2023. The engineering report is certified and signed and sealed. And the engineering report does provide that the building is under construction, that yes, structural and electrical work needs to be completed before the building can be certified. But because we're in this situation where we're trying to pay for the construction, no movement can be made, no movement has been made. And my clients are, again, trying to finance this project, but they're having trouble doing so. So that letter, and I apologize, Your Honor, that letter is not uploaded as evidence in this case, but I've been emailing back and forth with Mr. Ruby, the building official, with Mr. Remond, and with the city attorneys. I sent that letter to them, I believe yesterday or possibly Monday. Again, after this case was adjudicated, that engineering letter was filed with the city, which should have at least addressed the issues. So they're not going to be able to recertify this building. And like I said, it's not being occupied, so there is no life safety issue.
All right. So your clients bought a property that was being used as a church.
I'm not sure if it ever was used as a church. They hope to use it as a church. As I mentioned, their membership was thriving when they purchased it. And so I think that they needed to grow, and they initiated this construction project and then ran into financial issues.
Okay. So currently, as things are going on, I suspect that there is a plan for the building, whether it's demolition or restoration. Are there building plans filed for something?
I would imagine that their permits are expired, but I can't confirm the status of the building permits at this time. There were other issues There were other issues as far as notices. The city had, required business tax receipts and certificates of use, and we got those violations dismissed because it's not being occupied.
Okay.
Not a
All
business.
right. So I get it. I get it. So I want to ask the building department and/or the building official, if the building is vacant if there is no contemplated use for the property, and if it's not a life safety issue, why does it need a 40-year recertification?
Okay, so as far as the code states in the 40-year recertification, it doesn't state that it doesn't require that it will be exempt based on it's not being occupied. So because it is a building there and it's not being used, it still needs to be recertified unless they're gonna probably demolish the building. I'm not quite sure what they want to do with the building, but it doesn't be exempt from having to do the 40-year recertification.
All right. So how do they, if they have not made a decision on either demolition or what the building will eventually look like if it's restored, what should they do at this point?
If I don't receive anything, we will have to send it to unsafe structure, and then they will make the last final decision.
Yeah, I understand how that works, but so they issue a demolition order. That closes the case
at this point. But they would try to figure out some type of way, but I'm not quite sure what their plans are trying to do. Are they going to just have the building there without doing anything? Because I'm just hearing about the notice now as of today, as we speak now. And I post that notice, I don't know how long. I haven't received a copy of the notice, and I didn't get copy on supposedly the email that went out to the building official on Monday.
All right. Ms. Streitfeld, your client needs to make a decision. Demolish or not. If the decision is to demolish, I assume you need a demolition permit.
Correct.
You need to go to the building official, apply for a demolition permit. This case is over. If you want to keep the building, then you need to file a 40-year recertification. If you don't file it, you're going to get fined. So what is your client going to do?
Well, Your Honor, I appreciate that. And, you know, Inspector Pressey is not on the chain of emails, but Remy, Zane Remy, Jeff Cazot, Jen Warren, Paul Marie Bob, Debbie Love, Lazo Rahman, they're all on there, as well as Robert Ruby, the building official. I made the argument that you made, Your Honor, which is that this building does not have a certificate of occupancy, and therefore it does not fall within the definition of existing buildings under the Miami-Dade County Code. The building official disagreed with me, and that's why we're here. I see the city attorney is raising her hand. I don't believe that my client was planning to demolish. What they're hoping to do was an interior renovation. And so I'm happy to go back to them and say, do you want to sell the building, or are you going to be able to raise the money to complete the construction work? But at this point, they are bleeding money on this project. And so if there are fines, we need more time to make a decision. And I'm happy, Your Honor, if you want to reset this case, and we can work with the city so that I can force my clients to make a decision. But, you know, it's not like I said, it's not a life safety issue or a public nuisance issue. And I understand the importance of having the building recertified, but right now there's nobody inside it.
All right. First of all, I'll call on the city attorney and Manager Perez, who has his hand up. First of all, it's clear that I do not have the legal authority to overrule the decision or the opinion of the building official. The only way that you can challenge the decision by the building official, his opinion on whether or not you need to recertify, is by appealing that decision to the Board of Rules and Appeals at the county. What the city probably will end up doing is taking it as you heard from Inspector Pressey. They're going to take it to the Unsafe Structures Board, and the Unsafe Structures Board is going to say, because that's what they do, is because you have not assured the county that the building meets all of it, all of the requirements. It's not just safety issues. It's not just life safety. It could be plumbing. It could be electrical. It could be structural. It could be anything. That they're going to tell you that they will demolish it within 30 or 60 or 90 days unless you file the appropriate certification. And if you file a 40-year recertification, doesn't mean you have to do all the work the same day. You can, get extensions on things that need to be done. But you're the owner. You don't have the right or the privilege to maintain a structure, even with or without an occupational license. You don't have the privilege to maintain a structure within the city unless it meets the city's codes, even if it's unoccupied. So let me turn it over to the city attorney who wishes to make a comment about this case.
Your Honor, you stole my words from me. But I will confirm that Ms. Streitfeld had reached out to our office. She had made these legal arguments. We did reach out to the building official for confirmation, and he advised that in his interpretation of the Florida Building Code, absolutely a 40-year recertification is required for the building, whether it's occupied or unoccupied. What I did not know at the time is that this violation had been going on since 2022 for compliance, and so it's not really relevant at this point. At this point, there shouldn't be any challenge as to whether or not the 40-year recertification is required. This court has already made that adjudication and has already set that abatement date for back in 2022. Today, what the city wants to hear is whether or not there's compliance, and if there's not compliance, what is the timeline and the steps that the property owner is going to be taking to come into compliance.
May I respond, Your Honor?
Of course.
Thank you. The email from the building official, Richard Ruby, states that the report may state that certain aspects of the building are under construction and will be observed at a later date. And that February 20th, 2023 report from our engineer does exactly that.
Can we have Inspector Pressey confirm whether or not this 2023 report satisfies the requirements of a 40-year recertification? Because when I looked at it, it was a one-page report that basically said there was no structural issues, but I don't believe it had the contents that we usually see with a 40-year recertification report.
Correct. You are correct with that. And then also, being that she doesn't have a active permit, it then is going to override you doing the 40-year recertification. You don't have an active permit. You guys not doing any work at this moment. So when you guys gonna move to doing the recertification, the Miami-Dade County only allow 2 extensions for the 40-year recertification. So if you keep on prolonging it, how long can I stretch it out? But as you was correct, it doesn't state that in the letter.
So what's the answer to your question, Madam City Attorney, that there is no building certification filed?
Correct.
There may be something else, some other letter that was submitted or exchanged, but that's not compliance with the 40-year recertification code section 5-35. So I don't think I have any choice but to ratify the fines. The city cannot afford and cannot allow a vacant structure to remain there with or without an occupational license, without a certification saying that the structure itself is safe. Because ultimately, if there's a collapse and there's somebody nearby, you can have a really dangerous situation. And I'm not familiar with the project, the property. I don't know what's around it, but could be anybody. It could be a utility worker. It could be even a trespasser or a next door neighbor that could potentially be at risk. I don't have the authority to overrule the building official, and I don't have the authority to negate what the prior special magistrate ruled. So the only thing I can say is that if your client decides to demolish, you would have an excellent opportunity to come back to the city and ask that the fines all be wiped out in mitigation. But if on the other hand you want to go ahead and restore the property, you're going to need a 40-year recertification, because you can't have it both ways. If you're going to have a piece of property there, it's got to be recertified. So I know it's difficult. Financing may be great. But look, this has been around since December of 21, when the prior magistrate found the owner guilty. I think my hands are tied.
I appreciate that. I mean, and just one note regarding the timeline. I didn't know that this case went back several years, but based on the timeline and the date on the engineer letter, my assumption would be that the city requested, and this happens in many jurisdictions, where the city will request a letter from an engineer certifying that the building is structurally and sound electric as well. And the letter from February 20th, 23 does say the building is structurally and electrically safe. So there may have been an instance in a past hearing or in past meetings with the city where they said, provide us with a certified letter from engineer that it's safe. And that's what I would suggest happened. If Your Honor would give us an opportunity to, 30 days to make a decision as to whether or not we're going to demolish or whether or not we're going to sell, we would be really grateful for that time before you make a decision on ratifying the fines.
All right. Yes. And I know you're familiar with municipal law because you're an elected official, correct?
I am, Your Honor.
Okay. In my neighbor town of North Bay Village.
Yes.
And that's where I know it, that's where I recognize the name. Now, it is true that in many cases, a building official will require a property owner to submit a letter from an engineer saying that the structure is structurally sound and safe. It's not a public health issue. Yes, happens all the time. But to suggest that letter can be submitted in lieu of a 40-year recertification report, which is much broader than just, life safety, is a misstatement of the of what happens in government. We've had many code violation situations where property owner comes in and says, no, that crack along the canopy is not a structural life safety issue, and the building official may say, okay, so send me a letter from an engineer saying that everything's fine, and those issues get resolved like that. But if that same building is not due for a 40-year recertification, it doesn't have to file one. The letter might be sufficient. So I will grant you an extension. I will, as long as the building remains vacant and unoccupied. I will table a final decision on ratification until September 4th, as I've been doing all day. I've treated everybody the same. If you have good cause, and if you're reasonable with me, and if you're willing to work with the city, then I will table it until September 4th. Come September 4th, I need a decision. You either apply for a demolition permit, or you ask an engineer or an architect to certify. And you know, it's not a burdensome job. I mean, most engineers and architects that I know that do this for a living can do it in a couple of weeks, especially in a small building. You go in there, you do your inspections, you do your testing, you take your photographs, and you write a report. This is fine, this is fine, this needs to be fixed, this needs to be fixed, blah, 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 and that's done. It's filed, you paid $350, $357, and you're in compliance. Now you may need more time to do additional repairs or modifications, and I'll give you more time once you decide that you're going to keep the building and once you file your recertification report. So a decision has to be made. Is the building going to stay or go? And I'll give you until September 4th to tell me.
Thank you.
By the way, great things are happening in North Bay Village. I'm looking forward to that Publix opening. I'm looking forward to all those beautiful buildings going up on the water. You guys are doing a wonderful job. You got a great mayor. Say hello to him on my behalf. And you have a special master system there as well.
We do.
I know that she does a very good job. Monestine, is it?
Correct.
All right. So I follow what goes on in your city very closely. It's right next door to where I live.
Thank you for the kind words and the encouragement. I'm very proud of what we've done here.
I would be as well. You got a good commission for a change. Anyway, yeah, for a change. Anyway, let's move on.
Thank you, Your Honor.
You're welcome.
Yeah. Magistrate, we're going back to item number 2 on the agenda, 12940 Aurelia LP, case number CEDIC 2024000002. The officer on this case is Murillo. This was the video that we wanted to review.
Yeah, I want to see the video of the dumping.
Sure. Let me go back into... Here is the...
We had already introduced this case before, right?
We introduced it, yes, and then we're waiting for the video. So I'll go ahead and share my screen. One moment. Hold on. This was for the illegal dumping in the canal.
And again, the property address is 12940 Aurelia?
Yes, Aurelia Road.
And who took this video? A resident?
Gennaro, did a resident take this video?
Yes, Your Honor.
Okay, I'm going to ask, because I need to ask these questions. I know that we're not in trial, but somebody's going to have to authenticate this photograph. And by that I mean somebody's going to have to tell me that the conditions that are shown on this video are true and accurate depictions of what happened. Because this could be anywhere in the world. I don't know where this is. Somebody's going to have to identify this video for me, and best that it be that whoever took it, but in the absence of that person, then the code officer is going to have to confirm it.
Your Honor, actually that day we visited that property. The building official was there, my director, my manager, I was there because we had to handle a complaint about work that they were doing on the backyard. I had some pictures, but unfortunately, I don't know what happened, but they could support my testimony of what we saw that day at the construction that they were doing in the backyard. Thankfully, the neighbor sent us that video, but basically, they were dumping from the pool debris and sedimentation from the construction debris that was happening at the pool.
All right, I need to see the video, please.
Sure. Let's put it on the screen again.
That what I saw was a picture.
Well,
This is a video.
Okay, I see the video now. Where is the discharge?
Say that again?
No, where's the discharge of the materials from the pool? Is that hose, that blue hose?
Yes, Your Honor.
Okay, so you're testifying that there was building materials.
Yes, Your Honor.
That were flowing through that hose into the
canal.
Into the canal. Okay.
Yes, Your Honor.
And what work is being done at the pool?
So they were doing like a whole demolition in the backyard, and they were doing like renovations. So again,
can I just check? Can you put up the ownership information again?
Sure.
Okay. I don't know whether that's not a person. That's a company.
That's the company, and then we have the Sunbiz, the registered agent.
Hang on, going too fast. Who are the individuals? That's a registered agent. That's a law firm. But go down further, and name and address. Well, it doesn't tell me who the owner is.
No, this is also under a business. 12940 GP Inc.
Okay, so the general partner is 12940 GP Inc. Is that like a developer? Who's in charge there right now?
Well, the registered agent would be the legal firm, so we would indicate that the responsible party is the legal department for that firm.
Well, if I'm looking at Sunbiz, you see where it says general partner detail, name and address. It's that company that owns the property. So whoever is listed as the owner of that property is the owner. Okay, let's move on to the actual facts. What exactly was being pumped into the canal?
So, Your Honor, it was like like plaster and dirt from the pool.
And it was being pumped out?
Yes, Your Honor. Yes, Your Honor.
Okay. And does the water reflect a different color substance?
No, that I recall.
Yes,
was anybody,
it actually
was anybody on the site?
Oh, Jose was there. Mr. Ramon was there. I mean, we were all there handling.
No, I mean from the construction people, the owners.
Oh yes, Your Honor. Yes.
Did they say anything?
Not really. I mean, they were just pumping it out, and we observed what was happening, and that's basically what was happening at the moment that we arrived at the property.
How long were you at the property?
How long we were there?
Yeah, how long were you there? Yes.
10 minutes, I guess.
And the whole time you were there for 10 minutes, the pumping was ongoing?
Yes, Your Honor. So basically, we noticed it almost when we were leaving, because we were taking care of some other things, and that's when we
was there other construction going on?
Yes, Your Honor.
Okay, so there's nobody living there.
Yes, there's people living there.
You did not speak with them.
We spoke directly with the people that were doing the construction.
And did they seem to be surprised or to see you, or were they nonchalant about it? What was their reaction when you were there? Did they say, "Okay, I'm sorry, I'll turn it off right away," or did they say, you know, "Mind your own business"? What was their reaction?
Well, the reaction was not direct. It was not from the pumping. Again, we went to address some other things related to the construction, and then we observed that they were pumping the water from the pool to the canal.
Okay, were you allowed in, or did you go through the side, or did you have permission to get there?
Yes, Your Honor.
Okay, all right. I'm going to find that the based on the testimony and the evidence I saw in the photograph and video, and having looked at the applicable section of the code, I will find the property owner guilty. The damage is irreversible and irreparable. The legal dumping has been established by the testimony and the photographs. And so the fine for this violation is $5,000.
Thank you, Your Honor.
Okay. All right. All right. Thank you for that, Magistrate. The next item we're going to call is item number 3. Mr. Igor Nunez.
3 and 4?
3 and 4. Mr. Igor Nunez is the attendee on this case, so I'll go ahead and read this case into 5. It's 13000 Keystone Terrace, LLC. Case number is CEJNK 2024-00001. And item number 4 is 13000 Keystone Terrace, LLC, CEZPU 2024-00009. The officer on this case is Shanna Sanders.
All right. Anybody on behalf of the owner, Igor Nunez?
Igor Nunez
is present?
Yes, he is. He'll be using Director Laz Dusk. Laz, just enable his. There we go.
There we go. Wanted to make sure.
Oh, okay, I'm here.
Igor, if you can do me a favor and please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give and these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Mr. Nunez, based on the records that I've reviewed, you are not only the registered agent, but you happen to also be a manager for 13000 Keystone Terrace, LLC. Is that correct?
Yes, it is correct.
All right. You have been cited for junk construction materials within the property. You've been asked to remove it. You have not. Do you understand the nature of that violation, and are you prepared to immediately make steps to remove the junk?
Sir, I'd like to clarify. So the property, it's in the process of getting new permit for a new construction. I have proof here of the process. This could be approved as soon as next week, which this is what we anticipated. And what they call junk is not junk. I have also pictures here of the wood that we are storing there for construction purpose. I have several pictures here, and none of them, they are junk. I don't know. Are you
okay? So you take issue with the use of the word junk. Let me have the. By the way, if it is a construction site, then I would expect you to have some kind of approved plans and permits for that. Do you have any?
As I was saying, what I have here in my hands, and I'm sorry I couldn't upload anything because for some reason I couldn't do that from my own computer. As a matter of fact, I had to come here to the office in the city hall or the city because I couldn't do that from my computer, and I've been here waiting since 9:30 in the morning. So what I'm trying to say here is that in my hands, I have record of the permit number. I can give it to you if you want.
No, I don't. Unless you have a permit, I'm not interested in a process number. That's not going to help you.
It's a permit number, sir.
Oh, it's a permit. So a permit has been issued for construction?
It's not issued yet, but it's a permit number.
Okay. Is there somebody from the building department that can distinguish between a process number and a permit number?
What is that process number, sir, if you don't mind?
It's not a process number. At least here it says permit number. It's B as in boy, N as in Nancy, R as in Robert, 002023000024.
We can't hear you, Shanna.
Okay. When they come in to apply for a permit, a process number is the same thing as a permit number. Once we issue the permit, it turns into an active permit. So it's the same thing. The process number is actually a permit number that they receive once they pay their upfront fee, and then it go through the review process. So it's the same thing. It's just his permit is not active. So the process,
ma'am, with all due respect, I've been around a while. Okay. A process number does not mean that you have a building permit. Okay.
Correct.
Right.
Correct. What I'm saying is that the number that he's giving you is a process number. It doesn't turn into a permit number until the permit is actually active, is actually issued. So what he's giving you is a process number.
That has been my point since I started this conversation, that he has a process number. Whether the paper says permit number or the man in the moon, it's not a building permit. And because he hasn't filed the plans necessary to be approved for a building permit, correct?
No, that means he actually did submit plans to be reviewed. That's why he has the number.
He made an application for a building permit. He was given a permit. He was given a process number, but his plans have not yet been permitted.
Correct.
Okay.
Magistrate, I put on the screen here the process information. He applied, but it's never been issued or approved. He has several denials on the case on this.
Okay. Okay. And what is expected to be built on that property?
It's a new construction, sir.
Of what? A house, a building?
It's a house. It's going to be a 3-floor house, as you can see there in the
single family home.
Single family home.
Okay, so let's go back and look at what's actually on the property right now. I see a trailer. I see a couple of trailers actually. Obviously, that's not construction equipment, is it?
No, of course not, sir.
Okay, I did see some wood pilings towards the very rear on the right hand side. Okay, yes. What is that going to be construction equipment?
Yes, of course. That's stored there for the for construction, for the shelf of the construction.
Okay, those look like pieces of wood, right?
Yes.
All right. You're not allowed to have trailers on single-family homes, are you?
Well, since the property is fenced, I thought that I could keep them inside. I mean,
code. What do you say about those trailers? Are they legal or not?
Not allowed.
Sorry?
Dana, we can't hear you. You're not muted. I don't think your thing is plugged in. No.
Your Honor, to your question, they would not be allowed.
Yeah.
You can't hear me?
Now I hear you.
Is there any process? Is there any application or something to? I don't think I will even need it because I hope to get the permits, construction permit, as soon as next week. I just had a meeting today in the morning, but in the meantime, is there any application that I can fill out for the trailers to be there?
Sir, Shanna Sanders, Neighborhood Service Inspector, property address presented 13000 Keystone Terrace. I spoke with the property owner, the listed agent, this gentleman, a couple of times when he was originally cited by the weekend officer in my absence. Posted the property. When I came back to work on Monday, it was brought to my attention. As soon as the gentleman received the notice, he did give me a call. We've had a conversation on the phone. At that initial time and another time before, explaining to him that the trailers needed to be removed. At that time of the inspection, he had trailers, RVs, and things of that nature. I explained one trailer is usually allowed with the proper variance. However, he had an RV and I think 3 or 4 additional trailers. So to answer your question, there is an application you can submit for a variance, but not for all 3 or 4 of the trailers there. And because it's a vacant property with construction, possibly pending, I doubt if it's going to be, it would be issued and or approved.
With all due respect, I am the property owner, and I don't recall that we had ever talked. I don't know if you talked to one of my kids but I don't remember.
Someone called me as soon as, because the property was posted on the weekend. They identified themselves as the property owner. I know it was a gentleman. I'm not sure if one of your kids, called and identified themselves as the property owner, but we did have 2 verbal conversations where, as I explained, all of these items needed to be removed. He did state that some of that debris would be used for construction. However, magistrate, I will say, to any point, that wood and stuff looks quite weathered, and at the same time, not that it matters, but I think it does. It's hurricane season. The permit has not been issued at this time. It was actually even just denied again on the 4th of June. So if it was something where, as I thought, that the permit was going to be issued soon and that material will be used, expeditiously, I would say, let's leave it there. However, the permit was applied for in November and still hasn't been issued to this day. So, I would like for that stuff to possibly be removed. And again, those RVs can't be allowed to be there.
Okay. All right. I've heard enough, and what I'm going to do is, and I'll sign an order to that effect. I'm going to give you until the abatement date of August 19th to remove from the site anything that doesn't belong in a construction site. I'm hopeful that you can get your permit issued. Apparently there's some questions about whether there are the necessary approvals or not, or comments that need to be addressed. But whatever doesn't need to be on that site as a and we all know construction sites are not pretty, and there may be some fencing necessary that that may make it look a little nicer. It would help if the fencing was such that it did not show a lot of the construction debris that ultimately will go on there. But what I'm going to do is I'm going to give you until August 19th to work with Inspector Sanders to remove whatever needs to be removed, whether they're trailers, and homes, any motor vehicles that don't have to be there. That wood that you have there in the back, with all due respect to me, that doesn't look like construction equipment or construction wood. To me, construction wood seems a little bit nicer, newer, brighter, yellower. It may be used to, it may be used for some other construction purposes, but it's not the kind of stuff that I would want to see if I'm your next door neighbor, leaning against the window. So I agree with the code and compliance officer based on the photographs and the evidence presented, that there are violations. Proper notice has been given, I find, in favor of the city, and enter an adjudication and set a compliance date of August the 19th for you and the city to come to closure on what needs to go and what can stay. In the event of non-compliance, there shall be a daily fine of $300 until the violation is abated.
All right, sir. Thank you very much.
Please work with the city. They're usually very accommodating. We love to see nice construction. Make sure that the contractor is doing the work that he needs to do, and always maintain communications with the building official and the code officers, so we don't need to hear this case again. Okay?
Will do. Thank you very much.
All right. Have a good day.
You too. Thank you.
Thank you, Magistrate. At this time, we're going to call item number 7 on the agenda. Adela Estrelina Morgan, case number CEBPR 2022-00771. This case was previously found guilty by Magistrate Smith with an abatement date of October 19. Fine was set at $250 plus the $100 cost assessment. The officer on this case is Shanna Sanders. The attendee is Michael Fabiano. Mr. Fabiano, if you can please accept the invitation and enable your audio and video. All right, please enable your video so we can see you.
You going? All right, who's Michael Fabiano? Is that the owner's rep?
Yes. Mr. Fabiano, if you can, okay, there we go. If you can please raise your right hand for me. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Magistrate, are you okay with that? You see him okay?
Well, I see very hard to see his face, but I think it's good enough.
Okay.
Is there some lighting issue there, Mr. Fabiano? Do you have a problem with your computer, your lighting? Can it be made more clear?
Maybe you want to open the blinds a little bit.
Yeah, make it. That may be that makes it worse. I think that's better.
Okay.
All right, that's fine. Let's move on, sir. You're involved with the property in some way. What's your relationship to the property?
Husband.
Sir?
Husband.
He said he's the husband of the property owner, I believe he said.
Okay. You're the husband of Adela Estrelina Morgan.
Yes.
Okay,
yes.
But are you on the title?
I'm not sure. I should be. I'm not sure, but I am the owner as well as of the property.
Okay.
I'm looking, Magistrate.
I found the property owner guilty back in September of last year, and I gave an abatement date of October 19th with a fine of $250. I remember the pictures. If you could pull up the pictures of the windows and the door, I remember that there were new windows, but they were installed without a permit, and I required that you obtain window and door installation permits. Have you complied?
We have a contractor from the old owner. We bought this house. This work was done by the old owner, and we had an agreement with that old owner to complete the work. That was actually part of the sale of the house. He has not done what he's supposed to do. And every time we get a contractor from him that's supposed to go in, they went in, they applied for something. Obviously, they got turned down. So what I was asking the city to do is if I could pull a homeowner builder permit to go ahead and get this resolved on our own, because we've even asked other contractors to take the job, and due to the fact that the installation's already been done, we've been turned down by many contractors saying we don't want to take the work. So
yeah, we don't want somebody else's trouble.
Yeah, so here's what I'm saying. I talked to Mrs. Saunders about possibly pulling a homeowner builder permit, and she said I would need to talk to the I think it's the building chief. And I went ahead and sent them an email last week. I actually went to the city last week and said, hey, can I speak with him so I can get approved for a homeowner builder permit? They said the best way to reach him is by email. I sent him the email and I never got any response back with all my information, with the case, my phone number, and everything on that email.
What would you do as an owner builder, even if you can do it?
Here's what I did last week. Last week, I talked to a guy who I know for 25 years who's an expediter, and he's willing to help us expedite this if we can get a homeowner builder permit to get these windows passed. Because he said it's not a big deal. We just need to move forward.
Oh, everybody agrees you need to move forward, and that's why I thought that back in October, that when I ruled in September, I thought that by October 19th you would get the message. I don't even remember seeing you or your wife at that hearing.
I couldn't log in. I actually was that morning trying to log in. I could not get into that meeting. I even went online and submitted an extension. And I thought it was tabled and we got an extension because I actually submitted it that day because I couldn't get in that morning.
Well, if I entered an order, it was not an extension. Let me just tell you what I'm concerned about. What I'm concerned about is that those windows that were installed by the prior owner may not be compliant with the county's product approval department. They may very well be beautiful windows, but if they're not the right windows for this county, you may need to rip them out and put new ones in. And that whole process is going to take you months. So just getting a permit to do an inspection, to get the county to get an inspector out there for the building department doesn't give me enough comfort that you're going to be able to be in compliance.
Yeah, but there's only one way to know is if I can pull a permit, get that inspection, and then move from there.
Well, if the city's willing to allow it, it's a building issue. It's not a legal issue. Is there someone from the building department that wants to weigh in on whether he can be an owner builder and get an inspection and legalize the windows on the door?
Shawnee, are you there?
Ms. Parsley, could you please chime in?
She might be with a resident.
Inspector Pressy?
I'm back on. Yes, ma'am.
The question was raised by the magistrate as to can a property owner pull an after the fact permit as an owner builder for windows that was already installed?
No, they need a contractor.
There you go. That's what the building official,
Building officer.
The building officer has stated, and I have to take that as the law because I don't have the authority to overrule them. The only way you can overrule the building official is by taking them to the Board of Rules and Appeals in the county, and that's going to cost you a fortune, and you're probably going to lose anyway. So I can't believe that in Miami-Dade County you cannot find a general contractor to file papers with the city to legalize illegally installed windows and doors.
It's been the hardest thing I've had since we've got here. You have no idea. And the old owner, who I'm still in communication with.
I would forget about the old owner. The old owner is, you're never going to hear from them. They did something illegal, okay? And if it was done by a non-licensed contractor, that non-licensed contractor can go to jail. So, and if it's a licensed contractor, he can lose his license for putting up windows without and doors without a permit. That's why they're not going to help you, because they're exposing themselves to more liability. So what you need to do is what the building department suggested is get an engineer, get an architect, get a general contractor, go to the city, file some papers. City will go out, send an inspector. If it was done right, you're home free. If the windows were made in South Korea and they don't meet the county requirements, you're going to have to replace them.
Okay. All right. So where do we go from here then? This way, I'm going to work on getting whoever I possibly can, because I've been waiting on them, and it's like, they call me, they get me excited, they go to the city, they send me a picture of a receipt, and then they disappear. So I just can't wait anymore.
Get somebody competent. Don't think that getting somebody cheap is going to get you legalized. It's going to have to be a certified, bonded, insured general contractor that has done work with the city of North Miami, that knows the process, and it's a matter of a few days. It's just getting somebody filing the paperwork, getting somebody from the city to come in, do an inspection, making sure that the windows and doors are legal.
If I can, Michael, let me ask, because I'm seeing here, who is Glogo's Construction? It shows as though they submitted an application in October, but, they denied it 3 days later and no movement have been made. So, as I directed you and instructed you at the property when I was hand delivering the notice to appear, and when I went back again to take the photos, call them, get them moving, since you say you paid them already.
But here's the deal, that company disappeared. And then a new company, Lee Roofing and Construction, called me, and now they're on the case. I call them up and ask them what's going on. And the old property owner is invested in this as well, because there's over $5,000 sitting in escrow for this matter. So they're invested in this. And I'm just, at this point, I can't wait anymore. I need to fix this because I'm past it already.
Well, I'm past it too, because I'd like my orders to be complied with. So, what's the code, Ms. Sanders? What is your solution? What is your recommendation?
I'll be honest enough to say that I would like the fines to go ahead and move forward. This is a case that I've opened over a year ago. We've given more than enough time. Even before initially opening up the violation, I spoke with the property owner, and we had that same conversation about the previous owner and this, that, whatever have you. I stated to him exactly as you just said. Let's take the old owner out of the equation. It's now your problem. Let's get this situated. Nothing has happened since October when you gave the adjudication. So again, I would like the fines to go ahead and move forward. He's had more than enough time.
They sent me a new guy. They really did. And I love how you guys talk about fines. And right now people can barely survive. I mean, my wife is literally in medical school. She's in her clinicals. Everybody here is working, trying to make a living. And we buy a house with a bunch of legal work that was done that we're invested in now. So it's like, it's easy to find somebody. Now you just try to solve it.
It's also very easy to lay blame on people that are just trying to follow the law. Okay, you have $5,000 in escrow because you knew you were buying a house with violations. Okay, don't try to pull a fast one on me, because I've been in this business longer than you've been alive. Okay, so don't blame us for your problems. You got money in escrow. You go ahead and solve the problem. And I'm going to start finding you. I'm going to start finding you because you did not comply with my order, and you have done nothing since October 19th, which was the abatement date. And you've just been dragging your feet, waiting to get some. Look, I'm done. Okay, I'm done. Please turn off his mic. I'm gonna rule, and this is the way it's gonna be. Based on the testimony of the city's code enforcement officer, testimony that I've heard from the owner of the property, and the photographs and the evidence that has been presented, I find that the property has been out of compliance since the abatement date back in October 19th, 2023. I find in favor of the city and hereby ratify the fines accrued to date, set at $250 plus a $1,000 cost assessment. The fines shall continue to run on a daily basis until there is compliance. And if there is no compliance, we're going to put a lien on the property and take whatever actions are necessary to enforce my order. Yes, ma'am.
Magistrate, you said 1,000 for the cost assessment. Just wanted to.
I'm sorry. No, that's a mistake. It's $100 cost assessment. The fine is $250, which, by the way, it's one of the more lenient fines that I impose. My fines typically are in the 300 to 500, sometimes even as high as 1,000. So I treated you fairly from the beginning. I treated you in a very respectful and try to be helpful. And all I hear is blame the city. Blame the city. Yes, times are tough, and I do wish your wife well, and I wish you all success. But we are obligated in this town, in this city, to follow the law. Everybody follows the law. So next time, understand that we're not responsible for the problems that you decided to put yourself in. Thank you. Next one.
All right, Magistrate. Next item I'm going to call is item number 9. This is Ariel Matan Goldberg. Case number is CED RP 2024-00001. The officer on this case is Shanna Sanders, and we have Alex Lima, the attendee on this case. And let me invite her in. Axel, sorry, I said Alex, but it's Axel Lima. If you can please enable your audio and video. Thank you, Axel. Are you an attorney?
I'm not Axel. I'm Ariel Goldberg. I'm the
okay.
owner.
You're the owner. All right.
Axel is my tenant.
Sure. Can you please raise your right hand?
Yeah.
Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you, Officer Shanna's on the case, Magistrate.
Okay, let me, first of all, sir, you say you're the owner?
I'm the owner of the house. Axel should be on the call as well.
All right.
He's my
yes,
tenant.
I see him. I see him.
Who is Ariel Matan Goldberg?
That's me. But I'm renting the house currently to Axel. He's my tenant.
Okay.
Okay, so you're Ariel.
Correct.
And you're the owner, and you are leasing the property to who?
To Axel.
To Axel?
Axel, yeah, he's on the call as well.
Axel Lima. So the name Axel Lima there is actually not your name. That's the tenant's name.
I guess I don't know. Yeah, I guess I joined with the same link as he did, so that's why it says my name.
Okay,
But
I guess I see.
I changed
it,
Magistrate, just so there's no
I see the other gentleman with a beard, right? Well, you both have beards.
I changed the name, Magistrate.
Okay, all right. So now we got everybody right. Okay,
Let me swear in Axel.
Okay.
Axel, if you can please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
And Ariel Goldberg has been sworn in already as the property owner.
Yes.
Okay, so guys, you've been cited for attempting or renting your dock space, some advertisements to rent the space to boaters. Is that, do you understand that to be the allegation?
Yes, I understand, but they here in the paper says that they are signs on the dock that we are renting, and we don't rent the dock because the boat is mine, and also the jet skis are mine. And I don't know where they say that it's a sign saying that we are renting the docks.
Because I believe they found something in the internet advertising your dock for rental. Is there something that the city wants to show me? What is that? What is that? Somebody from the city. Who's the inspector here?
Shanna Sanders.
Shanna Sanders.
Yes,
Can you explain what is being shown on the screen right now?
Shanna Sanders, City of North Miami, Neighborhood Service Inspector. What's being cited, there's two different websites that an advertisement was listed for charter boat rentals. I spoke with, I believe, I think it was the property owner at a time, or maybe it was a tenant, I'm not sure. But I spoke with a gentleman, as well as a woman about this property, who stated that at that time it was some rentals going on. They stated that they would remove the website from the they would remove the advertisement from the website. However, the advertisement has been removed, but from what I'm understanding through the residents and from Marine Patrol, that the charter boats are still taking place and that the boats still remain off and on at the property. I apologize. I did have the officer from Marine Patrol on who wanted to give testimony about this case, but this is his Friday, so he was leaving for the day. But from what's been said to me, that he has been renting out the dock space to different individuals. One of the boats that's parked there does not belong to the owner or the tenant, and that is continuing to happen.
All right, let's put this case in context. Okay. Number one, the violation that is being cited is for the advertisements. Okay. Advertising to rent the dock space. I see nothing in the description of the charges talking about illegal charters. And the fact that one of the boats may or may not be theirs doesn't meet the clear and convincing evidence burden that I have to follow. But I'm going to inquire further, and I have not made up my mind. I want to hear from everybody. Either the owner or the tenant. Yes, ma'am.
Yeah, I want to say something, if I may. I think first of all, I'm the owner. I rented my property to Excel, so it's a 1-year lease. I did put in the lease no rental, no using commercial uses for the dock, but this advertising is for somebody else. You can see the address is not correct. It's 12910, where we are 12951. So this is not Axel. I believe, again, I will let Axel talk, but I feel like most of the stuff you see there,
I was going to say the same.
One person at a time. One person. Sorry. Ariel, I just want to hear from you right now. But you're the witness.
So again, I never rented the dock. I rented the full house to Excel. I have a 1-year lease with him. In the lease, I did put no usage for commercial for the dock, or no doing boat rentals, because I knew he has a boat, and I knew he does boat rentals, but he's using Duffy's dock to pick up and drop off clients. So this is what I know. I got the notifications from Axel last week telling me, hey, we got this letter. I didn't have enough time to. I know he sent the documents. He told me. My mailing address, by the way, is different than my home address. I'm currently living in Puerto Rico. I just want to mention it there. That if there is a future problems, I would like to get the letters to my mailing address and not to my home address. But yeah, I'm gonna let Excel talk from here and kind of like defend himself, because this is not really my case.
Well, it is your case because you're the owner of the property, and notwithstanding what is on the lease, whatever you write on the lease, doesn't matter. Ultimately, you're the owner, you're responsible. If you find out that the tenant is violating your lease by engaging in chartering or water sports or commercial activities, charging people to go fishing or whatever it is, it's your responsibility to go to court and stop it. And I'm going to caution both of you, while I have you both, that I am very strict with chartering activities out of residential neighborhoods because they disturb the peace and tranquility of neighborhoods. It is something that is now becoming very prevalent, particularly in waterfront communities where these boats are, and I know what they do. They charge a fee. They take you to Hollover. You go fishing. You have a party out in the sea somewhere. You come back in the afternoon. We've seen some cases where people actually bring luggage with them. That's how bad it's getting. And it may be that they stay overnight. So I'm not saying that any of this is happening here. I'm just cautioning you that if it is happening and you are cited again, I'm gonna fine you like the maximum amount that I'm allowed to fine.
So I absolutely agree with you, and I would appreciate next time if you guys can send the letters to my mailing address and not my property address, just because I do not receive mail there. I mean, Axel did receive the mail, and he gave me about the heads up was after June 17, where I could reply. It was like last week over a voice memo. So I would appreciate if you guys can send it to the 53 Calle Palomeras, Suite 601. This is where I receive all my mail.
Well, I would also encourage you to write to the city, instead of just saying it now, saying that going forward, anything having to do with this property, please send me the notification, or you can when you do your
in here it says my mailing address. You can see it over there, office the property appraiser. This is my mailing address. It's right there. I changed it because I wanted to get all my bills and everything from the city to that address. So I would appreciate getting the
Magistrate. Yes. Just for the record, to Ariel, we pull the property appraisal for every case, and a letter is also sent to the property appraisal mailing address as well as to the property that the violation is at. So it's mailed to the property registered on property appraisal as well left on your actual property.
I've never received on the other mailing address. I've never received it.
Okay.
Well, anyway, let's move on. Let me ask Axel if he had anything to do with that advertising that was posted on the internet.
No, I was going to tell that about that. It's not my company. It's not my link. I don't know who are that persons. Sometimes they are like brokers that they rent boats, but they don't ask me nothing for put my boat in that page or something like that. I want to talk with Ari here that he also, when he rented me the house, he asked me what I was doing for work. And I told you that I rent boats and I do all this, but I do this business like 3 years ago from zero. And I know how it works. I learned a lot for start doing it because I don't want to, I came from Argentina and I don't want to lose my money. And I was 5 years working a lot with affairs for permit, sorry that I don't talk really good in English, to do all the papers and to do all good for stay here, and I'm not going to do nothing bad for the America get angry with me and take me over here. I know that I can't do charters here, I can't take people from here, I can't rent dogs, the boat is mine, the jet skis are mine. When I work with this, I take it from Duffy's, all the people. I used to have another house in the 79 in Norway Village. and I take the people from chokers because I learn about this business and I build it from zero. I'm not going to do nothing bad for do bad things in America.
Well, you know, people. You mentioned 79th Street, the Pelican House there. A lot of people rent jet skis and other equipment from there. Okay, so there's nothing wrong with you if you have a boat at Pelican Harbor and somebody calls you to go pick them up at a certain place. I don't believe there's anything wrong with that. But if you're doing it out of that house, you're doing it out of that dock, then you're in violation and you're going to be cited. So do you own one or more boats?
No, I have only one of my 2 jet skis, but I don't rent the jet skis. They are private for me.
You don't rent the jet skis. You have what?
Jet skis. Shed boats.
Wave
in the picture, you have the two
okay.
jet skis.
All right. So you have one boat?
Yes, the gray one that is in the picture.
And you're a tenant. You got a 1-year lease, and you're keeping it at that particular dock.
Yes.
Okay. I caution you that the North Miami Beach Patrol, Marine Patrol, and others are looking. Your neighbors are looking.
Yeah, I know.
The evidence of illegal charters out of that house that comes to me is going to be fined at the highest level that I can find. So I am Ms. Sanders.
Yes.
What is your recommendation?
For this one, I have no recommendation. This was called into me through a complaint, as usual in Keystone and San Francisco. The property owner is stating that it's not his advertisement. The boat belongs to him. With this one, I want to ask before I close out. I don't even really say, because I see that someone uploaded some documentation about Milk Tour USA. Is that your company, or is that because I'm seeing an ad, to go to piggyback on both violations, whereas I cited about the boat rental and about obtaining a business tax receipt. Some email was sent to me and information was loaded stating that there is a company there. They stated that they have licensure, but what they have is with the county. So who is Milk Tour USA?
Milk Tour USA is the company of my father. It's the company that is the registered at the boat. Also, my father also live with me. We are the two on the agreement, but now he's in Argentina. He's coming back now on 10th of July in a few days.
So
Ms. Sanders, are you referring to the next violation?
Yeah, yes, I'm referring to the next one, but I'm questioning only because he's saying for him to submit information and documentation saying he does have a company. However, in this one, he's stating that, the boat belonged to him. He's, doesn't rent it out, things of that nature. So I just, they're different violations, but it seems as though it's contradictory information. So I just want to make sure that I'm understanding this correctly.
Well, I want to make sure also, because you can't get a business tax receipt to operate a charter business out of a single family home. So you're asking him to do the impossible.
I am asking him to do the impossible because he was adamant, again, that whoever I spoke with, whether it was him or his father. I mean, this is the first time I think I'm speaking with the property owner, but when they stated that they had a business, and, they said they had documentation, things of that nature, I asked them to give it to me, at that time. They didn't, again, we were on the phone. I wanted to do it kind of as a double-edged catch as to, if you are doing it, let's do it with the proper approval. If you're not, let's get these boats removed and, stop doing the rental. So I kind of, did, both as a catch-all. So for either way.
All right. You can't get the boats removed because the boats belong to, the boat belongs to Axel, and he owns it and he's got a right to put it there. What he does not have the right to do is to use it for commercial purposes. and even you can't make him get a BTR because that would be an illegal use. So all I can say, guys, is that the use of that dock for any commercial purposes, the use of that house for any commercial purposes, whether it's boats, jet skis, skateboards, whatever it is, not legal, okay? And so I'm not convinced that that advertisement came from the owner anyway, and I don't believe that that they're doing illegal charters based on the testimony that I'm seeing. If the neighbors want to come in and testify, if the police officer, the Marine Patrol people want to come in and testify that they've observed people engaging in chartering, I'll be happy to reconsider this. But based on the testimony that I've heard and the burden of proof being on the part of the city, and it's clear and convincing, I am not going to find them guilty. But I do caution them to be careful because we're going to be watching you, okay? And you never know what neighbor has videos of you guys engaging in illegal stuff. Yes, Axel.
Yeah, I know who is the neighbor because I see him taking me pictures some days, a few days. And one day I finish with my family and I say I go to talk with him. I go with my girlfriend. And I touch the door and I say, hey, hi, I'm from the boat that you were taking the picture. He said, no, this is private property, but I want to like talk and explain and see why it bothers you that I pass with my boat. And it finished bad because he take a gun and say me, this is private property. I get out of fear. I come to my house. I call the police for do a report because it was like not more in Argentina. Don't pass that like people take out a gun and show you and say, get out of here. When I call the police tell me that he can do that. If you to touch his door,
right. Listen, if you follow the law and you do what I tell you, you're not going to be in trouble. We're not going to deport you to Argentina, okay?
Oh.
Don't worry. You know, we're not doing any of that. Even
I work a lot for me here because really like the United States.
Even if I could, okay, that's not something you should worry about. Just do your business and stay out of trouble. And I saw a hand. Somebody raised a hand. Somebody else.
Yeah, sorry, it's mine.
No, it was
actually me.
Yes.
Oh,
Karen
it's you, Karen.
I'm still here this whole time.
Karen, give me a moment. Magistrate, I did not call item number 10 into record. Can I do that so you can rule on both at the same time?
Yeah, I'm going to rule on both. By the way, Karen, are you also going to speak on this?
Yes, if I can, please. I registered.
Okay, so all right.
All right, so let me call it.
Call number 10, and then I'm going to call on Karen.
All right. Item number 10, Ariel Matten Goldberg, CEFOB 2024-00075. Do I need to swear in Miss Karen again for the third time?
If it's a different case, absolutely.
Yes. Miss Karen, do you solemnly swear and affirm the testimony you're about to give for these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay, ma'am. You've heard everything. So what?
Real fast.
What do you want to add?
I want to add that to Axel. Axel, it's very confusing for all the neighbors on the waterways to necessarily know where a boat is coming from with the charters. The neighbors are basically asking that we keep this a single-family neighborhood. I'm very sorry that somebody pulled a gun on you. That embarrasses me. It scares me. Not the way we want to operate, but please know it's many neighbors that are complaining about charters, not just one. And we use the city because we don't want those type of interactions. So I volunteer myself to you. You can find all the information you need about how to reach me on KeystonePoint.net. If you have some type of problems or questions that you don't know who to ask in the city, I'm happy to help.
That's a very helpful comment. I know of many homeowners associations that have websites. If you would invite them to become, what do you call it, members, or link into your, you know, send them a link, invite them in, And I'm sure that you, like other homeowners associations, have newsletters, and people post their concerns and pictures and information. Some of it sometimes gets a little testy and a little profane, but that's today's world.
Not ours. We won't do that. But I put it in the I put the website in the chat. It's free to sign up for emails, and obviously, if you can make a contribution, we appreciate it. We're just trying to have a nice single family safe neighborhood. So thank you everybody for that.
I would hope both the owner and the tenant take advantage of that and participate in making obviously the owner has a vested interest in making sure that the neighborhood succeeds and becomes a high-end neighborhood, which I know it is. Have a lot of friends there. I go there often. And so I would like to see everybody get along with everybody else. So with that said, I will dismiss both cases, but cautioning both of you to be careful going forward.
Thank you so much, Your Honor. Thank you, Karen, and thank you everyone for this
really
call.
Thank you for all, and happy 4th of July.
Happy 4th of July. Thanks, guys.
Next.
All right. Next item on this case is item number 22, Holy House Partners, LLC, CEMHS 2023-00659. The officer on this case is Shanna Sanders, and the attendee will be Carlos Cespedes.
Okay. Just how many more cases do we have, Madam Clerk?
We have a couple, Magistrate. I haven't counted, but we have one more attendee, and then after that, from there, well, two more attendees, and then that's it.
Okay, so I just want to announce after this one, we're going to take a 5-minute break because I've been at this now for many hours, and yes. We need a bathroom break, and we need a drink of water, and maybe eat something, and maybe take some emergency call.
You got it.
After this one, we'll do a 5-minute recess.
Okay. All right, Mr. Carlos, if you can please enable your audio and video for us. Oh, all right, Carlos, if you can, yes. Can you raise your right hand for me, please?
Yes.
Yeah, there we go. All right. Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say, I do.
I do.
Perfect. Do you need a translator, Mr. Carlos?
I speak English good. It's better. I don't think so because it's not big deal, you know. Okay.
Okay.
If he has a problem with the translation, I can help him with the need.
Yeah, thank you.
Yeah, and we'll use the interpreter, but the magistrate is fluent in Spanish also. So if every once in a while you say a word in Spanish, I will know what you said. Okay.
Okay. Thank you.
Okay. How are you involved with Holy House Partners? What is your relationship to the owner?
Yeah, the property manager.
You're the property manager. Okay.
Yes.
And what is Holy House Partners? Is that a residential building?
It's a residential building, right.
How many units there?
57.
Okay. How long have you been the property manager?
Since the new owner bought that one in December 29 of the last year. Yes, 6 months.
Okay. So you're aware, of course, that there has been a citation for cracks throughout the building, and we can see them in the pictures from Shana Sanders. You see all the cracks?
Yes.
Okay. So how much time do you need to fix that?
I sent to one company to check to ask for the permit because there are a miscommunication because in the property address stay the same because the owners bought the building with the name also. There's no warranty deed, and the property appraiser remain the same address, and I sent to the all owners all communication. But you go to the Holy House Partners, the Zambis, there are updated address there, the mailing address and the owner address, the new owner address. But now I already spoke with the MVP permits company, and they will handle the permits. And they told me that need a survey. I already spoke with the survey company in order to make a survey and submit the plans with all the information that need for get a permit, and after that do the job.
My question, sir, with all due respect, was how much time do you need?
Well, I think is for the permit need, I don't know how much delay that one, because we will do ready for submit the permit in 2 weeks or 3 weeks, and for make the job, I don't know how much need the contractor for do that one.
You have a contractor already in place?
No, not yet. First, we need to
so do you have a contract with an architect?
Yes, I will have. Yes, I have.
No, do you now have a contractor with an engineer, with a contract with an architect?
No, now. But I can get an easy one contractor.
Okay. Well, have you done construction before?
No.
I don't mean in this property, but in general. In other properties?
No. Construction, no other purpose, no.
Well, you got to fix these cracks, right?
Yes, but that cracks, I don't see that cracks. We bought the building without that cracks. There are.
What are those things?
That these things, for example, I don't see so. I saw several cracks, but small cracks, not that big cracks. No, that one was covered for sell the building, probably.
So you're not seeing those pictures?
Yes, I see in the picture, yes.
All right, so nobody faked these pictures. These pictures are real. Okay, you got a lot of issues there, a lot of cracks, and a lot of work that needs to be done. Otherwise, your 57 unit owners there are going to be. Is it a condo or is it a rental?
I say the apartment.
Okay, well, your owner is going to be spending a lot of money there if he doesn't. He's going to be fined a lot of money if he doesn't fix that. You see those pictures? That's not acceptable.
Yeah, for sure. But that picture, the property don't looks in that way now.
Why? You painted it?
No, we don't paint it, but we bought but that picture maybe.
That picture was taken 15 days ago.
Oh, okay. If that 15 days ago, but I need to check carefully that one because I don't see so. But I will check and we'll take care.
Okay, this is what I'm going to do, sir. And listen to me very clearly, because if you don't do what I say, I am going to issue fines, and your boss, the owner of the property, is going to have to pay huge fines if they don't spend the money to fix these cracks. Okay. I am going to give you until September 16th.
Okay.
That's all of July, all of August, and half of September.
Okay.
To fix the cracks. It doesn't take 3 months to get permits and to get a contractor to fix the cracks.
Okay.
If you do not fix the cracks and correct those violations by September the 16th, I'm going to issue you a fine of $500 a day. Okay? All right. So to repeat, for purposes of issuing my order, based on the testimony of the city's code compliance officer, the photographs, and the evidence presented, showing that the violations still exist as of 15 days ago, proper notice has been given. The property manager has appeared in front of me. I find in favor of the city, enter an adjudication, and set a compliance date of September 16th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Sir, do not wait. Trust me. Do not wait until the day before to file your permit.
Okay.
Okay.
No.
You file the plans and for the permit next week.
Yes.
So that there's enough time between now and September for you to get the permits and hire a contractor.
Yes.
So I'm giving you plenty of time. Don't come to me later saying, I'm sorry, I couldn't do it on time. You got plenty of time. Okay? Next case.
Okay, thank you.
You want to do next case, Magistrate, or you want to take
we're going to take a 10-minute recess.
All right.
10-minute recess. It's 3:10. We'll see you at 3:20.
You got it.
Okay.
Recording stopped. Recording in progress.
All right, guys, we're ready to go. Ready?
Yes. The next case I'm going to call is item number 46. It's TNT Marine Center Ltd. Huh? Never mind. My microphone is off. You guys can't hear me?
We hear you.
Little louder.
Long day. It's a long day. Sorry about that. All right. TNT Marine Center Ltd. FYBRR 2022-00048. The officer on this case is Shawnee Pressey. We do have Mr.
Yes.
Chuck Fortin. Chuck Fortin. If you can please enable your audio and video. Chuck, please accept the invitation and enable your video and audio.
Really? No.
Xavier, go up real quick. Let me hit the middle.
Chuck, if you can please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say, I do.
I do.
Thank you.
Mr. Fortin, please restate your name, address, and your relationship to the property.
Chuck Fortin, 1940 Northeast 135th Street. I'm the general manager for TNT Marine Center.
Okay, so apparently there's a building at 13301 Biscayne Boulevard, and the 40 or 10-year building recertification is due. Is that your understanding?
Yes, sir, it is. These seawall and electrical inspections, apparently prior management dropped the ball. We were unaware of this situation until I received the notices that were sent out in June. Since then, we have contracted with Edgewater Resources, an engineering firm, to perform those certifications. I do not have a date as to when that's going to be completed.
Okay, so basically you're saying the seawall needs repairs and the rest of the building seems to be in good shape?
As far as I know, I have not seen any history on it for the rest of the inspections. But according to the notice we were sent, and after reviewing it with the engineers. What we need to do is a seawall inspection, which is underwater cameras, possibly divers, to inspect the entire length of the seawall on the property, and the electrical systems were never done.
All right, whatever work needs to be done, you still need to do a 40-year recertification report, and the report may cite to the deficiencies that you're talking about. But have you filed a 40-year recertification report yet?
No, sir, we have not. And as I understood, that was the violation, was that 40-year for the seawall and the electrical have not been completed. And that is why we're having this discussion today. Apparently they did some of the buildings, but that part wasn't, those two inspection certifications.
Okay. Maybe I misunderstand the process, and perhaps building can assist me. It's two separate processes. There's the filing of the report, which may contain some deficiencies, and then you got to correct the deficiencies.
Correct.
Right? So they have not, according to Inspector Pressy, they have not filed anything with the city. Is that correct?
That's correct.
Okay, you understand that, Mr. Fortin? That even if you have issues with your seawall, you still have to file a recertification report.
Correct, and that's what we've contracted with Edgewater Group to do, is the inspection and the recertification.
Okay.
Whatever deficiencies are found, we'll move forward from there.
Knowing, and by the way, is it what kind of use is your building? Is it a marine recreation building, or is it boat storage? What is it?
We're a marina, a waterfront marina here in Keystone. We do dry storage. We do repairs. We have a fuel dock.
All right. Let me just try to simplify matters. Let's not get overly complicated. The county requires that there be a 40-year recertification report. Okay? That should be relatively easy to do. And I'm gonna give you plenty of time to do it. I'm gonna give you until September 16th to get your report in. Okay? After that, there will be fines if you don't file the report. Once you file the report, there may be some seawall issues or electrical issues that come up. I will give you more time to fix those things, but you first have to file your recertification report. I'm going to give you until September 16th to do that. Okay, that's really not a difficult job to do. You need an architect, or you need an engineer with experience in the type of structure that you have. You hire them, they do all the necessary inspections, they file the report, and they may say, seawall is defective, it needs this or that, or the electrical has this problem, or there's a structural issue with this column. That comes later. We'll fix that later, but we need the report. The actual report needs to be filed. So, based on the testimony of the city's code compliance officer, the photograph and the evidence presented depicting that the cited violation for the 40-year recertification still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of September 16, 2024. In the event that there is non-compliance by that date, there will be a daily fine of $350 until the violation is abated. So you need to go to work, sir.
Understood.
Okay. Next case.
Next item we're going to call is item number 43, Rashid A. Tahir and W. Salim, FYBRR 2022-00017. The officer on this case is Shani Pressy. Mr. Rahid, if you can please enable your audio and video for us.
Hello.
Yes, Mr. Rahid.
Can you hear me?
We can hear you. May you please raise your right hand?
Raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
Sir, you own the property at 1025 Northeast 126th Street?
Yes, sir.
Okay. Do you know what the violation is about?
Yes, I know now.
Yes, you know now, meaning like you just found out yesterday, or you found out?
Your Honor, one thing I have to explain to you. My name is Rashid Tahir, with the wife Salim.
Sorry, sir, you're breaking up. I'm having trouble hearing you.
Okay. My name Rashid Tahir and wife Salim.
Okay, sir, how much time do you need to do your 40-year recertification?
Your Honor, I have to explain to something, but it's okay. I'm very depressed. You give me October. You're giving everybody September. I need October 15. It's okay. I will be very happy. That's it.
Okay, I'm going to give you, like I did with the other gentleman, I'm going to give you until September 16th to get your report filed with the city. Based on the testimony of the city's code officer, the evidence presented, depicting that the cited violation exists, proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of September 16th, 2024. The event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
September 16th, right?
September 16th, yes, sir.
All right, thank you very much, sir.
Okay.
All right, the next items we're about to call magistrate are, this is a long one, magistrate. It's item number, one second, let me remove Mr. Okay, he's gone. It's item number 36 through item number 42. So I will read each case into the record. Item number 46 is Northeast Palm Condo Association, case number MHVIO 2023.
Did you say 46 or 36?
36 through 42.
Okay. Okay. Read them all, and we'll take them all together since they all relate to one another.
Correct. Yes. All right, so item number 36, Northeast Palm Condo Association, case number MHVIO 2023-01073. Item number 37, Northeast Palm Condo Association, MHVIO 2023-01074. Item number 38, Northeast Palm Condo Association, MHVIO 2023-01075. Item number 39, Northeast Palm Condo Association, case number MHVIO 2023-01076. Item number 40, Northeast Palm Condo Association, case number MHVIO 2023-01077. Item number 41, Northeast Palm Condo Association, MHVIO 2023-01078. And item number 42, Northeast Palm Condo Association, case number MHVIO 2023-01079. The officer on this case is Brentley Daniel, and we also have the attendee, Megan Perez. Megan, if you can please enable your audio and video for me, please.
Where is Ms. Perez?
She's here. We're just waiting for her to enable her video. Thank you, Megan. Megan, you're not an attorney, are you?
No, I'm the CAM for the property.
All right. May you please raise your right hand for me? Do you solemnly swear and affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Thank you.
You're welcome.
Okay, good afternoon, Ms. Perez. You say you're the CAM. I assume that you're the property manager
I am, yes.
for Northeast Palms Condo Association, correct?
Yes, correct.
How many units in that association?
There are 14 units in total.
How can 14 units accumulate so many violations?
Well, they're actually violations that, for the most part, we have started to correct. There's furniture on balconies. I've been in contact with Inspector Daniel. We've been in communication about all of this. This has actually been turned over from other owners to an investor buyer who's buying up the properties little by little, and so we are bringing everything into compliance as we go.
Okay, the first issue is the outdoor storage on balconies.
Sure.
That has to go, right?
Yes, so we've sent out notices to our residents. We let them know, and I've informed Inspector Daniel as well. The last notice went out last week and kind of instilled a little bit of fear, and told them, hey guys, everybody's got to remove all storage off of the balconies before the city comes to do re-inspections again. Some of those pictures are, they might be a little bit older, I'm not sure. And some of those issues have already been tackled.
Are those balconies common areas, or are they individually owned?
They're limited common areas, so they are the responsibility of the association. At least, the tenants have to abide by the rules and regulations. Okay, so they're used by the individual unit owners, but they're nonetheless they're owned by the association. So it's the association's responsibility. So correct.
You need to get that done right away. Whatever means you have to force unit owners to comply, including including fines and court actions and liens and whatever else you can do. So how long you need to get compliance on the storage?
If you could give me till the August meeting on that one, that would be more than enough time. I also have, I understand that Ms. Telon, the clerk, read in all the violations. So we also have the certificate of use and the BTR that we're working on. For some reason, this property had a DERM requirement. So the application wasn't as easy as ones I've done in North Miami in the past. But that's been already submitted. The office should see a...
That case is not on file, ma'am.
Oh, I'm sorry. I'm sorry.
So.
Well, there is a certificate of use in item 40, and in item 39 there's a BTR issue, right?
Do you want to go into order, Magistrate, or you want to?
I'm going to take all of this together because I'm going to require them to do it all by the same time. We don't want different dates, things. I just want to understand. On the outdoor storage, you said until I don't have a meeting in August. I have a meeting in September 4th. So for all of these violations, I'm gonna set what I'm gonna do is I'm gonna get a compliance date of August 19th with my meeting to be held on September 4th. Some of these violations may be moved by then. Some of them may require a little bit more time, and I'll be lenient with you if you're moving along quickly. So the next issue is the sliding door screens. They need to be replaced throughout the entire building. That may take a little bit longer, but how long do you think that'll take?
Well, right now I'm trying to figure out with the board, since we have the structural integrity reserve studies and those numbers are coming out, and that includes the windows. I'm having a communication with the attorney of the association to see if that mandates us to change the windows as an association expense when normally the documents state that it's an owner expense. But that should happen quickly. At some point this month, they're going to decide whether or not they're going to change out all the windows. As for the screens, there is a violation that says that the windows should have screens also, but the windows actually open out. And because they're old, we're having an issue with some of them fully opening, and I don't want to add any more, work done on those windows that could cause possible leaks if we're going to change them soon. So I know that's a lot of information, but that's where we are.
Well, you're discussing an issue that is above my pay grade. I think you need to talk to the building official, the building department, as to what to do with windows that open out, and whether there's a requirement or not to put screens on them. I don't know, but I'm going to give you a little extra time actually to resolve all of it. See if you can resolve all or most of it. I'm going to give you a little extra time. So I understand the sliding door screens and doors. Let's talk about window screens. Same issue, right? Window screens. Yep. And business tax receipt. Is there any reason you don't have it?
No, so it requires a certificate of use to be processed first. I do have stamped documents, which I sent over to Inspector Daniel from the city. I've done this before for another condominium. They accepted it there and got it initiated. For some reason, this property required me to go through DERM approval, so I had to do some stuff online, which has already been completed. I actually have the paperwork in front of me if you want me to show you the stamp from the city of North Miami. And I believe, Inspector, I sent that to you. If I didn't, I certainly will.
Yes, ma'am.
Okay.
All right. Inspector Daniel,
yes, Your Honor.
I think the desire is there for the corrections to be made.
Of course.
Any thoughts? I was going to give them until September 16th to get everything done.
I'm in favor of that, Your Honor. Myself and the property manager have been in close contact with each other, even with the last building that she also manages as well. Any issue that I've brought to her attention, she's always made effort in trying to come into compliance.
All right, I'm going to adjudicate violations on all of them that we've discussed, beginning with 36, 37, 38, 39, 40, and 41. And I'm going
42.
And 42?
Yes.
I missed 42. The orders will essentially be the same. That's why I wanted to do them all together. Based on the testimony of the city's code compliance officer, photographs and the evidence presented depicting that the cited violations still exist, having heard from the owner's rep, and the property, a proper notice having been given, I find in favor of the city enter an adjudication. And as to all the violations, I set a compliance date of September 16th. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Thank you, ma'am.
Thank you very much.
Keep in touch with the inspector, okay?
Will do. Thank you very much.
Let him know what's going on.
Yes, yes. Thank you all.
Right.
Sorry, the interpreter is dismissed.
Yes, interpreters, you may be dismissed. Thank you very much.
All right, what do we got left?
All right, Magistrate, let's go from the beginning. Item number 5, 1530 Northeast 130 Street, Inc. Case number CELDR 2022-00019, previously found guilty by Magistrate Smith with an abatement date of September 21, 2023, fine set at $1,000 plus the $100 cost assessment. The officer on this case is Shanna Sanders.
Anybody on behalf of the owner?
No other attendees are here.
Okay, well, I remember this one well, and I remember how upsetting it is for these violations to go on forever, and then when they're called before me, they don't show up. So I found them guilty on July my gosh, almost a year ago, and we're still here, and they're not even appearing. I noticed that there are two people listed in Sunbiz, a Francis Jacob and a Jacob Ney. Somebody's got to wake them up, send them some really nasty letters. My orders would be helpful. I've looked at the photographs. Has there been any improvements, any corrections?
Well, you're muted. We can't hear you.
Officer Murillo, is that your case?
No, that's Officer Shanna Sanders.
Miss Sanders?
Yes, she's having trouble with her microphone a little bit. I don't know what's going on up there. No.
Which case again are we in?
This is number 5. No, Shanna.
Okay. Yeah.
Oh my goodness.
Now we hear you.
Okay.
Shanna?
Okay, I'm here. I don't know. I'm having a problem with my microphone.
Miss Sanders, any change?
Not necessarily. They did submit an application back in October. I'm showing here October 2023 for the driveway. It's been denied on 4 or 5 different occasions by all the disciplines, and they're asking for the exact same thing. So I would say yes and no. Nothing has happened with the application since it's been submitted.
But the pictures that you're showing me are depict the same condition that existed months ago, almost a year ago, when I first found them guilty. Nothing has changed. They haven't done any corrective work.
They haven't done any corrective work. The only thing they've done was remove those rugs. They had rugs and little carpet remnants out there that they were parking on. And now it just looks, it's depicted in the picture now. But anything other than that, no. The violation still remains.
It looks like a pigsty to me, so it still remains the same.
It still remains the same.
Based on the unrebutted testimony. No, this is a ratification, right?
Yes,
that's
it is.
Correct.
Based on the unrebutted testimony of the city's code enforcement officer, the photographs and the evidence presented, depicting that the property has been out of compliance since the abatement date of September 21, 2023, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $1,000 and assess costs in the amount of $100. The fines shall continue to run on a daily basis until there is compliance, and I think that a lien should definitely be placed on the property, and they should be notified immediately that a lien has been placed on the property.
Got it. All right. Item number 6, 1595 Northeast 123 Street, LLC. Case number CEZ-CU 2021-00165. Previously found guilty by Magistrate Smith with an abatement date of April 17, 2024. Fine was set at $250 plus the $100 cost assessment. The officer on this case is Jonathan Lemestre.
Mr. Lemestre, I'm familiar with the case. It's hard to believe that Valero has not responded. I don't know what the issue is with the certificate of use. Do you know whether there's any activity going on? Have they filed anything?
So I actually spoke to the Development Services Department about a week ago, and there is no application on file with Valero at 1595 Northeast 123rd Street. I've spoken to the clerk. I've given my business card to them, provided them with the notice to appear. We mailed out the notice to appear. Nothing.
Okay. Well, I don't like it when they don't appeal, when they don't appear before me. These are not your new kids on the block. They're, pretty big entity. They know what to do. They know how to do it. They have great lawyers. So I'm going to ratify the fine. And if they're not happy, they can go and get mitigation somewhere else.
Yes,
based on the unrebutted testimony of the city's code enforcement officer, the photographs and the evidence presented showing that the property has been out of compliance since April 17, 2024, I find in favor of the city, hereby ratify the fines accrued today in the amount of $250 plus a $100 cost assessment. The fines shall continue to run on a daily basis until there is compliance.
All right. Item number 8, Andy Perdelis, case number CEMHS 2023-00821, previously found guilty by Magistrate Smith with an abatement date of March 20 of 2024. Fine was set at $350 plus the $100 cost assessment. The officer on this case is Shanna Sanders.
Ms. Sanders, this is should have been a relatively simple case where they just need to put an ID placard on the property with emergency information. Nothing. Have they done anything?
They haven't done anything at all. No. It's even worse. The property is even worse condition now. But nothing.
Okay. All right. Based on the unrebutted testimony of the city's code enforcement officer, the evidence presented showing that the property has been out of compliance since March 20th, 2024. I find in favor of the city, hereby ratify the fines accrued today in the amount of $350 plus a $100 cost assessment. The fine shall continue to run on a daily basis until there is compliance, and I authorize the entry of a lien. Go ahead and file a lien against the property, please.
All right. Item number 13. Bedoma Plaza LLC. Case number is FYBRR 2014-00049. Previously found guilty by Magistrate.
Yeah, who is the AM Magistrate? I didn't know you had AMB. That's obviously a typo. Which magistrate?
It definitely is a typo. So let me check that for you.
Which magistrate did that?
I'll let you know 1 second. As I read it, I said, wait, we don't have a magistrate.
Maybe there is no magistrate. Well, I guess there is. If there's a finding of guilt, somebody must have done it.
Somebody found him guilty.
And I try to look for the order, and I don't think it's in the file. Yes, as a matter of fact, I did make a note on my agenda that the order is not in the file.
It's not in the file. Hold on 1 second, Magistrate. This is item 13. Bear with me a moment. All right, this was long ago. This was before my timing, so.
So now that I'm looking at it, back in 2015, when it was found guilty, we actually used to have 2 hearings, one in the morning and then one in the evening. That's why they have the AM magistrate and then the PM magistrate. And back then we had only 2 magistrates. We had Magistrate Benjamin, who became now a state representative. And then we also have Magistrate Kazo, which is still one of our acting magistrates. I hope that narrows it a little bit.
But we don't, okay, let me see who. Well, it
doesn't
we don't know which is the magistrate.
We need, not just that, it doesn't matter who the magistrate was. It matters that the order be part of the file.
Right. They never put the order in from the beginning. Right. From my information, their system was different from some time ago. I don't.
All right. Yeah. Now that you know what the issue is, you can resolve it. Let me just hear from you and see if any recertification reports have been filed.
Shawnee Pressey.
I'm here. Hold on, let me turn my mic on, my camera on. You can see me now?
Yes.
Yes.
Okay. For this case right here, I'm so sorry because they had me doing something else. This is for the 1981 Northeast 135th Street?
Yes.
1981.
No, I mean, it was yes, the report was submitted, but I still brought them in front of you because repairs had needed to be made. So they had 150 days from the date the letter was sent out to let them know that repairs needs to be made. So we there now. They need to be in compliance.
Well, the citation is for not filing the recertification, which you're telling me they did file it.
Yes, but they have to be all the way completed through the whole process. Not only that, when you file the report, you have 150 days if you have any repairs or any corrections that needs to be done. If you haven't done that within that time frame, you're still not in compliance.
All right, I accept that. So not only do they have to do the recertification filing, they also have to comply with the requirements.
Yes, in order to receive the compliance letter.
And they have not done everything they need to do. Okay.
Correct.
Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the property has been out of compliance for failing to complete the 40-year recertification timely and make all the necessary corrections. It's been out of compliance since September 1st. They were found guilty by a prior magistrate. I find in favor of the city, hereby ratify the fines accrued to date. At $100 plus cost assessment of $100. I hereby ratify those fines and the fines shall continue to run on a daily basis until there's compliance. I'm considering whether or not to increase the fines. Madam City Attorney, is that within my authority? Has the City Attorney left the meeting?
Correct. The City Attorney is left.
All right. I'll leave things the way they are so as not to create a legal issue. So we'll leave it at the fine set at 100. Okay. Next.
All right. Next case, Magistrate, is item number 16, Empire Legacy Management, case number CEBPR 2023-00801, previously found guilty by Magistrate Smith with an abatement date of April 17th of 2024. Fine set at $350 plus the $100 cost assessment. The officer on this case is Shanna Sanders.
All right, Ms. Sanders, I'm aware of the violation. I've reviewed the file. There's an issue with the asphalt driveway, needs a permit. Anything new?
Shanna Sanders, Neighborhood Service Inspector. No, nothing new.
Based on the unrebutted testimony of the city's code enforcement officer, the photograph and the evidence presented showing that the property has been out of compliance since April 17, 2024, I find in favor of the city, hereby ratify the fines accrued to date in the amount of $350 plus $100 cost assessment. The set fines shall continue to run on a daily basis until there is compliance.
All right. Next item on the agenda is item number 20, Golden Terrace Condo. Case number is CEWWC 2023-00125. The officer on this case is Christopher Colson.
This is item 20, you said?
Item number 20.
And also 21?
Yes. Okay, item number 21 is Golden Terrace Condo. Case number is CEWWC 2023-00126. Officer is Christopher Colson.
All right, the first one has to do with a leaking ceiling.
Yes. Officer Colson, City of North Miami. I spoke with the residents first of all, it's a violation for leaking ceiling. And I've spoke with the residents on several occasions They tried to come out and patch it, but it's still leaking. Was my final inspection. The violation still remains. I have no contact with the owner of the condo. I've tried, no contact. Reached out several times, no reply back. Only the tenants that stay there.
All right, let me understand something. This is a condo association, correct?
Yes. Yes.
And Unit 401 is owned by a private individual?
Yes.
And that private individual is obligated to maintain the unit weather tight, and it's the owner's responsibility, not the condo association.
Yes, my understanding is the owner's responsibility. Yes.
You know where the leak is coming from?
This one is in the bed. This one is in the bedroom, in the mother's bedroom, and the other one you're going to see that's outside on the balcony area. It's
Yeah,
a closed-in balcony.
let's deal with the 401 ceiling issue and not the balcony. So
Okay.
so you think you don't know where the water is coming from?
Yes, this is coming. This is in the bedroom area. That leaks in the bedroom. It comes out that water that's in the bedroom, in the mother's bedroom. It leaks in there. They said they tried to do some work to it, but that's the most recent picture when that rain fell not too long ago.
Oh, so this is rain intrusion into 401
Yes,
through the roof.
through the roof or the side of the building. Because I've looked on the side.
Okay,
I've tried
so
to
why is that the unit owner's responsibility and not the association? Oh, you cited the association.
Yes, I cited the unit owner, and I sent it to the association as well. I sent it to both of them.
Okay, so because the unit owner has no responsibility over the roof. So, but you did cite the condo association. So as to that particular, I guess it's a roof issue then. All right, based on the testimony of the city's code enforcement officer, which is unrebutted because nobody appeared on behalf of the association. The photographs and the evidence presented depicting that the violation still exists. Proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of August 19th. August 19th. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated. Now we go to the balconies and show me what the problem is.
Yes, that's the case right there. It starts with a ceiling fan separated, but it's more pictures where that one is cracking right there.
That's a balcony?
That's the balcony. Has that big crack here. That water. They're talking with the tenants. The water comes through the bubble right there. And
is that due to rain also?
I would say it's due to weather. Yes, because that's on the outside balcony. Because I tried to see if it was a rebar or something coming through. I didn't see any rebar or anything like that coming through.
Okay, is that also outside for Unit 401?
Yes, that's the balcony on Unit 401.
Okay, all right. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city enter an adjudication and set a compliance date of August 19th, 2024. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
All right. All right. Next item we're going to call magistrate is item number 31 and number 32 is N&W 1051 Inc. Case number CEFOB B2023-00494. Item number 32, N&W 1051 Inc. Case number is CEZCU 2023-00823. The officer on this case is Shanna Sanders.
Has this case been before me before? I seem to recognize the church.
No.
Well, it came before you, but I think you tabled it. Yeah.
Yeah.
Mm-hmm.
No, I think that you all told me to put it off for a while. You were talking to the minister or
Yeah,
somebody.
it's been tabled, I believe, a couple of times.
Yeah, but it was withdrawn. I recall it was withdrawn either last meeting or a couple of meetings ago. But so it's now before me on a business tax receipt violation and the certificate of use. Is the property still being used as a church?
It still appears to be occupied and being used as a church. Yes.
Okay, and a church is required to maintain business to pay business tax receipts.
Shanna Sanders, Neighborhood Service Inspector. Yes, per the Development Services Department, they do still need to obtain it. They get it, I think, free of charge. They say they are exempt, but they need to at least put it on record and apply for it, and they give it to them, I think, from what is stated, free of charge.
Okay, and the certificate of use, what's the problem? Are they having any problems with zoning?
Well, I've spoke with the pastor and his daughter through translation. It was the language barrier at one time. So his daughter or granddaughter was kind of translating, but they said they submitted, paperwork. They had was in the process. Again, they've asked for an extension a couple of times, for which we've granted. However, every time I visit the property, I even went on a Sunday a few weeks ago when I worked one of the Sundays and tried to have a conversation. But, it seems like they're just saying they're applying. We've already submitted the application, but nothing has happened.
Okay, this is it. It's a building, right? Which is being used as a church. Or is it a building that serves other purposes as well?
It's a plaza along 119th Street. There are this particular bay is being used as a church, but there's like 3 or 4 other businesses there, a beauty salon or hair salons or something like that. There's an insurance place or something that's doing, I think, taxes when I last inspected, but those two for sure.
But are we citing a tenant church, or are we citing the owner of the building, or who are we citing here?
Well, we cited the actual property owner because, I think we've had these conversations in the past. We have to cite the property owner, but both of them have been put on notice, the business and the property owner.
Okay. So as to both the business tax receipt, case 31 and 32, the certificate of use, the orders are the same based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the cited violation still exists. Proper notice has been given. I find in favor of the city. Enter an adjudication and set a compliance date of August 19th. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
And this is for both, correct, Magistrate?
For both. Yes, same order for both.
Thank you. All right. The next item we're going to call is item number 44.
All right. I hope we're getting close to the end because I'm running out of gas.
Yeah, we're almost there. Yeah, I believe it's 1, 2, 3 left.
Okay, number 42?
44.
Okay. 44.
I believe we've heard already 42. Yes.
Spinnaker Marina.
Yes, Spinnaker Marina, Ltd. Case number FYBRR 2022-00012. The officer on this case is Shawnee Pressy. Inspector Pressy.
No, I'm almost done.
Hello?
Yes, I'm here. Go ahead,
Okay.
Officer. Go ahead and tell me what the issue is here.
This one right here, they not in compliance. Same thing. I believe this one right here, they have not submitted the report. I'm trying to double check this one. I'm sorry.
Okay.
Yeah.
All right, so we're talking about 44 right now, right?
Yes. No, I'm sorry. They did submit the report. This is this is the marina also, right? Yeah. This is
like
the marina. They have two buildings.
It's a TNT Marine Center. Yeah.
So that should be probably the second building. They have building 1 and building 2. That particular building, they did submit the report, but they had repairs and modifications that needs to be corrected, and they haven't been in compliance with that yet.
All right. So you're looking for an adjudication?
Yes, or unless you're going to give them additional time, it's up to you. I can't remember what you ruled on.
Well,
on the
let's.
other
I think what I did before is I found them guilty and I gave them time. So let's. Regardless, my ruling here will be that the violations still exist because they haven't complied with the terms of the recertification report. I find in favor of the city, enter an adjudication and set a compliance date of August 19th. In the event of non-compliance, there shall be a daily fine of $350 until the violation is abated.
All right. Thank you.
Next item we're going to call is is item number 47 and item number 48, which is Trident Management Heritage Condo Association, case number CEFOB 2022-00400. This was previously found guilty by Magistrate Smith with an abatement date of April 17, 2024. Fine was set at $350 plus the $100 cost assessment. Item number 48, Trident Management Heritage Condo Association, case number CEZCU 2022-00707. This case was previously found guilty by Magistrate Smith with an abatement date of April 17, 2024. Fine set at $350 plus the $100 cost assessment. And the officer on this case, both cases, are Jonathan Lemestre.
All right. Officer, the violation still remains?
Yes, sir. No applications on file. For BTR and CU, Heritage Condominium, they have not applied for.
All right. So my order will be identical. Except that one will deal with the BTR, the other one with the certificate of use. Based on the unrebutted testimony of the city's code compliance officer, the evidence presented showing that the violation still exists, proper notice has been given. I find in favor of the city. I'm sorry, I'm reading from
ratification.
I need to ratify. This is a court order, my order. Based on the testimony of the code enforcement officer and the evidence presented showing that the property has been out of compliance since April 17, 2024, I find in favor of the city and hereby ratify the fines accrued to date in the amount of $350 plus $100 cost assessment. The fines shall continue to run on a daily basis until there is compliance. Same order as to item number 48, which deals with the certificate of use.
Thank you.
Thank you, Magistrate. This does conclude the agenda for today.
Okay, hallelujah. I happen
Happy 4th of July to everybody.
Happy 4th. Don't rush the typing of the orders because I'm out of town right now. I'm out of town. I will not return until the 10th of July. So after that, I'll be happy to go by and sign the orders.
All right.
Director Riman, wish you a happy 4th as everybody else. Be safe. I'll see you next time. Okay.
Thank you very much, Magistrate. We appreciate staff, team. Thank you. You guys are the best. Thank you.
Thank you very much. You guys as well.